Okay, I think we ought to get started. So, I assume... Okay, here comes Jeff. So I've been told to make sure your microphones are on and you have it pretty close to you when you're talking. And I thought we'd go around the table. And I visited with a couple of Cub Scout troops these last 2 days. And I asked them where they were born. And the majority of them weren't even born in Sammamish, and these are 10-year-olds. So I thought it'd be interesting to find where we are born as we go around the table. So what happened? Jessie's up there. We'll get her back. Christy, why don't you start and tell us where you're born, where you grew up, maybe.
I grew up in a suburb of Denver, Colorado.
Okay. You might give us our name as we go around, too.
Yeah, they're working.
Okay.
Shanna Collins, and I was born in Mission Viejo, California, and I grew up in San Juan Capistrano, California, where the swallows are from, or where the swallows go.
Nancy Anderson, Planning Commission. I grew up, well, I was born outside of a suburb of Chicago, grew up in Park Ridge, Illinois.
Lyman Howard, City Manager, and I was born in New Haven, Connecticut, on the polo fields of Yale. So, yeah. After World War II,
I think there's a lot more to this.
They brought in all the GIs and basically created housing there for them. So, my formative years were spent in Three Rivers, Michigan.
Tom Hornish. I was born on a small farm in northwestern Ohio, and I grew up there all 18 years.
And Don Jaron on the council, and I was born in Memphis, Tennessee, and grew up in a small town just north of Green Bay.
Frank Plow, Planning Commission Chair. I was born in Santa Barbara, California. I kind of refuse to say I grew up, but I grew older in Westchester County, New York, South Jersey, lived in Rome, Italy for 2 years, and Los Angeles, so all over.
Romero Valderrama on the council. I was born in La Paz and spent enough time to get baptized and put on the plane, and then grew up in Bethesda, Maryland. Also spent time in Lima, Peru, and in 90 different countries. So.
I was born in Chicago within sight of Cubs Stadium, and then we moved to the west side suburb of Cicero, where I grew up, and then spent the next 25 years moving around the world with my husband, who was a retired Army officer.
Eric Brooks, Planning Commission. I was born in San Diego, California, and grew up in southeastern Wyoming.
Bob Keller. I'm surprised going around the room because I was born in Detroit, Michigan. But as opposed to what I've heard here, I moved my family to Southern California and grew up in Huntington Beach, Fountain Valley area. And I hear people that are born in California, Santa Barbara, and moved to New York. That surprises me a little bit. But I am going to be going to Mission Viejo for Christmas to spend time with my family down there. So.
Larry Crandall, the Planning Commission. This is a good segue because I was born in Bishop, California, Inyo County, which is located halfway between, at that time, the highest mountain in the United States, Mount Whitney, and Death Valley. So I was kind of an average type of thing, but at a young age, we moved to Cooley Dam, Washington, and I spent either formative or at least through the 8th grade there.
And
Jeff Thomas, Planning Director, was born and raised in a college town about 60 miles west of Toronto, Ontario, a couple hours up the road from Councilmember Keller.
Great. I think it's clear, none of us were born here. No, it's not. Oh, Jesse, yeah, you came back. Let's hear Jesse's story.
I think I'm one of the only Washington natives. I was born in Tukwila, Washington, 5th generation, which is also where I grew up. And my great-grandfather was the blacksmith in Tukwila. So my family's been here a long time.
So the point I was trying to make with this is it's a big difference in this city compared to some of the places where we were born. This upstate Wisconsin town, if you got a group around the table in upstate Wisconsin town of Marinette, probably 9 out of 10 of them were born in Marinette. So you have that generational stability. Now what we're seeing here with our Cub Scouts, some of them are born here. Hopefully we can develop that generational stability in our city and plan our city for the generational stability that some of us at least had when we grew up. So let's see if we can do some of that good planning, starting with a sign code amendment.
So, Mayor, if I may, to introduce our guest speaker here this evening and to kick things off, the council will recall, and the Planning Commission as well, going back to the beginning of this year, doing some sign code amendments. We're on our work program for 2016. We're getting started here late in the year, but better late than never. This will carry over into the beginning of 2017, first with the Planning Commission and then on to City Council with some recommendations. This evening's presentation, this is Charlotte Archer. She's with Mike Kenyon's firm, one of the outstanding attorneys that works with staff I wouldn't say daily basis, but maybe a weekly basis. And we're really pleased that she has some experience in dealing with kind of breaking down, and she's going to present here this evening, a federal Supreme Court case, Reed versus Gilbert, Arizona. We're going to set up the legal basis for some of the sign code amendments that we're going to be moving forward to the Planning Commission in early 2017. And we thought this would be a good opportunity to have the City Council and the Planning Commission hear this presentation at the same time, so that as we move forward with the Planning Commission and then on to City Council, we can focus really on the substance of the code amendments, and we don't have to worry about, what is the legal basis for doing this? Why are we doing this? Charlotte's going to explain all that to you here this evening. I think she's got about 10 or 12 slides that we'll move through and take about 20 minutes or so. With that, Charlotte, I'll turn it over to you.
Thank you, Jeff. As Jeff mentioned, my name is Charlotte, and I am a Washington native. I was born in Bremerton, to keep the game going, and grew up in a tiny town called Indianola. I don't know if anyone's familiar with Indianola, but I'm third-generation Indianolanite. So tonight I've been asked to discuss with you, as Jeff mentioned, the recent Supreme Court opinion of Reed v. Town of Gilbert, Arizona. This case had a substantial impact on the manner in which cities are permitted to regulate non-commercial speech in the form of signage. And just by way of background, signs contained protected speech, protected by the First Amendment. But the government may regulate the content of the signs, or the signs themselves rather, under its police power. And there are different levels of regulation permitted based on the type of speech, and the two general categories being commercial versus non-commercial. Commercial being defined as speech designed to sell you something, essentially, and non-commercial speech being everything else. The case of Reed v. Town of Gilbert deals specifically with non-commercial speech, and, as is our wont, lawyers are disputing whether or not commercial speech is impacted in any way by Reed. But for the purposes of tonight, and from our perspective at Kenyon Deason, the case is limited in scope to non-commercial speech and the regulations that cities adopt for non-commercial speech. When I say non-commercial speech, I'm talking about signage for political candidates, signage for religious events, signage for holidays, all the holiday decorations that constitute signage. So when I discuss this case, we're thinking about it in that context, non-commercial speech. And the case essentially, to give away the punchline of my presentation, but changes the way the courts define content-neutral versus content-based regulations. Content-neutral regulations being ones that are applied uniformly regardless of the content of the sign, and content-based regulations being ones that are specific to the content. So regulations for political signs, regulations for religious signs, regulations that are specific to the content are content-based. With this decision, the court has redefined what is content-based and essentially said any signage regulation that forces city staff to look at the sign and determine what regulations apply based on what they see is essentially unconstitutional, with very limited exceptions to that. So that's the punchline of tonight's presentation, and let me take you through how we get to that point. So first, to give you a little background on the case, the town of Gilbert, Arizona, and this is actually one of their signs, had a comprehensive sign code that prohibited the display of outdoor signs without a permit, but exempted 23 categories of signs. And this honestly is a very standard sign code situation that you see in cities across the country, including 3 categories that were relevant to this particular case. They had, in particular, signs defined as ideological signs were given a favorable status. So they could be up to 20 square feet in size. They could be permitted in all zoning districts. And there were no temporal limitations. They could be up for as long as the sign bearer wanted. Ideological signs under their code were defined as signs communicating a message or ideas for non-commercial purposes that is not construction, directional, temporary directional, or relating to a qualifying event, a political sign, or a garage sale sign. So that was sort of the broad definition of ideological sign, and they again were given a favorable status. Political signs were another category at issue in this case. Those were defined as temporary signs designed to influence the outcome of an election. This may ring a bell. I think Sammamish has a very comparable definition. Those were given sort of an intermediate status. Up to 16 square feet was permitted on residential property, 32 feet on non-residential property, and they could be displayed for up to 60 days before an election and up to 15 days after, so a specific temporal window. And then the third category that was issued in this case is referred to as temporary directional signs, and this is really the heart of the case. These are the types of signs intended to direct pedestrians, motorists, and other passersby to a qualifying event. And the code was defined qualifying event specifically as an assembly, gathering, activity, meeting, sponsored, arranged, or promoted by a religion, charitable organization, community organization, or educational organization. And the code would treat those sort of in the least favorable manner. They could be no larger than 6 square feet. They were permitted on private property or in the public right-of-way only. There could be no more than 4 signs placed on a single property at any time. And they could only be displayed for 12 hours prior to the event and no more than 1 hour after. So you needed to be quick to clean those up. And the city, in their briefing to the United States Supreme Court, provided some illustratives that are really useful to sort of visualize the scope of the regulations that Gilbert used. This illustrative in particular shows you how favorable certain types of signs were deemed under the code versus others that were smaller. So this case deals with a church, a traveling church, a transitory church, where they would hold their services at a different location every week, and they would use directional signs to let their parishioners know where they were located at that particular week. You can see a homeowners association sign under the Gilbert scheme was allowed a very large sign, whereas the Good News Church sign was allowed a very small sign, sort of distinguishing based on the content of the sign. See if I go, there we go. Another couple illustratives that come from the briefing to the U.S. Supreme Court that I thought were useful. You can see that the differing regulations based on the content reflected the location of the sign, the location of the event, which was a distinction very important to the U.S. Supreme Court. An event that was taking place within city limits was given certain more expansive permission to be posted for a longer length of time, whereas events that were located outside the city were treated differently, poorer in the sense of, or in the perspective of the church, because they moved their location at one point and the city changed their regulations specifically to impact them by restricting signage for out-of-town events. The number of signs that were permitted differed based on the content, and whether or not you needed a permit differed based on the content. As did, again, the temporal limitation applied to each particular sign. The duration before the event, after the event, differed based on the content, based on the city's preference. So the Good News Church, as I mentioned briefly before, was a small transitory church, and they used 15 to 20 temporary signs in order to inform the community and their parishioners the location of each service. Church members would actively post the signs on a Saturday early in the day, and then the church service would be Sunday morning, and they would remove them within the 1 hour window following their services. The church was cited, pursuant to the regulations by the city that we just discussed, for exceeding the time limits for displaying its temporal directional signs. You remember that I said temporary event signs were only permitted to be up for 12 hours. So a Sunday church service means that that sign could go up in the middle of the night, Saturday night. And the church was objecting to that on the basis that who in their right mind is going to see the sign in time for a church service the next morning. The church was then also cited for failing to include the date of the event on their signage. The signage would simply refer to the time and the location, but not the date. So the church filed a lawsuit against the city, arguing that these sign regulations were discriminatory and violated the contents, or the principles rather, of free speech and free exercise of religion and equal protection. The decision hinged on the free speech part of it. The trial court dismissed the case on summary judgment on the city's motion, and the Court of Appeals for the Ninth Circuit affirmed that dismissal. And they did so applying the sort of pre-existing test that the courts had set out for content-based and content-neutral regulations as they applied to signs. The court held that the regulations in Gilbert were content neutral under the First Amendment because the classifications were based on objective factors relevant to specific exemption from the permit requirements and did not draw distinctions based on particular content of the signs. That's a mouthful. Let me unpack that. Essentially, they said all religious signs are treated equally and all political signs are treated equally. The fact that they're categorized as such does not make the regulation content-based. So insofar as the city is saying all signs for all candidates are allowed to be up for this amount of time, that regulation is content neutral. The city's not making or taking a position that a particular religion's sign is better than any others. All of the religions are regulated in the same way. The court then held, and we'll discuss this briefly in a moment, but that because the regulations were deemed content neutral, they were subject to what's known as intermediate scrutiny, which gives the city sort of a lesser burden to prove that it has a need to regulate the signage in this particular manner. Intermediate versus strict scrutiny is a topic that we'll talk about momentarily, but ultimately the Supreme Court determines that all signs that are on their face content-based are subject to content-based regulations are subject to strict scrutiny, which is essentially a death knell for any regulation. There we go. So I touched on this at the beginning, but I just want to make this clear because this is an important distinction. But the Court of Appeals, in affirming the dismissal, again, made the determination that those regulations were content neutral, meaning the restrictions applied without regard to the content and the communicative impact of the message conveyed, whereas content-based restrictions would limit the communication because of the message that it conveys. The latter category is the category that is subject to strict scrutiny, and we'll jump ahead to that. Sorry, oh, hopefully it didn't go too far. There we go. So under the intermediate scrutiny test, the court essentially looks at whether or not there is an important governmental objective that outweighs the constitutional interest in the particular type of sign. The city in Gilbert, or the town of Gilbert rather, passed their signage scheme, much like most cities do, with the interests of safety and ensuring the aesthetics of the city were uniformly applied. Those were their interests, and the court held that temporary directional signs in particular, which is what they classified the church's signs as, signs that point you to an event at a particular time, were sort of a less important type of speech than political or religious signs. So on balance, the city's interests in safety and aesthetics outweighed the church's interests and their protected free speech rights. And they also said that they felt that the restrictions were reasonable because, quote, no one looks for directions more than 12 hours before an event anyways. So on appeal to the United States Supreme Court, this opinion, the Ninth Circuit's opinion was reversed. And this is the opinion that has changed the landscape of sign regulations across the country. There were 4 opinions issued, and the majority's opinion essentially reversed the entire reasoning of the Ninth Circuit and deemed these regulations to be content-based. And the way that they got to that conclusion is that in order to apply the regulations, you had to look at the content of the sign to determine which category that sign fit into. And the fact that there were categories at all made all of the regulation scheme content-based. So where the Ninth Circuit had found that because all religions are subject to the same regulations, that makes the regulations content neutral, the Supreme Court flipped that on its head and said, because you are differentiating as to the regulations that apply to a sign based on its content, these regulations are hereby content-based. And accordingly, they subjected it to strict scrutiny. So the government, in order to continue to utilize those regulations, needed to meet the strict scrutiny standard, which meant they had to show a compelling governmental interest, and likewise that their regulations were narrowly tailored to achieve those interests. So in response to that burden, the city presented evidence that the aesthetic appeal was a valid and legitimate concern that warranted the regulatory scheme that they had in place, and that traffic safety was another legitimate government interest that supported the regulation. And these are values that most cities utilize when developing their sign code. However, the court held that the town had ample content-neutral options available to them to resolve the problems of safety and aesthetics, including the regulations on size, building materials, lighting, moving parts, and portability. Similarly, they talked about narrowly tailoring these regulations to actually address concerns related to pedestrian and traffic safety would be a better model than what the city had been utilizing. So warning signs, marking hazards, and signs directing traffic. These are ones that are permitted for a city, not the scheme that has been set out in the city of Gilbert. So essentially, the city's sign regulations failed the strict scrutiny test, and the sign code provisions were an unconstitutional restriction on speech in violation of the First Amendment. And none of the city's reasons for their sign outweighed the free speech rights of the church. There was a concurrence, there were actually 3 concurrences, one from Justice Alito that many lawyers have been looking at as a possible sort of map to the potential new sign regulations that cities could utilize and that could be deemed constitutional given the changed landscape. Justice Alito actually lists regulations that he believes, and there are two signatories to the concurrence, that would be permitted post this decision. So rules regulating size, I won't go through all of them, they're listed, but these are a good roadmap for cities to utilize when revising their sign codes. These all are based on the structure, the location, and not the content. So insofar as the regulation applies uniformly across all signs of a temporary nature and all signs of a permanent nature, those regulations are likely to be deemed constitutional after this decision. So the takeaway from Reed, again, government cannot ban speech based on the topic discussed or the idea or message expressed unless it has a compelling interest. And strict scrutiny, again, is normally fatal. So most cities must review their sign codes to eliminate any categories that are currently based on content. And again, virtually every city had regulations of that ilk before this decision, such as political signs, temporary event signs, and religious signs. Even historical markers could potentially be deemed a content-based regulation, and holiday decorations as well. Moving forward after, Moving forward after this decision, the impact of it, this was decided in July of this year, and the impact of it could potentially be wide sweeping. The court's decision, there's a great Harvard Law Review article that I can circulate that discusses sort of the potential ramifications of this decision for speech categories outside of the sign context, so actions and all the different things that constitute speech under the First Amendment. But a couple takeaways that have sort of been somewhat solidified in the few months since this decision came down. It appears that there has been, or that this decision, again, has no impact on commercial speech, and I said that at the outset. A recent decision from the Northern District of Illinois made clear that at least a few courts are saying that this Reed decision, does not overturn the Supreme Court's consistent jurisprudence regarding commercial speech, which commercial speech can be regulated to a more stringent degree than non-commercial speech because of interests such as protecting consumers from fraud and whatnot. So courts seem to be somewhat, to the extent they can be, somewhat consistent as to commercial speech being isolated from this decision. City-sponsored signs can't be treated differently, and this is another recent decision out of actually the Northern District of California, a city regulation that exempted official public signs or notices posted by a public officer were deemed unconstitutional. So essentially the city had exempted its own signs from its regulation, and the court said, you can't do that. There are some choice quotations from this opinion, and I'm happy to send out copies of it as well, but official signs could be a mile high and a mile wide in the middle of a residential neighborhood and illuminated with bright flashing lights at all hours. So obviously the court goes to the worst case possibility, but essentially, if your code does not, if your code intends to carve out city-sponsored signs or even signs for city-sponsored events from regulation, that can be deemed unconstitutional after this case. And then a recent case from the Washington State Supreme Court, and there's actually cases like this all over the country dealing with panhandling. The state Supreme Court recently held that Lakewood's begging ordinance is content-based unconstitutional regulation, and that it prohibited solicitation in a particular manner. So it didn't prohibit solicitation in all forms, but it prohibited panhandling in the right-of-way. And the court held that it essentially prohibited solicitation with a very specific purpose. The court had this quotation, which was an interesting one. A sign reading "sober" or "two children" conveys a message. It constitutes speech. And the city of Lakewood's attempt to regulate that particular type of speech was deemed content-based under Reed and deemed unconstitutional. So in closing, the takeaway from Reed again, cities have a directive now for non-commercial speech or non-commercial sign regulations. To the extent the city seeks to regulate the content via prohibition of certain signs or approval of copy design, those questions, or those regulations rather, likely run afoul of the Constitution. And adopting rules that apply uniformly to a sign and signage are likely constitutional, and cities are moving towards those forms of regulations. And I guess I'm happy to take any questions that you might have about this very interesting case. I have copies of the case as well, if anyone wants some light dinner reading. I don't know, Jeff, if you want to.
Questions? Well, I have one. What was the decision? Was it a 5-4 decision?
No, it was far more complicated than that. Oh. As is their want. So the majority, written by Thomas, he had 5, so 6, and then Alito +2, and then 2 other concurrences in judgment only, Breyer, Kagan, plus Ginsburg. So it was a messy one.
Okay, right. So the determination of what is commercial versus non-commercial, how is that made?
That is a subject for an entirely additional presentation. And that's a great question, because that is something that the courts struggle with. And it really is something that would take a long time to discuss. Commercial is sort of broadly defined as speech on behalf of a company or an individual. But there is a recent case where a nonprofit giving out pamphlets was deemed to be commercial speech. Mm-hmm. So it really is almost subject to the opinions of the court at the moment.
I guess the example that I'm thinking of here is a sports organization that is ostensibly run for profit, but it's for children, but they do make a profit. Maybe they're a 501c, maybe they're not. And they're putting up signs in right-of-ways and things like that. Is that regulatable or not?
So Little League signs, I believe that would be non-commercial speech that would be regulatable, correct.
So could we say something like, if you are, I'm just trying to determine, like you said, who's commercial and who's
right.
not. Could it be based on 501c status, whether or not, whether someone was a nonprofit, with all nonprofits are non-commercial?
No, not, okay. At least under the jurisprudence currently as it exists now. That's not a bright line.
And another question, a real estate sale sign by owner, not by a real estate company, sale by owner, is that commercial speech or is that?
My understanding is it's non-commercial speech that can be regulated.
So
it's commercial speech? Yes. I believe that's what it is, yeah.
Okay, getting complicated.
I would be happy to come back and give you all of the commercial versus non-commercial.
Yeah, so there's going to be some fine lines to tread here, it sounds like,
right.
And then lastly, the city has a particular type of sign which has been under discussion lately, which is a public notice of development sign, the big blue signs that we talk about. Mm-hmm. And we have been talking about making them more readable from a longer distance and not having to get out of your car with a pair of binoculars to read the sign. Mm-hmm. Is that what they're talking about when they're talking about public, in the interest of the city's interest in signs, can't be any different than other regulations?
So land use and public notices of that ilk, you would just simply need to have some sort of a justification for the size and the regulation and the lighting or whatever other sort of elements the city's considering to make those more legible. At its heart, that would be something that would need to be subject to some semblance of a uniform set of regulations. So if the city were to adopt a particular sign structure for its own internal land use signs, if you could also categorize non-commercial public or private signs in that same category, then they would need to be subject to those same regulations. I'd be happy to look into it more and give you some analysis on that, but
I think it would be useful because it's something that we are discussing right now.
Right.
It's something that the public has brought up an interest in, and I think we want to make those signs more readable.
Right.
And able to make them more accessible. So there's some issue of location of them also. We don't want them 50 feet into the property. We want them on the edge of the property, things like that.
Right.
So.
Yeah, I'm happy to look into that.
I was just going to comment real quick on those signs, is that that's been under discussion, and that's due to have a change actually in January. So the signs will change, and I believe the location of them, is that part of it, Jeff?
Yeah.
As to where they're put. But they will be readable from the street as you drive by.
Typically, we're not interested in making those Little League signs large enough to be read. They usually do that on their own.
I think as far as the city's own personal signs, I leaned over to Jesse in the middle here. I said, our banners over 228th are not going to fit into our current sign regulations, which are 32 square feet. Those are probably larger than 32 square feet that span over 228th.
So Charlotte, if we want to put up a sign, oh, okay, Kathy, move it forward. A little closer.
Most of the signs you're talking about seem to be signs that are posted in the median and on the side of the road. Does this also apply to business signs and other signs that are going to be on buildings?
It would apply to signs that are, I mean, the city could regulate signs that are on buildings, signs that are on private property as well. And the city, I believe, still currently does regulate those types of signs.
Well, I think we do. And when I served on the Issaquah Planning Commission, our largest ever meeting dealt with signs on businesses, because there are a number of nonprofits that have some of the storefronts on Front Street. And so there was a significant interest in the size of the sign, height, width, readability, and so forth on those buildings. And I don't see anything in this particular regulation that would address some of those types of signs or signage.
Well,
Or is that all considered commercial, even if it's a nonprofit?
the nonprofit versus commercial distinction is something that, again, I could look into for the city and provide you with written. But this particular case is focused primarily on non-commercial signs. So the city is still permitted to regulate signs on business, whether they're on site or off site for business purposes. The city is still free to regulate those, and it's subject to intermediate scrutiny. So the city merely needs to show, it has a lesser burden to show a reason to justify the regulations that it puts on commercial signs, both on site and off site.
Because we did at one point somebody wanted to have a neon sign, do you remember, near the McDonald's or something? That caused no end of consternation.
Lyman?
Thank you. Quick question. Basically, we're regulating the content of signs, size of signs, but it's my understanding that we can still regulate location of signs. Is that true?
Correct,
Okay.
yes.
So it's not a free-for-all?
No, that's something that the court carved out, and Justice Alito spelled out in the concurrence as one of the topics that could be regulated moving forward, particularly as it relates to the right-of-way and whatnot.
Question, I thought I heard you say a second ago, non-commercial speech could be regulated? Is that what you said?
Correct.
But under the strict scrutiny test?
Well, if the regulation is content based on its face, then it's subject to the strict scrutiny standard.
But, okay, if it's content.
So a city could regulate.
It's non-commercial content based, but they made the distinction that it's content based just by, everything was, yeah.
So, yeah, so a city can regulate non-commercial speech. You could regulate all signs that are for, that would be used in a temporary nature. So political signs that would be up for the period of a election, event signs, you could regulate all of those, but they would need to be regulated in the same manner. So a political sign, the temporal limitation placed on a political sign would have to be identical to the temporal limitation placed on a sign for an event or something of that ilk. If you're looking at the content of a sign, then it needs to be uniform. You can't essentially look at the content of the sign and assign a particular type of regulation to that
But by
sign.
saying it's political, you're saying that is content.
Correct. So I'm saying the regulations cannot say the word political, essentially. They need to simply say any sign that intends to be up for a period or addresses something of a short-term nature is subject to this particular signage scheme.
Tom, I think the distinction you're driving at here is there's commercial speech on which the rule, or commercial signs on which the rules have not changed. Now we also have effectively two categories of non-commercial. There's non-commercial speech that can be regulated because it's content neutral, and there's non-commercial speech that almost surely cannot be regulated because it's content based. And so the difficulty, the challenge for the Planning Commission and the Council, with Charlotte's help, will be to draft this new ordinance so that we address that non-commercial, so that the ordinance addresses non-commercial speech in a content-neutral manner. If it's in a content-based manner, strict scrutiny applies, and as the court said in Gilbert, that's fatal, basically, meaning you can never satisfy the strict scrutiny standard.
So Charlotte, if the city wants to put up signs, directional signs saying City Hall this direction, does that allow private industry to do the same thing then?
Well, industry would be subject to the commercial regulations, which would be different. But, you know, as far as the Reed decision and how it impacts, it sounds like if the YMCA, well, I guess that would be commercial, but you would need to, the city would not be able to exempt itself from its sign regulations via directional signs. So the regulation applied to that particular directional sign would need to be applied uniformly to all directional signs, if that's what the city wants to define a sign category as.
Just one other question, and this came up many years ago in the city, and that was the quantity of duplicate signs in a given location. Can that be regulated? And what brought this up was not just political signs, but there was also commercial, the real estate ones. You'd come to a corner and there would be literally 30 signs for the same development.
Right.
And as far as I'm concerned, that's littering. So, so I'm curious, is it possible to say, look, you can't have a duplicate sign within a given geographic area? Is that considered too restrictive?
No, I believe that's not too restrictive. Yeah. I think that would be permitted, and as long as it's, again, applied uniformly to the signs, regardless of the content. So you couldn't have a regulation that said political signs, there shall only be one political sign per corner, or this development shall only have one, although the development would be commercial. So you could potentially do that, but that is something that you could regulate.
Because I think if what we're talking about is, at some level, is an aesthetic thing, right?
Right.
And I think that is personally my objection to some of the signage that we currently have is the duplicate nature of it every block, and it just feels like littering to me. And I think that if we could somehow put some boundaries around that, it would go to the character that we're actually, our later conversation here, that we're actually talking about getting to. So I think that might be an effective tool for doing some of that.
Kath?
Yes, many years ago, we talked about signs where various and sundry city organizations could post a sign, Rotary, Kiwanis, Lions Club, whatever. So in terms of what I'm hearing you say, is it possible for the city to say, we're going to put these standard sign posts, whatever they would be, where people could add their own sign to it, and at the intersections of the city and the county, or can the organizations just ignore that and put up their own signage as they choose? Or is that something that the city would have to discuss with all the organizations and see if we could all come together and put a sign on a city designed sign so that you had standardization at every entrance into the city?
So to the extent the city would consider putting a sign or creating some sort of a forum for speech, a
Yes.
physical forum, the city would be unable to limit that to particular organizations. So you wouldn't be able to enter into an agreement with the Rotary and other social organizations to limit their use, to allow for only their use of that particular forum. But I don't see a problem with actually physically having the forum to the extent it's open to all types of speech.
That's what I meant. If
Yeah.
it's open to all, but you can't say, because we've made this available to you, now you cannot post your own sign next to this.
Oh, I
As
see.
opposed to putting it on this particular forum that we've offered to you.
I'll look into that for you. I don't know offhand whether or not you could then, I would believe you could then also prohibit additional signage if you've created this forum, but I'm glad to look into that for you.
If this isn't confusing enough, there's another aspect of First Amendment jurisprudence called reasonable time, place, and manner restrictions, and that's probably where the answer to your question would lie, Kathy. I don't know what the answer is, but it's that time, place, and manner case law that would direct the answer.
Right.
Larry, then Bob.
What I want to say is this presentation has certainly motivated and challenged me to learn more about the topic. And I did have one thing, looking for a loophole. You know, I sit there, what? Yeah. Where does art fit in, or symbolicness? And you don't have to answer that right now because we're into the evening a little bit. But it's, and I won't go into those symbolic signs that have had some controversy. So maybe a brief answer or later on. Okay.
Yes, well, that again is probably a subject for another speech, but there was one recent case where a city had regulation prohibiting painted walls, so essentially murals, and that was deemed a constitutional regulation, so permitted, not content-based. But I'd gladly look into that for you.
This is a complicated subject, and so I have a couple of specific examples that hopefully I could get maybe a little clarification on. And it might really dovetail to Planning Chair Blau's question about a development, and now I'm talking about their marquee. Is that what you were referring to when you were saying duplicate marquees?
No, I'm talking about sales ads for the developments, you know.
Okay, because I do have a specific example where I know the development that I live in has two entrances, and they desired to have a marquee, just naming the development on both entrances, and they were declined the ability to have two. Our regulations, I believe, says one. So I'm wondering how that falls in, number one. And then the second question would be the large, bright signs that we've been putting up about public notice for our street development, that we just kind of wheeled out the trailer with the lighted sign, this is when it's going to be Tuesday night. What you're saying is that if the city does that, any other business would also be able to wheel up their trailer and put the same type of notice out. Is that correct?
To answer the first question, I believe homeowners associations, if that's the entity, those would be subject to non-commercial standards. So the city would have to use content neutral regulations to apply there. So essentially, they would need to justify based on the strict scrutiny standard if that essentially that's non-commercial speech that we've been discussing tonight. I'm happy to give you some written analysis of that as well. But the latter, I agree. Yes, lighted notice signs. If the city is utilizing those and is exempting those from its code because it's a city-sponsored event, then if challenged, that regulation would likely be deemed unconstitutional. I'll have to read.
If I even went further, for instance, notifying people the fireworks ban. That was another issue, I think, that we had posted using that tool, the trailer with the lighted tool. So that would also be...
Potentially, the city would be able to justify that one with the interest of public safety. So there's a chance that something of that nature could be justified on balance. So.
Go ahead. So a lot of really good questions here in this session. And the great news is that Charlotte's not going anywhere. She's going to be right in tow with staff as we move through the process going into 2017. We're going to do we're going to move this conversation forward a little bit more with the Planning Commission on Thursday night with just starting to conceptually look at some of the types of things that we may be looking at in our own code that we'll have to give some attention to starting in January. So that'll be one of the items as part of the Commission's regular meeting Thursday night this week. I guess Mayor will.
Yeah, thank you very much.
Thank you. And I have copies of the case in case anyone's bored.
Okay, next on the agenda is the discussion of neighborhood character. Who would like to start, Jeff?
Yeah, I'd be happy to make a couple of introductory comments. This is a continuation of a couple of different threads of discussion. The council will recall back in June, as part of your review of the public works standards, you had a brief dialogue related to character. I think it may have started as how the streets are designed and how the feel of the public realm influences character of neighborhoods. And in addition to that, there was some additional discussion here this fall that the city manager then asked staff to do a little bit of work on to look at in terms of improving character along some of our streetscapes, buffering between certain types of streets and future new development, as well as transition between different zoning districts. So for example, an R6 zoning district to an R4, or an R6 zoning district to an R1 would be two examples of that. So we've got some slides that will help with that second part that I just covered. If the group wishes to see those now or at some point during the next half hour of your discussion, I think in response to council's request back in June to have the Planning Commission work on this, the Planning Commission did have a discussion in July, and the chairman and the vice chairwoman did come back to the mayor and the deputy mayor and say, hey, we'd really like more specific direction on what our charge is here with talking about character and making some sort of recommendations. So this was really set up to be a continuum of that dialogue from July. And whether it's tonight or whether it's in the near future, perhaps at the beginning of 2017, I think the Planning Commission is looking for some specific direction from council on whether you'd like the commission to have a policy discussion, which could involve amendments to the comprehensive plan, or whether the council would like to have commission work on implementing tools such as possible code changes that again, the commission would go about its work and bring some recommendations back to city council. Staff recommendation would be, we have a comp plan that went through a major amendment process in 2015. We've got several goals. By way of example, land use goals 1, 2, and 4 in the 2015 comp plan update that speaks specifically to character and related to character as goals of the comp plan. And then we've got several policies that fall under those respective goals that in different forms and fashions address policy statements about character. So, and again, just a couple of examples to set up the conversation here. Land use policy 1.2 deals with transitions between zoning districts. Land use policy 2.6 deals with character surrounded stormwater facilities and such. Land use policy 4.3 speaks to character in the public right-of-way and the public realm. So we do have several clear statements, goals and policies in our comp plan update that speak to character. We may want to tune our thinking similar to some of the work that we did here this fall towards actually trying to implement those goals and policies and identifying possible code changes that would assist in that.
I would say that the Planning Commission punted this one back to the council, but that's fair. The Planning Commission doesn't punt as often as the Seahawks, so. as an introduction to the conversation, who would like to start? Romero?
I would be interested to see the Planning Commission begin to work on actual tools. I mean, they have the policy guidelines already that we had laid out in the comprehensive plan, and in fact, when I raised this on June 28th at the meeting, I was specifically looking at them to be having tools that they could look at, whether they're trees, amenities, we talked about the right-of-ways, and since they are the voice of the people, to be able to get input from the different citizens as to what they would like to see between those neighborhoods as defined by either zoning or topographic areas and maintaining that character. So I think if we go to a comprehensive level, it'll be just punting back to us and going in, but we can take advantage of a unique capability that they have, which is being the voice of the people, hearing that the input of them and what's working in their neighborhoods. And in specific, you have a number of neighborhoods like Lancaster today that they can look at and see what would be the effects to be able to visualize what would happen with these amenities that are being put in those transitional zones. So that's my take.
Good. Christy?
Yeah, I was just going to say, I think there's probably some code changes that can be done. And Jeff, you said you have some of the graphics. I think that might help put some of the neighborhood context as far as these zone transitions and the arterial street setbacks in perspective. And that's probably a good place, at least to a starting point for the commission, and then they can kind of massage it and bring it back to us. But neighborhood character could mean 10 things to 10 different people, and it's a fluid thing, but I think this probably narrows the focus a little bit.
I kind of want to just ask what the Planning Commission wants from us, that now that you punted to us. Do you want us to run it back? Do you want us to take a knee or what? I mean,
Bob. So I guess I'll answer for the Planning Commission. We felt that the language around character was leading us into, we use the term wordsmithing of the comp plan. And we would spend an awful lot of time. They're usually great discussions. We get a lot of good input on them. But ultimately, it's really, we've done that already for this topic in terms of the comprehensive plan. We have good language in there. We have the things that it says in the comprehensive, in the comprehensive plan as it exists today, we feel represent our best thinking about vision and policy. What we don't know is what tools are we being asked to evaluate? What specific tasks that we can actually sink our teeth into. We really don't want to sit around, even though I was an English major, sitting around talking about words. We really want to talk about tools and tasks, and it's kind of, I will say, more meat and potatoes, and less blue sky. And I think it's something that the Planning Commission, like Commissioner Valderrama says, is uniquely suited to do and get input on when we are given the right task. And I feel like just having us think about community character is kind of like going to your room and thinking about what you did bad, it doesn't really get you anywhere. And I think that, like I said, there's enough in the comprehensive plan today that reflect our discussions about character. What we want to get to now is what kind of tools can we apply, and what do we think about how those tools are written, and the kind of stuff that we're good at on the Planning Commission, I think. And bring that back to you as now we have a vision. We've agreed on that a long time ago. We're not going to reopen that Pandora's box. And here's some tools that we think might effectively make that happen.
Kathy, then Bob.
Well, first of all, Frank, I respectfully disagree with you.
Yeah.
I have long said that I happen to live in a neighborhood right at the west side of the 32nd Street barricade, which was fine. It was open because of development. We all knew that had to happen. There are sidewalks to 220th. And then you have, and I'll send you the pictures, but I wanted to, you can just take these for the moment and look at these. The road is narrow. It is curvy. You cannot see the stop signs when you're coming around. There are children being picked up by bus there. When there are garbage cans on the street, you can barely walk on the streets, and I will send you some additional. So I think the first thing we have to understand is whenever we do this, the character of the neighborhood is going to change. Children will never play in the middle of that street again. They will never ski down the hill that goes down, which they used to put signs up and in the wintertime would sled down. That's all gone because there's too much traffic flowing through there now. But how do we preserve some of the character that was there? In the instance that I'm showing you, and again, I'll send you some better pictures. I told you I was trying to print them tonight, but I had sent them to Melanie once before when we were talking about the comp plan. My biggest concern is that we opened a street, and Christie's neighborhood is very similar. When you open these streets and then you don't provide a sidewalk, a trail, or a pathway. So you see a group of people walking down there in the middle of the street, and when a car comes around the corner at 40 miles an hour, where do they go to be safe? It's a fairly large group of people. You have children, you have dogs, and so there has to, from my perspective, and the comp plan says nothing about that. We discussed it for a fairly long time about when we opened either barricades or opened from one neighborhood to another because of development, whether the substandard street at the other end needed to be open and safe, and we never could agree on what that meant. So we have nothing in our comp plan that says it should be. So that's I respectfully disagree with you. And I think that in and of itself changes the character of the neighborhood that can never be reversed unless we get something in there that allows for protection of the people that are walking in those neighborhoods so that they can still have a safe street to walk on.
So wouldn't that be the implementing tools that we're talking about?
It's not, but I just wanted to make the point, though, it's not in the comp plan. And Frank said most of it was in the comp plan. That particular piece is not in the comp plan, but I would like to see those tools in there.
So if I could just respond. So again, when I say that it's in the comp plan, I think that our best intentions are in the comp plan. Maybe it's not complete at this point, but I don't think we're going to look at the comp plan again for some time, probably, with the exception of maybe doing amendments and things like that.
No, we don't do those either.
But I think that what you're talking about, maybe not 100%, but I think we could get to some tools that would have some impact on that particular use case that you bring up. That is the removal of a barricade and the preservation of neighborhood character and safety based on that. I almost feel like we could talk about some policy, some actual policy and some tools around that wouldn't conflict with what's in the comprehensive plan, and would be, the ideas and thoughts that are already in the comprehensive plan would be enhanced by the tools to make that case. There might be some things where there's a little bit of a gap there, but I think we can close that gap a little bit, and I would hope that we're given the chance to look at tools that could close that gap. For example, the connectivity to substandard streets. That's something that I feel like it's a perfectly reasonable thing to talk about in terms of tools. It's something I think we did talk about in terms of public works, actually, and there were some various examples. Again, some of this stuff is extraordinarily site-specific, and so I don't want to go back to talking about the comprehensive plan in terms of something that is just site-specific. I want the comprehensive plan to remain, shall we say, our constitution, as it were, and subject to interpretation perhaps, but it's not something that we go back and rewrite. And I think that's kind of my concern.
And I appreciate that. My point was not that when you did the comp plan, that it wasn't as explicit as it could be. We've discussed this for several hours, and we could never come to an agreement on language of how connecting to substandard streets, whether it was safety issues or what we could put from that high-level perspective of the comp plan, how we could protect those neighborhoods. And we did have that judgment over on 236, where the hearing examiner said, no, you couldn't open to a substandard street unless you improve that substandard street. So, thank you.
Bring the mic close.
I don't think I'll make this easier, but my comments really relate to the discussion that's going on right now. I did go back to the Planning Commission meeting, and I viewed you grappling with this among yourselves, and question that came up was, are we looking for something prescriptive versus holistic, I think was the term that you were bouncing around, and I could see that difficult. And it's urban versus rural migration. We see those two concepts clashing, that migration in our city. We see a clash of that. There's also a question as, we're talking about neighborhood character, not the community character necessarily. They may be two different things. So I'm trying to look at this at a holistic versus prescriptive, using your thoughts. And one of the things that I came out with is exactly what Kathy is saying. I think there are a lot of examples in regulation and in the comprehensive plan that if we started going through it and looking for decisions that have been made, do demonstrate the character, the neighborhood character that we're looking to define. And what I mean by that is exactly the street. We have a situation right now where we have an urban street, a new development, abutting to an older development, and we came up with this narrowing of the roadway, and it had to be, when I say we came up with it, that really is a regulation, a rule that we need to follow, a standard. And so there are some of those things that kind of tell us how we need to respect the character of a neighborhood. Some of those things do give us some guidance. So we might be able to go back to some of the regulations and the comp plan in the evaluation process, looking for those tools that give us guidance of decisions we've already made about neighborhood character. Our tree regulation policy is probably full of things that you could interpret as neighborhood character and protecting neighborhoods. So I think it's a big thing, and we might be able to go from the specifics, the specific issues that we already have been working with, and come out with a more general concept of what the character of the neighborhood is.
And I think I would look at it as, how would you get to that? Would you get to that by deductive or inductive, right?
It's exactly what we're talking about.
And I think that the tools will tell us whether or not, because if we propose a tool that's going to affect character, everybody at this table is going to have an opinion about whether that's going to be a good effect or a bad effect on character, and we'll get public input on that also. And I think that looking at it from the perspective of the tools will help us find out where we're missing. If it does turn out that we go through all this, we don't feel like, yeah, but you really haven't addressed the problem of when you change connectivity, you affect character. If we feel at the end of looking at all these tools, we don't have enough tools to do that in a way that is both substantial and effective, and I will look to council to tell us whether or not they think it is, then we can go back. But I think the first thing is to say, do we have some things in our toolbox to affect this character decision? And let us bring some of those things forward first. There will be kind of an iterative process, I'm sure. But I think that starting with the tools is good because we already have the vision. We already have that. And yeah, it might be missing some specific ways of looking at some of those problems, but we really want to look at the tools and be able to give you some ideas about how we might use these tools to affect some of the things we've already decided on.
Romero, did you?
No, I wasn't going to add in at this point in time, but now that I've been given the opportunity, I want to wrap it up. In the sense that I think we have to give them the leeway to work on the tools, not try to go to neighborhood specifics. And this Southeast 32nd, that happened in 2010 with that council. It's been 7 years since then, and there's a lot of other neighborhoods that have been affected since then. So let's not go to one neighborhood that's specific to drive the rest of the city. Let's look at the general tools, and as Frank said, I would concur with his position.
Thank you. Actually, being on the Planning Commission at this time, I'm very excited with this opportunity to have our second chance to recover the ball and run with it. It seems like and I've done quite a bit of work, not going to share all that tonight, but we are talking about characteristics, but there's another term out there, the sense of place. I am caught up in that. And secondly, we've heard about a lot of the goals of the city of Sammamish. There's a lot of goals. What is the purpose of our city? That could be defined. We have neighborhoods, and in summary, what I'm saying is maybe part of the vision statement of this city would be, we are one. Okay.
We have to look at the vision again. Jeff, you want to go? Okay.
I just have one thing.
Go ahead.
Because what I was hoping for tonight is to hear more of the hot button issues and what tools do you want us to develop, based on which problems. So we've heard trees are a problem. I've heard, creating tree buffers to fix that. We've heard about the substandard streets. Is there anything else that you want us to look at? Oh, is Jeff going to walk us through that? So that's what I was hoping for tonight. So maybe I'm just a little early on
Christie
that.
has a comment, and then maybe we could see something.
Yeah, I do want to make a comment because I think the reason that you all are grappling with neighborhood character in general was generated from the public works standards when we were going through it, and it was because of the connectivity issue to substandard streets is where we kind of put our foot down and said, okay, well, what is neighborhood character? And I'll be the first to admit, when I was the one pushing the issue that we really need to define it, is that defining neighborhood character and literally, a written definition will be nearly impossible because of what I said earlier, that a neighborhood is always fluid. Your definition of your neighborhood character could be who lives next door to you, but you can't control who lives next door to you. They have, they may move and someone new may come in. But I think it's important to note that this is not strictly limited to neighborhood character, because I think this speaks to both neighborhood and community character, where I think the zone transition is more of a neighborhood character thing. The arterial street setbacks is more of a community character, and that is defined in our comprehensive plan, community character. Neighborhood character didn't get a definition, but that may have been somewhat intentional, because how do you define a neighborhood's character when it's fluid?
I kind of thought that was what we asked the Planning Commission to do, was to define character, not necessarily come up with the tools at this point. And I realize how hard that is, which is why we didn't want to do it.
Yeah.
But I think I'm just trying to play with some ideas, and Kathy, you mentioned some things, being able to walk within your neighborhood. I think it needs to be stated explicitly that connectivity will affect character, period. Because, you can't have urban growth without affecting the character of the city to some extent. So there has to be some acknowledgement that connectivity will be a factor on character, but that is a balancing act of how much it is or isn't, and how much you're willing to accept or not willing to accept. But there's other factors. The sidewalk, I like the idea of being able to walk. Being able to play in the streets, that's probably not going to happen if you do the connectivity. What are some of the other things? People out in the yards? Maybe there's some, I think we have codes as far as how the houses are designed with setbacks, height, but I'm not sure each neighborhood lives up to the same ones of those. If there's a way of defining that as the character. I'm throwing out ideas, but I think I'm more along Councilmember Malchow's idea. We're looking to define character, not the tools yet. It's more of the things that to be considered to define character, to define the tools.
Well, I was going to, the conversation seemed to be moving towards maybe taking a look at these things, but I was also going to express my excitement for how excited Larry is to work on all this next year. 2 for 2 team. So,
I just wanted to make the one, because you said you didn't know what else to define character. I think we have to take into account also the fact that schools are no longer picking up children unless they live more than a mile away from the school. So many of the communities, where we are doing these connections or opening the communities are within that 1 mile walking distance, and suddenly we've made the streets less safe. So walking, being able to get to school, a lot of the traffic that we see at Pine Lake Middle School and Discovery School comes because people are driving their kids to school because they don't feel there's enough safety. So I think it's both a design issue and some safety programs that we might be able to help create, such as the walking school bus and some other activities, so that it not only reduces the amount of cars that are dropping kids off at school, but makes the roads safer so that the parents can feel more comfortable that their kids are walking. The difference, the one other thing that people used to talk about, I haven't heard as much, is, for example, the change in the character of the homes. And the Evoke homes, I think, were the ones that were most pointed out because they are so modern in comparison to the regular homes. You put them side by side and it really looks a little odd, but how do you can't build trees around them and screen them so that no one can see them. So it does create some problems, and some we'll just have to live with and learn to enjoy.
So Romero and Frank, short ones, and then maybe we can look at a little bit of this.
Again, I think we have to be careful that we don't try to reinvent the wheel. I mean, this thing of character, to some degree, has already been done by other cities. I remember Lyman a couple months ago passed out to all of the council members, and I hope the Planning Commission, I think it was from Mercer Island, a definition of characters, and they had come up with an iteration. As far as the schools issues, the schools are already working with the city as they opened up new routes that they could pick people up. We had a big issue 2 or 3 years ago up here on Northeast 8th, and we have mitigations, the type of walking bus. So there are already processes that have been developed. And likewise for the homes, looking at each other's, the homeowners associations already have many ways to start to look at that. So instead of having the Planning Commission reinventing a lot of stuff that's in place, I would prefer that they get the information from Public Works, from the school, from these other characters as a guide, and look at the tools that we can use. We're talking about whether trees, walls, sound barriers, right-of-ways, et cetera, be more specific and more productive to be able to come with something and to be able to work with the citizens, because if they start to try to work out what's the characteristic of our city with the citizens, it'll be endless amounts of meetings to go through. So I think that would be a more productive use of their time. Thank you.
I would agree with that, and I'm going to be extraordinarily briefly philosophical, and I would say that every decision we make at the Planning Commission, everything we discuss, goes to character. I can't think of a single thing that I've talked about on the Planning Commission in the 2.5 years or whatever that I've been on that doesn't go to character in some way or another. So we aren't avoiding the topic of character. Just like when council discusses regulations, you're instantiating a morality at some level when you create regulations. There's not a single law that a government makes that isn't reflective of also a morality in some way. And I feel the same way about this character issue. But we are being, as a planning commission, we don't want to stay up in the air of, what is character? It doesn't get us anywhere. I think what gets us somewhere is evaluating tools. What gets us somewhere is coming up with some ways that you can do the job that we're volunteered to do, and that is affect character through tools and affect character through the decisions we make, not just debate what character is. I think we already did a good job of that. And so I would say that the Planning Commission looks forward to getting into some of this meat and potatoes of the tool so that we can make good decisions reflective of the character decisions that we've already heard and talked about.
So the council's been punting a little bit on zone transition, arterial street setbacks. Jeff?
Yeah, why don't we move through these quickly, and then maybe we'll come back. And I've actually got a staff suggestion that might help move this to the next step. So Mike Sugg is sitting at the staff table behind some of us here and across from others of you. Mike's going to actually walk you through these slides expeditiously and show you what we worked on here a few weeks back. Mike, I'll turn it over to you.
Thank you, Jeff. Good evening, Planning Commission, City Council, staff, and community members. Tonight, I'm going to quickly run through some zone transition and arterial street setback examples. And in developing this PowerPoint, staff looked at a sampling of some other cities And from that, we developed a few rough examples of how these setbacks could be implemented. And these would be some of the new tools that could work towards achieving an ideal community character. So the first one we'll look at here are arterial street setbacks. And basically what this table is showing are that R1, R4, and R6 zone sites must have a 50-foot minimum setback from a principal arterial, a 40-foot minimum setback from a minor arterial, and a 25-foot setback from collector arterials. And these numbers were sort of adapted from some other cities who do something similar to this. So here's a very basic example of how that would be implemented. This is a 1.2 acre site with a minor arterial running across one side of it. According to the table we just looked at, the minor arterial would require a 40-foot setback, and that would take up about 9,000 square feet or 18% of the total site area. Looking at a slightly larger site, 5.7 acres here, same scenario, minor arterial on one side, the same 40-foot setback for the minor arterial. The setback takes up about 8% of the total site area. Now looking at the zone transition setbacks, this table is showing that R4 and R6 zone sites would need to have a 100-foot setback from R1 zones, and that R6 zones would need to have a 50-foot setback from R4 zones. An example again of how this is implemented on the same 1.2 acre site, zoned R4 with an adjacent R1 zone shown in purple above. The R4 zone would be required in this case to have a 100-foot setback from that R1 zone, and it would take up 44% of the total site area, which is a little burdensome for such a small site. So a potential solution could be to cap the setbacks at a certain percentage of the total site area. And going forward in the next few examples, I'll use 30% as the cap for the setbacks. So this is the same exact scenario, but with a 30% cap. The setback is reduced from 100 feet to 68 feet to stay below that 30% threshold. And here's the larger 5.7 acre site. Again, same example. The R1 zone is adjacent to the R4 zoned 5.7 acre site. A 100-foot setback is required, and it is below the 30% cap, so the full 100-foot setback can apply here. Here is an example of, say, or where both setbacks could apply. So it's the smaller, again, the smaller 1.2 acre site. You have a minor arterial across the top and an R1 zone to the right. And so the minor arterial setback is fully applied at 40 feet, but the zone transition setback is reduced to stay under that 30% cap. And with the larger site, same scenario, the minor arterial with the R1 zone on the right, both the arterial setback and the zone transition setbacks are fully applied because it is below the 30% cap. In this case, the combined setbacks take up 26% of the total site area. And that's it. Are there any questions?
Romero, Frank, and Kathy.
I have a question. If the minor arterial is further out in front and they have an R1 on the side, and let's say that property is an R6, would it then have to have two buffers on each side? Or would it be capped by 30% regardless of how you're bordered on different parts of your parcels?
I think I understand what you're saying. I think it would be capped at the 30%.
Second, as far as the tree retention goes, would that basically be encouraging everybody to move the tree retentions into the buffer zones to avoid putting further restrictions on the property? How is this envisioned in other cities?
It could be that all significant trees or significant and non-significant trees be retained within these buffers. There aren't really a lot of examples of other cities who do this kind of thing. Normally it's, a commercial or industrial zone next to a residential zone where they'll have these zone transition buffers, not necessarily between an R1 and an R4. It's usually of two zones of quite significant different, right. So I didn't see any examples where they prescribed what exactly needed to be within the setbacks, but you could require certain landscaping and tree retention within those.
That was actually, you kind of jumped right on what my question was too, is that there has been some discussion about, from the public, about what to do with these buffer areas. What can we say about them, and what can we say about what the character of them, shall we say? And I know that in some of our other regulations around the pervious surfaces and impervious surfaces, we talked about if you landscaped, you would get a credit. And if you have a certain amount of space and you landscape, you get credit for doing that landscaping. Possibly that could be applied here too. I don't know about how it would dovetail into tree retention. I think there has been some discussion about on major arterials requiring trees to be planted. I don't know about the legality of that. I don't know how that applies. That's certainly something we'd want to talk about. And I applaud the suggestion. I think the idea of a visual buffer between a major arterial and the housing is good. I just don't know what we can get away with doing there in terms of and if it's not just retention. If it's retention, we have sort of one set of regulations that we could apply, but if it's saying you will landscape in a certain way, I feel like that's getting into an area where I want to be very careful about what we do say. And just quickly, where you in your drawing you have there that minor arterial, major arterial, are we measuring that 40 in this particular example from the edge of the right-of-way?
Correct.
So, actually, yeah, so I want to just briefly touch on that because we talked about in our public works standards about the width of the right-of-way, developed and undeveloped. So there is sort of a case whereby we have an arterial and we have significant buffers on the edge of it that are within the right-of-way. We just haven't done anything with them yet. They may be on somebody's, what they think of as their property in their front yard.
Right.
Where are we measuring from in that case? You know, you could conceivably putting this almost right onto someone's front porch if it was a wide enough right-of-way that they just happen to have a lawn in. So I want to be careful about how we define some of this stuff as we go forward also. Jeff?
Just two very quick responses to the chairman's comments. We can establish a landscaping standard for these areas. So for example, in our code already, we have type 1 and type 2 landscaping standards when landscaping is required, whether it's on a commercial project or on a residential project. So we do have the ability to do that. We establish that through code and then we apply it, right? To your second point here, you were just talking about the edge of the right-of-way and unused right-of-way. I think part of the challenge when we looked at this initially was that we have different right-of-way widths. Some of them are right-of-ways that were established a long time ago, and some of them are now new streets that are being established in current day. So I think your variation in unused right-of-way is going to vary from street to street, you know, based on the moment in time when it was established. So having a consistent standard, whether it's going to be from the edge of street or the edge of right-of-way, to have this type of tool developed, I think the important thing is that we probably need to be consistent, and then in some cases, it may be more of a winner, and in some cases, it may not be as much of a winner, so.
Kathy and Bob?
Yes, I wanted to follow up on one of Ramiro's questions that I wasn't sure I understood. So if, for example, this is, Jeff, if this were an R6 zone plopped in the middle of R1 zones and it was surrounded on 3 sides by R1 zones, what would be the buffer setback from each of those? Would the 100 feet be the total and you'd split it between the 3 the sides and the back, or how would you deal with that?
So that's a super interesting hypothetical that you've posed.
It's not a hypothetical.
it-
Oak is in my neighborhood that way.
Yeah, so I think, and again, this is all just from the idea tank in the back room, right? That we've mocked up some examples here. One way of looking at that, Mike mentioned during his short presentation a 30% cap. So you may have to take that 30% cap and divvy it up around all the edges. That would leave you with certainly a much smaller transition than just applying the 100 feet on one side, for example. Yeah, that's a great question. I mean, that's an extreme example, so.
Well, but it is helping parts of our community. And the other thing I wanted to follow up with is to comment on what Frank said, is that we have these now tree ordinances coming in. And how does that work? And last week, we were talking about the camp property, for example, which if that had most of the significant trees in the back, which it did, and then you're going to require a setback and put trees in the front, and we have a total tree canopy issue, do we have to cut some of the significant trees in the back and remove some of those in order to in order to not or take so much property away from the developer, because now we have 55% tree cover instead of 35% tree cover. And so to my mind, the interaction of some of these regulations that we're putting forth is going to be the most significant thing, and what's going to trump and how we're going to apply it in each specific situation.
Good. Bob?
Thank you. I ask myself the intent of the setbacks. What is the intent of the setbacks? I'd like you to be thinking about that as you go through this, because if the intent of the setbacks is to save trees, then I think Kathy hit on something. The quality of the trees that are being saved is an interesting point. Is we're putting a setback that in one area there'll be no trees, another you go down the road 2 blocks and there might be a lot of trees on that particular property. Kathy just made a hypothetical that I don't think is that hypothetical. There could be quality trees somewhere else on that same lot that now all of a sudden these trees in this buffer may not be the priority trees that you would want to save on that lot. But because this buffer is incurred on them, the quality trees are lost. So what I'm looking at is the unintended consequences. What is the intent of doing this? And please evaluate. There may be some other things that you can look at aside from the buffer, or even in conjunction with the buffer. Some ways that you can look at it to make sure that we get quality trees. That's one thing that even our existing tree ordinance, really the one question I have is I wish there was a tree quality standard that was put in, a requirement of an arborist to maybe look at it, that we could even apply an exception to an area with some quality evaluation, as long as they're preserving better trees or the more quality trees. We have groves is the big issue that we want to give a priority to, and we could, again, have areas where a nice grove of trees is being cut down and a string of trees left. So the question I ask myself again is, what are we trying to do with the buffers? Is this the best way to address quality trees in the area? Or is it neighborhood character that we're looking at from a setback from R1 and R4? Is it really, is that what we're trying to get, the nuance of it? In R4 and R6, if you start throwing those together, is there really a character difference between R4 and R6? I know in some of the reading that I just did in the study for this material, we have setbacks that are standards that are different for a multi-use development next to a single-family home development. That gets back to the character. So I was saying a lot of the things that we do already reflect some of the things that we value that are very specific that we can look at. So don't want to go on, but while I understand the intent of this, I think that as we move through this one, we should really make sure that we are looking at, are there any unintended consequences, and are we really getting what we want between community separation and the retention of trees? Because I think that's one of the very important things that this does try to reach. These setbacks really are looking and saving trees.
Good comments, good points. The best, I think you're the one that said it earlier, though. I think there's a big distinction between neighborhood character and community character, and I would ask the Planning Commission to keep that distinction in mind.
So, one of the, as Jesse will tell you, learning how to compromise competing interests is something that I had to learn in coming to volunteer for the city. I think if we just limit ourselves to a tree-based solution here, we're not going to get things done. I don't think it accomplishes either character or the purpose of doing this is not for tree retention. I would say that. While tree retention is a goal, and certainly there's nobody more in favor of that than me, but I think that's not what we're trying to do here. I think we are talking about a character issue. So I think the language that Jeff was talking about with regards to landscaping standards is probably a more effective and potent tool to apply to this particular situation. Those landscaping standards may include trees. They may include cooperation, for example, with the upcoming discussion about the urban forestry management plan. I mean, that's what we're talking about there is landscaping standards as they apply to doing the best thing possible for the environment. And I think that's where we're going to get to some of those more effective solutions rather than just say we're trying to put trees against arterial. That to me, there are going to be cases where that's going to work out great. I can, like you were saying, I can envision others where that just creates a handful of unintended consequences that results in less trees in the long run. So I want to make sure we're doing this right, and I think applying the right tools is the right place to start talking about it.
So it sounds like we have a few tools to pass to the Planning Commission. One other thought is whether the setbacks would affect the net density. In other words, can you cluster, if you're going to take away land on the perimeter, can you cluster and keep the same density?
Something we're going to have to look at and discuss. Yep.
Good. Christy.
Thanks. So I think the advantage that we have is that the Planning Commission gets to grapple with all these issues that we've brought up and will likely uncover more as they start to work through the examples. And I think that's why we have a Planning Commission. So I don't envy you guys for having to go through this exercise, but I think we certainly appreciate it. It's easy to hatch these ideas in a back room. It's quite another to work them out so that they will work out in our community. Just a couple of things. I think the vision initially was not necessarily inclusive or exclusive of saving trees. I mean, yes, but I think there was that character issue. Was really the idea of being able to drive down a principal arterial, the only one we have in the city, 228th, and not just seeing homes, but being able to see some trees along the way. How that works out in different scenarios, I think you guys will get to go through that exercise before we see it again as a council. And then another thing I at least wanted to point out is we allow clustering in the R1 zone, which is effectively like having R4 zoning. So just another thought to keep in mind as we go through this is you wouldn't want to necessarily have a transition zone between an R1 and an R4 when you have clustering that's existing.
And I think we'll probably also want to talk about the implication if there's buffers already and that environmental buffers in these buffer areas. You're talking again about a competing interest there. You have one type of buffer which is based on zoning. You have another type of buffer on the other side of your property which is based on, say, a sensitive area or something like that. There has to be some consideration of you've now buffered an entire property, and I'm not sure how to solve that for where everybody's going to be happy. But I think, like you said, these are the things we're going to grapple with as we start looking through this. What are the exceptions and how do they apply? Tree houses. Hey, I'm all about. That'd be great. So.
Okay, great discussion. Jeff, you want to close it up?
Yeah, I think so. So then I'm sensing our dialogue here the last several minutes is going towards the council would like to, as a starting point, have the commission take a look at some of this work that's been completed already, vet it, hopefully get some good public input, and bring some recommendations back to the city council then, first quarter of 2017, okay?
Under the parameters that you and Frank mentioned of the landscaping and.
Yeah. Yep. So we'll work on that. I imagine we'll probably have a number of work sessions with the commission leading up to putting some recommendations together for them to deliberate on. I think the additional recommendation I'll make is we'll also have the commission maybe do somewhat of a literature review in terms of, we'll compile statements about character in our comprehensive plan that was updated in 2015 and bring that back to present to council as well. So you can kind of see everything in one place. That might, I think, assist with some of the dialogue to come in the future as well.
Sounds like a good plan.
Great.
And I'd like to thank the Planning Commission for this spirited conversation. And I think we're adjourned. Thank you very much.
That's next to each other.
Good evening and welcome to the December 13th, 2016 meeting of the Sammamish City Council. Madam Clerk, would you please call the roll?
Mayor Don Gerand.
Present.
Deputy Mayor Ramiro Valderrama.
Present.
Councilmember Tom Hornish.
Present.
Councilmember Kathy Huckabee.
Present.
Councilmember Bob Keller.
Here.
Councilmember Christy Malchow.
Present.
Councilmember Tom Odell.
Here, finally.
Councilmember Odell, would you lead us in the Pledge of Allegiance?
This could take a while. Maybe he'll hum it while we're going.
I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I'll get even, Don.
Okay, do I have a motion to approve the agenda?
So moved.
Are there topics to be removed from the consent agenda?
Yes, Mr. Mayor, I would ask that items number 2, contract prosecution services Moberly, and item number 5, contract legal services Kenyon Dyson, be removed from the consent agenda.
Okay, items 2 and 5 we'll put under new business. Any other changes? Nope. All those in favor of the agenda, please say aye. Aye. Opposed? By your vote of 7-0, it's approved. Next comes presentations and proclamations. And the first one, do you want to introduce it, Mr. City Manager, or not?
Mr. Mayor, why don't you go right ahead?
Okay. I was looking for my copy. Maybe you could put the copy here.
Maybe.
Okay, we have a proclamation here, and the council is going to share in the reading of it. So, proclamation. In the wake of a contentious and discordant national election, we take this moment to pause and reaffirm our principles and values.
As your city government, our role is to bring people together and not divide them. Our job is to be welcoming of all people and all ideas in recognition that we are truly stronger and smarter together. We need to recognize certain essential principles and conduct our government and our lives consistent with those principles.
Consequently, as your city council, we pledge to do all we can to foster civil discourse, to ensure that city services are always provided in a manner that does not discriminate on the basis of race, sex, religion, national origin, disability, sexual orientation, or gender identity.
To foster a community that always encourages people to achieve their potential and help others to do similarly. To protect our air, water, and other parts of our natural environment, to protect the health and futures of our family and future generations.
To welcome, without reservation, new people from all parts of the world, with an abiding faith in their potential to be part of and strengthen our community. To never marginalize or demonize any person or group of people.
To respect and listen to people and their ideas. To understand that we have a responsibility not just to ourselves, but to others in our region, including many who are not as fortunate.
To do all we can to ensure that our children will inherit a world that includes all of the good that the world our parents brought to us had, to encourage our national, state, and regional leaders to uphold these same values.
We commit to regularly remind ourselves of these principles and to judge ourselves and our city by our adherence to them. Proclaim this 13th day of December 2016. Thank you. Okay.
Mr. Mayor, the staff intends to post that proclamation in the lobby so people, when they come into City Hall, will be able to see the values that we hold.
Good. Thank you very much. Okay, the second presentation, Mr. City Manager.
Thank you, Mr. Mayor. We're fortunate tonight to have Angie Fesser, our Director of Parks and Recreation, and Anjali Meyer, our Parks Project Manager. We are reporting back to you with a discussion on the YMCA property. This is the property that is south on 228th near the Pine Lake Middle School that we have a relationship or a leasing arrangement with the YMCA on. And we were reporting back to council with some work that we have done or were charged with previously. So I will turn things over.
Good evening, Mr. Mayor, members of the council, Mr. City Manager. I'm Anjali Meyer, Parks Project Manager, and here tonight to provide an update on the YMCA property study. The discussion outline for tonight is as follows. We will first report out on the 3 studies conducted as directed by Council in July of this year. These will include the wetland reconnaissance, the preliminary geotechnical analysis, and the arborist evaluation. After that, we will give you an update on a discussion we had with Arena Sports, a provider of indoor field houses in adjacent cities. And then I will turn over the presentation to Jesse Bond, our Deputy City Manager, who will give you a brief overview of the lease agreement once again, as well as discuss potential next steps for the property. Just as a refresher and for the benefit of those in the audience who are not familiar with the property, it is the red box you see at the south end of the map. The YMCA property is on 228th Avenue Southeast, just 2 miles south of City Hall, adjacent to Pine Lake Middle School and the Issaquah School District bus barn. The property measures about 7.25 acres. This was purchased by the YMCA back in 2005, and the current assessed value from the King County website is about $1.9 million. Not only is the site flanked by 228th Avenue on the west, it also has a shared road within an easement between the school district to the north and the YMCA to the south. The site is zoned R4, and we discussed some of that at the last meeting. With that brief introduction, I am going to go ahead and give you a quick summary of the 3 study reports. I would like to let you know that we do have all 3 consultants in the room today. We have Marcus Byers from Kleinfelder, who did the preliminary geotechnical study. We have Katie Hogan from Tree Solutions, who did the tree evaluation. And we have Nell Lund from the Watershed Company, who did the wetland reconnaissance for us. We'd like to request that council can hold their questions to the end of the presentation, but they would be happy to take any questions that my summary doesn't cover. First, with the wetland reconnaissance, all the studies were done in the August-September timeframe. The property is located within the Laughing Jacobs Creek sub-basin. As previously discussed, there is a stormwater detention pond at the northwest of the site. There is also a stormwater drainage, which is from the school to the north, the outfall of a drain that now has a wetland and a stream, a seasonal non-fish-bearing stream associated with it. And then we have an off-site wetland and seasonal stream that is located within the open space sensitive area tract south of the property, the buffers of which do encumber the YMCA property. Looking closer at the wetlands, Wetland A to the south of the site is a Category 2 wetland with a 100-foot buffer, and Wetland B is a Category 3 wetland with a 75-foot buffer. As for the streams, both Stream A and Stream B are seasonal, non-fish-bearing streams with 50-foot buffers. Now, we have had a question that the reconnaissance was done at a dry time of the year, but these studies are routinely done any time of the year, and there are more than one indicators to identify limits of wetlands and streams, and they would encompass the presence of water, the planting, and the soils. So all three factors come into play. For instance, this was looked at in the dry weather, but yet we know there is the existence of seasonal streams, and that's by looking at the stream bed, you can actually map it on the site. Moving on to the preliminary geotechnical study, really the point of this study was to check what the soils at the site were like and to see if they would be suitable to support a structure should we decide to go in the direction of building an indoor field house at this location. We found no surprises. There were about 10 test pits excavated on site, and the soil conditions have been found to be appropriate to support conventional shallow spread foundations for a building. The soils included forest duff, weathered glacial till, and glacial till. This forest duff layer was found to be about 6 inches, and so the geotechnical report does recommend that we factor in about 6 to 12 inches of that duff layer to be removed before we start work, and that would have to be factored in for our grading at the site. Fill materials are recommended to be either undisturbed native or compacted structural fill. The site soils do not infiltrate well, and so that is ruled out as an option. This is fairly similar to what we went through with the community center site. Essentially, rain gardens and such are ruled out since the soils do not infiltrate. And the other thing to be expected is perched water to be anticipated following a wet season. And what perched water really is there are these sand layers between layers of glacial till, and that's a path for water to travel through the site. And again, that's to be expected. So generally speaking, with sites like this, it is recommended that a lot of the earthwork construction is timed such that the earthwork is done in dry weather, as the soils become quite unworkable in wet weather. And third, we have the arborist report. The tree assessment found that the site is fairly stable. The health of the trees is fairly stable, mainly native species including Douglas fir, western hemlock, bigleaf maple, red alder, and western red cedar. And the recommendation is, rather than focus on a tree that's a significant or a landmark or a heritage tree, that we focus on preserving clusters wherever possible. 5 trees at the northwest corner of the site were identified to have some serious structural defects and have been flagged for the city to look into and keep a watch on, because they are near the road and they are near power lines. And there has even been a timeline established within which the recommendation is to either reduce them to snags or remove them. So we would have to watch those 5 trees closely. Other than that, there have been isolated root disease pockets identified in about 3 locations of the site. To the southeast, there is a group of about 15 trees that have been found to have the root rot disease, but the recommendation is to let them be for now, as they are near a wetland. And there are 2 smaller pockets of trees, 3 in one grouping and 6 in another, where dead trees were identified, again due to the laminated root rot disease. That concludes the summary of the 3 studies. And just to loop back on where we were in July, this was the graphic we presented. The assumed buffers at the time were about 100 feet for both wetlands. And What we have today is that the wetland along the east of the property has a buffer of 75 feet. So you can see that the buffer shrunk slightly. Also in front of you here is a graphic that you did see in July that has been updated with the corrected buffer, and this was part of a what fits exercise showing you the recreational facility of about 40,000 square feet with associated parking of about 133 cars on this site. And just so you can look at it a little closer, that's what the footprint would look like. This is just the bare bones of 2 fields, the minimal lobby space and restrooms. It doesn't have any restaurant, any gathering place, play areas, warm-up areas. Based on what we are seeing from other facilities, our best guess is that a facility like this would cost about $15 million. And the confirmation will have to come from a professional architect. This is just our best guess looking at other facilities in the area. A meeting with Arena Sports. Don Crow, the owner of Arena Sports, made the time to come and meet us in August of this year. Don has also made the time to be here tonight. Don, you can identify yourself in the crowd. So he is also here to take any questions council would have at the end of the presentation. I just have one slide that summarizes our conversation. According to Don, about 10% of youth soccer players would typically play 1 season of indoor soccer, and about 2% of youth soccer players would play for 2 seasons. His highest demand for his facilities are always from December to February, and it's not just one sport competing for space, it's all the sports. It's soccer, it's lacrosse, baseball, football, you have it. They all want to use it at that time, and then the facilities sometimes would stay empty at other times of the year. Revenues come from rentals and concessions. Without us doing a market analysis, Don's best guess is that a single facility would probably be sustainable, a single field facility would probably be sustainable for Sammamish. Now, we have to keep in mind that there is a facility, arena sport facility in Redmond with about 3 fields and a facility in Issaquah with 1 field. And finally, Don is in the middle of getting his biggest and newest facility ready in Mill Creek. And the direction in which they are headed is family entertainment. And that is, from the learning that it's hard to always rent the fields out. And so there's a lot of other amenities that they're throwing in, like bowling and laser tag, bumper cars, inflatable play equipment, party rooms, and all the other amenities that make it easy to draw regular users. That brings me to the end of my presentation.
A few more slides, Mr. Mayor. Sorry I snuck up on you. Good evening, Jesse Bond, Deputy City Manager. I'm fielding these last few slides to try to make sense of what your former Parks Director was thinking when she was participating in the negotiation of the ground lease. So just for context, and I should identify our YMCA partners who are here tonight. YMCA. Marcia Eisenberger, who is the regional executive, I think that's still your job title or some variation. It's close. Okay. Marcia and I had the pleasure of working together to negotiate not only the operating agreement, but what followed and became what is now known as our ground lease. What I wanted to share for context is it took us quite a while to get to the finish line on the operating agreement. The component of this that tells how everything came together on the community center. The ground lease came second, and the YMCA had envisioned doing something purposeful with their property. But they said, as partners, we would be happy to lease it to you, and you can do something purposeful with this property. The vision was a structure, and the YMCA pushed pretty hard for us to clearly define in the lease the timeline and the size and all the details of what would come on this property. And we pushed back equally as hard and said, look, we get it, but we've got a $30+ million project that we need to focus on first. So what transpired in that time was an agreement that we softened the language, and we would work together today to figure out what the future of this property looks like. So some of you have asked, Jesse, you kind of set us up for a big giant gray area, and we did, because we knew that if the YMCA expected us at that time to say we will build a $20 million facility by 2020, that was a non-starter, right? We just couldn't make that commitment. But we had a strong partnership. We have a strong partnership. And as recently as last week, I sat down with Marcia from the YMCA and said, where are you at? And I will share that we had a wonderful conversation. That partnership is still there, and the YMCA is willing to work with us and support us as we determine and discuss further the future. So we're in a good place. So as I get to, Anjali, I'll have you move to the next slide. I thought I'd talk just a little bit about the details of the ground lease and then offer some suggestions regarding next steps. Again, the ground lease is part of this overall agreement that was approved in 2013. We've already talked about the property it pertains to. We did desire, we the parties envisioned a facility, which is in the lease described as a recreational facility, leaves some room for interpretation. If you asked the why, they would tell you it is a building. That was their vision. We would say, yeah, okay, maybe to be discussed. There's no rent. It was rolled up as part of the operating agreement. The terms are exactly the same as the community center. It's an initial 25-year lease up to a maximum of 50 years. And if for some reason the operating agreement for the community center terminates, the lease terminates as well. Why are we here today? Why now? The Y felt strongly that they wanted us moving forward with a plan for this property. So we put in the date of which a development plan would be completed, which is now coming up on June 30th, 2018. Part of the reason we touched base with you this last July was because that date is looming. And our interpretation of a development plan is there probably needs to be some analysis put together with support of a consultant to get to that date. I will tell you, the YMCA has said, maybe we need a little breathing room. They would be willing to sit down with us and talk about pushing that date out within reason, a year, let's say. All right, next slide. So the development plan, we loosely described in the agreement as a concept level site plan with a preliminary budget estimate. I think we both interpreted that to mean something that looks like a feasibility study comparable to what we did for the community center, and I'll talk about that in just a minute. The things we can build on the site, in addition to a recreation facility, which again, as I've said, the Y really thinks that means a building. We're not so sure, but we're willing to talk, right, Marcia? The agreement, the intent of laying all these things out was to say this is for recreational purposes, right? Starbucks might be great, but we're not going to put a coffee shop here necessarily, but we are all committed to recreational type amenities. The costs of building and developing this property, whatever that may look like, are ours, the city. The YMCA may be interested in talking about a relationship, but the way the lease agreement reads, it's our job to pay for the improvements. Next slide. So we don't need to talk about this except to say that if we invest in the property under the terms of the lease and for some reason it's terminated, there's a whole component of both the operating agreement and the lease agreement that says we won't lose our investments. They will be depreciated. We also don't have the ability under this lease to sublease the property without permission of the Y. And we do have the option to purchase the property at fair market value. All right, so next slide. So next steps, I have some options for you to consider. And before I go there, I want to just talk about what a feasibility study is. So next slide. Some of you may recall I shared a graphic like this 5-6 years ago when we were working on the feasibility study for the community center. When we do a feasibility study, it's with the intent of completing a public process. So at this point, we know generally what we're going to build. In the community center feasibility study, we knew we were building a community center, but we went to the public and said, tell us more about what you want in this building. So at that time, for example, aquatics really rose to the top, and that became a major component of our study. We do a market analysis. So it's important to remember this building has any building would have a component of expenditure and revenue. And again, with the community center, we learned that if we operated the building through our market analysis, we were looking at a pretty significant subsidy. And finally, we take time to figure out, and these are probably not in the right order, what we would build. So Anjali showed us a slide earlier that had 2 fields side by side, but likely a structure is going to need a little bit more than that. So we put all of these things into a process with a consultant that knows a few more things about this than we do, and they provide us some data points, and that would produce analysis that would give you more information about a potential building. So the final slide is some options for you. These aren't necessarily, we have to do one or the other. It's really to foster some conversation and discussion tonight. Your 6-year park CIP does call out completing a feasibility study for an indoor field house or soccer facility, or you plug in the blank athletic activity on the YMCA property. So if we were to undertake a study, it would include the components that I just described, and that would be per your park CIP. We could do a slight variation on that and study an indoor athletic facility that wouldn't be site-specific. When you did your community center study, we had the general zone confirmed, but we did not have the site confirmed at that point. We've also had a lot of questions about pursuing passive recreational use of the property. So when I talk about passive recreational use, that's not built structures. That's typically things like small parking lots, trailhead, trails, consistent with Evans Creek Preserve or Beaver Lake Preserve, things like that. Big Rock Park is mostly passive. If we really wanted to pursue that as a conversation, I would suggest you direct staff to sit down with the YMCA and formally engage them in discussions around the lease agreement. We definitely have perhaps some slight difference of opinions of what that definition of recreational facility is. And I think that's fair. So we would be happy to renegotiate, and the Y has said, yeah, let's sit down and talk. The other thing I want to remind you is we have a big planning year ahead of us across the city. So you have the option with, again, sitting down and asking the Y if they would allow us to postpone the date of that development plan deadline by, let's say, a year, to work through your parks plan update in 17 and your land acquisition strategy. Your parks plan will really take a deeper dive into athletic field need. Had several questions about how many fields do we need. I don't know. Your new parks director will, though, in about 9 to 12 months, right, Angie? So your park plan, it's a chapter of it's an appendix of your comprehensive plan, and it's scheduled to be updated this year, adopted by the first quarter of next year. It is really a guideline for your entire park system. Your land acquisition strategy is already underway. The first phase is identifying a policy that helps guide how we do land acquisition and how we prioritize properties. The second phase is actually taking a look at what we might want to put on our wish list down the road. What I'm not mentioning in this list is you also have the urban forestry management plan coming up mid-year, and indirectly, although I think it relates to everything, your transportation master plan. So you have a lot of planning work that really help guide property use. And this has been a tough one for us because we're focusing on just one property, not looking at it and asking the question, how does this fit into the whole park system? The other thing, and this came up in the mayor's meeting yesterday, is what is the role of the Parks Commission? Right now, you have not handed this off to the Parks Commission. So several of them are here tonight. I know they would be happy to entertain studying any of these options or fill in the blank and come back and prepare a recommendation for you. So you have the option of asking them for some help in working through any of these options, or, as I've noted, another option that I may not have presented tonight. So that kind of concludes our presentation and where we're at tonight. We will need direction at some point as to next steps.
I think first we have some questions for staff. Councilmember Odell.
Thank you. Jesse, this particular location was one of the sites we looked at for the community center and was rejected because we had some issues with the site in terms of size, and also because we wanted the community center to be in a more central location. My first question is, compared to the 80,000-foot community center we're looking at that point, how does the soccer arrangement that we saw earlier in this presentation compare? Is it the same size, smaller, bigger?
That presentation was about a 40,000 square foot footprint with 113 surface parking spaces, 133 surface parking. 133. We have about 100, give or take, surface parking at the community center and about 200 structured here.
Because the slide showed 150.
It did, yeah.
The slide was wrong, huh? The slide showed 150.
Yeah, that's what I saw too.
It did?
Yes.
But that's down in the weeds.
Okay.
No, I know, but let's get the correct one.
If you need it, I have the original community center layout. It had 80,000 square feet, 50 car spaces on the surface, and then a parking structure, 3 stories for an additional 270 cars, which is essentially what we put in here, I believe, or close to it.
Are you talking about the plan, the YMCA plan for the YMCA property?
No, this is our potential plan for community center.
The feasibility plan?
Yes.
Yeah, which of course morphed
Right.
as we went
Right.
into design.
It wound up being much, much larger than we could afford, but yeah. My recollection of the contract with the Y, and I do need to go back and look at it again, was that it did call for developing a plan for using it. It was not specific as to recreational use. Am I correct or not?
It calls for the development, well, establishing a development plan, which I will say in fairness, we probably could have defined a little bit better. The development plan is to include basically a plan for siting, improvements on the property, and a cost estimate. Your lease agreement did not go as far as saying this is when something needs to be built. We were concerned about putting that in the lease agreement, and it would have been a non-starter, I think, for those of you on the council at that time. However, in the spirit of the agreement, I believe the YMCA would tell you, and Marcia can march right up here and tell you herself, that she was hoping we would be doing something, the YMCA was hoping we would do something with it.
Okay. Looking at the chart.
Marcia, do you want to march right up here and tell them yourself?
Looking at the chart that's still up. No, I'm still asking questions.
Might as well just call you up. You want to speak to him?
Go ahead, Marcia.
Yeah, so, good evening. So yes, in the spirit of the agreement, it was to talk about recreational use. And I believe that recreational use is actually in the agreement. Have to go back and look. Thank you, Marcia.
Okay.
Looking at next steps, should 1B not come before 1A?
I apologize. Can you say that again?
Should 1B
I don't think it's in
Come before.
particular order, Tom.
Their options.
What I wanted to point out in putting 1A up there is that your park CIP was fairly specific in calling out funding to do a feasibility study for an indoor athletic facility on the YMCA property. We were very specific. That was an early vision that's carried through the park CIP. So just, I wanted to lay that out. That's what's in your funding. That can be amended. That funding could be used to do a feasibility study for a facility that's not site-specific. So you can make that decision to use that funding in a more general way.
Okay.
Moving along.
That's all I have. Thank you.
Okay. Deputy Mayor Valderrama?
Mr. Mayor, are we doing only questions at this moment?
Yeah.
For the sake of brevity? Well, prior to my being on the council, this idea had already been in the works, and as I recall, several of the council members here and others had gone to Colorado and visited other indoor facility sites. I take it that those lessons learned from that earlier council were also applied in looking at the schematic as well as meeting with Arena Sports, and that it is seen as a viable possibility of what taking in those lessons learned.
I do not feel comfortable saying that this is, I guess, what's viable? Is that full cost recovery? Is that profit? I do not feel comfortable, based on the information we have today, saying this is a cost recoverable facility or a profitable facility.
I'm saying the physical space and what.
Yes, physically, we know we can fit a modest indoor field house on the property.
The second question, the last time we had a presentation here, I had asked that we inquire both with existing clubs as well as organizations like Arena as the potential interest in the community by some of these to also partner with us in the structuring. That's been done with other cities where they've looked at putting fields in and getting commitments for blocks of times. Has anything like that been done, or is it anticipated to be done?
That has not been done. If you would like to speak with a representative from Arena Sports, he can probably tackle this one a little bit better than I. Should a facility like this move forward, if the council endeavored us to pursue a partnership, we would certainly be open to pursuing that. We're not quite there yet. But our big concern, and even before we partnered with the Y, was to do that feasibility study to determine what it is we propose to build and if we had the market for it.
Well, that's why I was saying if you start to inquire, you might find, as they did on Central Highlands, that there were people saying, hey, we're willing to block out 25% of all your times.
Would you like to hear from your representative from Arena Sports? I really feel that he has a better grasp of this operation than I do, and he's traveled here tonight.
Sure, Don?
Sure, why not?
With a name like that, we have to hear. So isn't Jay, is it?
So your questions, are we interested in partnering?
Or are there you or other entities that you would anticipate as well as like clubs?
Yeah, so we have a partnership with the city of Seattle at our Magnuson Park facility where we invested $9 million renovating their hangar and we run the whole operation. We work with clubs around here quite a bit. I think the caution with the clubs here versus say like in Parker, Colorado, where they went was, there the clubs have nowhere to go for 4 or 5 months, so they spend premium and they come indoor. In this market, Crossfire doesn't come in, Eastside doesn't come in, Seattle United doesn't come in. We're dealing mostly with recreational teams that come in, and it's a fun activity to do versus training, which is typically what you'll see with clubs.
Can I put you on the spot?
Sure.
We learned a little bit about operations. It's not just about fields. So without telling us all your secrets, can you tell us about what goes into a successful indoor field house?
Sure. So, just a little background. We not only run sports centers, we provide our Little Kicker franchise all around the country, North America. We have about 100,000 plus kids doing that, as well as we have software that about 200 and some facilities like Arena Sports use to run their program. So I have a great deal of experience with a lot of other owners around the country. And so we work pretty extensively on how to optimize the facilities. Ours, It's mostly adult leagues and little kickers, and then the youth leagues kind of fill in on a seasonal basis. We try, and then we have summer camps and parties, and rentals is actually very little. We'll have concessions, even beer sales, because the adults, it's an activity beyond just playing a sport. They're typically hanging around afterwards with their friends. People will drive about a 20-minute drive to come to our facilities. They come into town, they don't go out of town typically. So, a facility up here won't get people from Bellevue, whereas people from here go to Bellevue all the time. If you think about people in this area, they probably don't drive. You guys probably don't go out to Snoqualmie or North Bend to do much, right? But you'll go to Bellevue or Kirkland or Redmond all the time. That's just the nature of the business. So, and it's a year-round business. For us, we don't have the luxury of tax dollars. We got to pay all our bills, and we have bills in July, just like we do in December. So, the other thing is, a lot of different sports say they want to come in, but they all want to pile in at the exact same time, right? You want to have the football guys and the lacrosse and the soccer, and everybody else wants to be there at 7 o'clock at night on Tuesday, but they only want to be there for a certain period of time. So you just have to be careful when you hear feedback from the community to really filter that down. So you'll feel, it sounds like a lot of noise. Oh yeah, we need this indoor soccer center. But then, like I said, about 10% of the kids will actually come play indoor soccer, just for 8 to 10 weeks of the year. That's it. Adults will play year-round, and little kickers type programs will go year-round. And then camps happen every day, school's out, so except for Christmas and Thanksgiving and whatnot.
Other questions for Don?
I
Bob?
do.
Yeah.
Thank you.
Just for Don specifically.
I'm curious, have you seen any models a little different than your own? Because Sammamish has chosen not to be a service provider in the Parks and Recs department. This is, when we're looking at all this, we're talking about a building, but Sammamish may have to decide if they want to provide programming directly. So my question to you is, how do you see a facility like this, if it's not outsourced, or if we did not partner with an organization such as yourself, if we tried to do it on our own, how do you see that?
Yeah, what we refer to those in the parks world are wholesale versus retail, right? There are a lot of wholesale providers, even in my world, where somebody will build a big building and they'll just rent time. Ice arenas do this a lot, where they'll build the ice rink and then they'll rent it to the adult hockey leagues and the figure skaters and the youth hockey. So that's a wholesale provider, which is really what you guys have been like, where you rent fields and facilities to people. And then the retail side is more like Issaquah, where they're trying to run a lot of their own programs. But even then, there's a hybrid where they do partner as well with some other organizations. And I think a lot of cities we see in our software, we sell it to Parks and Rec too, is that they chose wholesale because they didn't want to have all that overhead of trying to run all these things. Well, nowadays, with all the software solutions, it's so easy to do, they choose to migrate to start to do some of their own programs. So that's really a decision that you and your parks will have to make on what you want to do. Do you want to continue to be the wholesale and keep administrative costs down? And I do think in the youth sports especially, there's some fantastic volunteer organizations out there. We're seeing basketball, softball, soccer, whatnot, and it just makes a whole lot of sense to at least be a hybrid rather than run all your own programs. But it is a whole separate business. You're going to have a lot more overhead and costs and marketing and customer service and support if you try and run all your own programming. So that's, up to you guys to decide what makes the most sense for you.
Christy?
A quick question. In our presentation, the revenue side came from rentals and concessions. And I'm a frequent flyer down at your Issaquah facility. Twice on Saturday I'm there. But I know that, you have your party rooms, that's probably part of your rental side. But, even the parents are sitting there drinking beer on Saturday afternoon, watching their kids. And I would suspect without a partnership, that's not something the city is going to be able to do. But I'm curious from a percentage side, your revenues are coming more from the rental side or more from the concession side?
Yeah, I must miscommunicate with Anjali on that. Rentals, we get very little. It's mostly leagues, classes, camps, and membership. primarily, and then, concessions is probably 15% of our overall revenue maybe, and about, 2/3 of that is beer sales, you know.
Okay.
So, yeah. Yeah, so, most of it's leagues and, little kickers. There's 75% of our business because they are year-round programming, and then camps come in, and then when I have leagues, youth leagues are included in that.
Thanks.
I have a question for you. This facility would be right next to a middle school. Do the schools use it for gym programs? Would they?
Yeah, it depends on the school. In our Magnuson facility, the Waldorf school is right across the parking lot, and they come in. We have arrangement. They, it's off-peak hours, so we give them a discounted rate and all that stuff. And usually with a city partnership, that's kind of drawn in, like what percentage you'd want to discount or provide free services for whatever programs. That's all negotiated in the deal. Up in Mill Creek, our new one's right across the street from Jackson High School, and we haven't talked to them yet, but my guess is they're going to want to use it for some reason. The Cedar Park Christian School is going to come in and use some of it for its PE programs. Typically, it's the private schools that don't have a lot of facilities, or home schools will come in and run PE type programming in those facilities. Not really public schools as much, because they often have their own facilities and they'll just use those for free rather than incur more costs.
The other question I have is in Pasco, there's a private facility that has an indoor field and then a small kiddies field 90 degrees from it. And then they had, at least some years ago, a gymnastics club there.
Yeah, they run our Little Kickers program and use our software in that facility, yeah.
Oh. So
yeah.
it seemed to be thriving.
Yeah. There's another thing to explore is hard court with futsal, right, where you can do soccer and then you can do a lot of different things. So that's definitely something that, I talked with your staff about, as, that's an option as well. You get a lot of different uses in there. And on hard court, volleyball will play year-round, and basketball will play a lot more year-round than in indoor soccer and field house. Yeah, just because if you think about it, if you had one choice and you were a soccer, football, lacrosse, what field would you want to be? An outdoor sunny day field, right? Whereas basketball, volleyball, you want a nice air-conditioned indoor hard court. So it's the primary use for that type of facility versus an indoor field house in this climate where you can play outdoor year-round is not really the primary. That's just something, we'll go do as an extra fun activity for the club side, for the youth side I'm talking about. Adults will play, year-round because it's a fun, different kind of game, and they'll play outdoor and indoor. It's a convenient activity for the adults.
Great. Any other questions for Don? Nope, I guess not. Thank you, Don.
No problem.
Christy, are you through with your questions, or do you have some more?
Yeah, I didn't have questions, but was going to address, Jesse was looking for some direction from us, so, but I can wait if we're still doing questions.
Yeah. Kathy?
Yes, it seems to me that there are almost more questions than answers. But I wondered whether the numbers that you had looked at had taken into consideration at all the potential cost of building a sidewalk in front of that facility. And particularly, we've heard a number of people say, well, if we converted it to something else, we could have people walking over there from Providence Point and others. And as I remember, when the Y first acquired this property, there was a quote of something like close to $500,000 just to do the sidewalk on this particular property, let alone an extension of this property?
Anjali can address that.
Yeah, so we have included frontage improvements, which would include a sidewalk as part of the costs to come up with that number we gave you.
My other question would be, I'm looking at option 3, and I'd like to get a better understanding of what it is we would do through that process to help us identify whether, first of all, whether we want an indoor facility, second, the correct location of that facility, because since this property came into this rental agreement, the city has expanded dramatically, both in terms of size and in terms of numbers of people. So I'm sort of leaning toward, let's get more information before we move forward and make any decisions on this. But I'd like to get a better idea of what it would be that we would do through that pro plan and the land acquisition strategy. Surveys of the community,
Yeah,
getting
that's-
better counts of people who might be interested or willing to use an indoor facility, better ideas of whether it would be successful with amenities or without amenities and so forth.
So I'll maybe jump in and then Angie, correct me. The Pro Plan Parks, Recreation, and Open Space Plan we adopted in 2012 stopped short of actually quantifying the need for outdoor athletic facilities. And frankly, I guess that would apply to indoor athletic facilities as well. There were a variety of reasons we didn't get there. Parks leadership maybe being part of the problem. We took the analysis as far as we could at that point. In this plan, a number of you and the community has asked, how many more fields do we need? Is it more fields? Is it field upgrades? What can we do? And let's measure that. So I would anticipate, as an outcome of this plan, having a measure. We can say, this is where we're at, population size, league size. We've spent time with our leagues as stakeholders to talk about really what they need, and we can share with you what that looks like. I would also hope we would take it a step further and start to identify some capital projects that would help address that need. Zooming out a bit, the first thing we do when we update the Pro Plan is a community survey where we ask, what type of park and recreation amenities do you want? If an indoor athletic field house comes out as number one on the list, we have a pretty clear indicator that this is a high priority. If something else comes up, walking trails is number one, you're going to have some data to help guide your decision making. We have not asked the community, frankly, if this is a priority, this type of a facility. We just haven't studied that. So our hope would be that you would have more data to help guide this decision. Land acquisition is another much more complicated piece, and I know some of you have said, well, this property is tied up, meaning it's safe from development for the time being. We have resources set aside to buy other lands. We need to look at the whole picture. It's hard to make a decision about this property to develop, to purchase, without having this policy in place and taking those next steps. So I think the position that we're in is you have some pretty remarkable planning work on your plate that I think will really help inform this conversation, more information than we have for you today.
Councilmember Hornish.
When do you need us to give you clear direction? Because what I'm seeing on these options, number 2 and 3, would entail additional discussions with Marcia and the YMCA. Is that something that you need now to enter into those discussions to find out what the options are? Because if the YMCA says 2 is not an option, I'd like to know that sooner rather than later. But yet, number 3, it sounded like we may not be able to meet the mid-18 deadline for the development plan and would have to start negotiations to extend that deadline as well. So I come back to when.
We're committed to meeting as soon as we get some direction. I believe, Marcia, jump in here, that the YMCA has expressed at least a preliminary willingness to push that date out. And I said a year.
Not to put you on the spot.
We'll go have beers in Issaquah at the Arena Sports facility. So if you would like us to work with the Y to talk about adjusting that timeline, Angie and I would commit to doing that during the holiday break and reporting back as early as January 3rd, provided that the lease agreement is a legal document binding between yourself and the executive board of the Y, so we would have to formalize it, but I think we could get to intent. The passive recreational use is going to take a little bit longer. That is definitely not what the Y envisioned based on this lease agreement. Would you like to comment? Did anything I say make you want to?
No,
okay.
No, never. No, the reason that the Y purchased the property was to build a facility. And obviously, as we've developed our relationship over the last 5 years, that we have a partnership, and you have an amazing community center that is doing phenomenal programming and phenomenal work. The Y is not in the business to own property and to see it not do anything. So the intent of the agreement was really to say, okay, we understand that this property is important to all parties, and we want to see the community, we want to see kids, we want to see families, we want to see adults, we want to see seniors actively engaged in some sort of recreational type programming. And so the intent is really to have real active, an active building where people could recreate, whether it would be a indoor soccer arena or lacrosse or, you know, basketball or something else. It really had no, that we didn't care about that. We just want a facility that is going to allow for kids and families to recreate. And so that's really the intent of the facility. From the time period of, you know, putting something together, I think that, we're good friends. We're almost family. So understanding that this is complicated. So let's get it right. It's more important to get it right than to try to push through something. So from the YMCA perspective, we're very willing to sit down and have some conversation and try to negotiate some, our way through this. But the idea of passive recreation, we need to know more about what passive recreation looks like in order for us to say yes. I know that our board of directors likes very active recreational opportunities. So I know if that, hopefully that answers.
It does, but I guess, so you're looking for direction tonight as to where to go next, correct?
Or we can repeat all this in January. No.
Okay.
It's hard, I understand. If you need more time to think through this, that's fair. I also want to honor all the citizens sitting here tonight. I think that are intending to provide some thoughts for you on this property, and we have not heard from them until public comment. We will not hear from them.
Exactly. I'd hope that we would simply ask questions here, then we'll have public comment, and perhaps during council reports we can come to a conclusion, or before council reports.
That helps.
So, Mr. Mayor, we would give guidance during council reports at 1 in the morning?
Yeah.
Okay.
Bob, you have a question?
Yeah, just as quick as I can. First off, thank you to the Y for supporting our community center. It's an excellent addition to our community. And I also thank you very much for your sure, when you said sure a year, because I think that shows the partnership. And I think the intent here, I liked your comment about purposeful use. But there's an other here, and I'm getting to the question because I know that's where you want me to go with this. The parks plan, as they go through this coming year, acquisition is part of that plan, because there's a 5 that's other here, that if we came to a point where our definition of passive recreational was not something that the Y agreed with, or if we doing some of the analysis that the parks is going to be doing on this, we may always come to the point that we could buy the property as well if
That's
we wanted
correct.
to do something else. So it sounds to me like is the parks plan is going to be comprehensive enough that it's going to cover all those areas, I guess is my question.
It is a full plan update, so it runs a gamut from trails to land acquisition to recreational programming, and there's a chapter on facilities, indoor facilities as well. It's a don't fix what's not broken approach. The plan is good, but it needs to be updated. It's been 6 years since we last did the work.
Great. Seeing no more questions, thank you very much, staff, and Marcia, and Don. Good input, and now I think we're ready for public comment, if we have the sheets. Is there any student liaison this evening? They're home studying. Okay, public comment is an opportunity for the public to address the council. 3-minute limit per person, or 5 minutes if representing the official position of a recognized community organization. If you'd like to show a video or PowerPoint, it's got to be submitted by 5 p.m. to the city clerk. Please be aware that council meetings are videotaped and available to the public. And we're ready at 8 o'clock. So if you hear someone say something that's exactly what you were going to say, ditto is okay. Or, yeah, similar. Okay, we'll start with Stacy Bowman, followed by Dia Hare and Maya.
Hi, I'm Stacy Bowman. I live at 2667 230th Avenue Southeast in the Audubon Park development. I'm here to talk about the YMCA and Pine Lake property and the prospective development and use of this property per the agreement with the YMCA. I'm also a member of the group Save Sammamish, founded by Jennifer Kim. She has presented at the council before, so I'm sure you're familiar with her presentation and her concerns regarding this site. My story is I moved to Sammamish 5 years ago. My family moved here because of great schools, quality employment centers, the slower pace of life, and the uncrowded feel. That was in 2011. A lot has changed since then. I don't believe, and I believe a lot of other individuals in Sammamish don't believe, that development has kept pace with the road infrastructure or school space needs. It has not resulted in, or it has resulted in characterless housing developments with little tree retention or natural beauty preserved, and it also has driven out wildlife or degraded the conditions under which the wildlife are trying to survive. That is why I think this YMCA Pine Lake property is important to be discussing in that context of development, because I believe it presents an opportunity for the city government to send a message that they listen to their constituents, it's not all about development, and that you're eager to preserve forested land, undeveloped or limited development spaces for all of us to enjoy. This would be a deliberate action to preserve this Pine Lake YMCA property from land development, and it's an important gesture at a critical time for the city. As I understand it, the city has the option to lease and buy. I think that's been confirmed by the presentation. If we lease, we must come up with a recreational use for the property acceptable to the YMCA agreements and their mission. With buying, the city could do whatever it wanted to with the property, and we've just discovered that the price tag for that would be a lot less than a lot of us were thinking, $1.9 million rather than $7 million. Leasing might be the best option as well. If the YMCA agrees, I believe the most low-impact option of a sheltered trails and signage about the area's history and wildlife would be the best option for the most people to enjoy. If it has to be a more ambitious project, per the YMCA's mandate to build communities where all people, especially the young, are encouraged to develop their fullest potential in spirit, mind, and body, then I think a multi-use development of trails, signage, a youth adventure park, and/or leadership building challenge, similar to Camp Sispis in Randall, if anybody is familiar with that. They have physical obstacle courses, parkour, different things that you can do with groups to build team building, trust, and overcome challenges. It's a very useful program for youth, especially, and for adults. Also, some parking would be necessary. Possibly a tree house would be a good option. We have the gentleman in Falls City who builds tree houses.
Could you sum up, please?
Thank you.
Thank you. That was a quick sum up.
Make sure you all learn.
Dia, followed by Maya.
Supposed to use it with bottles to make the noise?
Hi, my name is Dia Hare. And my name is Maya. We live in Tamarack at 402 209th Avenue Northeast. On this map of Tamarack, the pink spot shows my house where I live. If I turn the map around, the two blue lines look like my legs. It's where the water runoff flows down the hill. My sister and I are going to show you about soil saturation. This is soil along Northeast 4th Street in Tamarack. This is Lake Sammamish. This is rainwater. And this is water from new houses being built. In 1960, some new homes were built. In 1970, more new homes were built. In 1980, more new homes were built. You can see that the soil is soaking up the water. If you turn over the sponge, the soil at the surface is absorbing water and also deeper down. Then in 1990, more new homes were built. Then in 2000, the new millennium, Sammamish was established. There were no drainage problems yet. But many more new homes were built. And as you know, Tamarack has steep slopes. More new homes were built. And more new homes were built. And more new homes were built. Oh, look, it's dripping. And from multiple places. It is saturated. If the drainage is diverted, it's like turning the sponge at an angle. As you can see, the water runoff is focused onto one point, the corner of the sponge. This is what creates the stream flowing in front of our house. It flows constantly 8 months of the year, even when it has not been raining for days. Soil saturation in Tamarack is happening because of all the new homes built. It is the reason we have drainage problems and need a pipe or trunk line built along Northeast 4th Street in Tamarack. I'm in 6th grade and my sister is in 3rd grade. When we ride to school on the bus, we see lots of construction on Inglewood Hill Road. They are getting their drainage problems fixed to protect their area. We have the same problems and need protection too. Please help us by doing a drainage trunk line in Tamarack. In school, I've been learning about the water cycle in science. This experiment is a practical way to help us learn. Something else that we have learned is that water is heavy. Just 1 gallon weighs 8 pounds. So if my sister carries it around for a long time, it hurts her legs. This is happening in Tamarack too. Our ditches just can't take the stress much longer. Building a drainage trunk line for Tamarack, it is like helping my sister so the extra water can be carried without her having to hurt her legs or strain her back. In conclusion, many new homes have been built. The water is flowing. There is too much of it. We need a pipe built now. Thank you.
Hey, very good. Thank you very much. Now, does Gita want to say something? Yes. Mm-hmm. And then Paul Patterson.
Okay, my name is Gita Sahota. I live on 402 209th Avenue Northeast in Tamarack. So I'm the mother of Dee and Maya, right here, my daughters. As you know, I live in Tamarack along the Northeast 4th Street corridor. This is why my daughters have demonstrated the science of soil saturation. I maintain my ditches in my front yard. Even my mom helps keep our ditches clear for us. However, there's too much water, as you've heard, and there's no real place for it to go. It flows in my ditch for days into months, running from October to May. Plus, there's always sediment and fine silts being moved downhill and further downstream. Tamarack owners pay taxes to the county and city. We pay surface water fees and other fees and taxes too. As been shown to council members before, total funds paid by Tamarack to the city is $944,000. This amount can only be used for stormwater and capital improvement projects. The city has known since 2007 and agrees that there is a problem in our area. That's why the Emergency Surface Water Management Ordinance was approved October 18th of this year. Tamarack Drainage Improvements is SW-12 on the CIP list for capital improvement projects. This project can legally be funded 100% and should be fully funded by the city. Doing the project has multiple important public benefits. A significant number of new homes have been built above me. The surface water runoff is excessive from all the new infill development. There's no conveyance between 210th and 208th Avenue. The ditches and culverts have insufficient capacity due to the cumulative effects. There's too much water and nothing we can do about it. And we didn't cause the problem. We residents and owners have done and continue to do all that we can. The problems are getting worse, and we ask the following. 1, resolution of issues needs to be implemented now as soon as possible. Before it gets too late, it might not be able to get fixed. And as a citizen of Sammamish and Tamarack resident, I note that the city has collected $944,000 for us for surface water. I would like to know where this money has gone. The city has sufficient funds to do our project. I hope the city council members will value the time and energy my daughters, other residents, and I have spent to present our drainage situation in Tamarack and the difficulties we face with the situation as the citizens living in Sammamish. Thank you.
Thank you very much. Now, surface water fees, Mr. City Manager, would you like to say something about that?
Do you have a specific question on surface water fees, where they go?
Yeah.
Well, essentially, they go to maintain the whole system. So, for example, the surface water fees that I pay at my house go in my neighborhood, and they also go on to 228th, et cetera. So they're not neighborhood specific as such, but they are part of the collective whole. So for all practical purposes, everybody shares in the, I guess, taking care of the surface water issue throughout the city. That's the general concept of those fees. Just like your property taxes that you pay and other fees, they go to basically the whole city as opposed to taking care of just your particular neighbor. So you do raise a valid point that you do contribute, and in your particular area, you can make the argument that you're not getting the same benefit as those in another area. So we have had that discussion among council and staff, and I believe the issue of spending city resources in a particular private area, that there's a greater public benefit. And so staff is working with council. We'll be coming back to you in the first part of January and actually codify that. So that would help us move this forward.
Great, thank you. Paul Patterson, followed by Denise Darnell.
Mr. Mayor, members of the council, and members of the community, as well as staff. Before I get started, I just wanted to comment that, Kathy, you covered my topic earlier this evening in the signage discussion. I'll try and amplify in a few short sentences. My name is Paul Patterson, and I live at 22412 Northeast 28th Street in Heritage Hills. And I am president of the Rotary Club of Sammamish. And with me, I have Bill Graff in the middle, who is the immediate past president and chairman of our Foundation Board of Trustees. Christina Williams, who is our secretary and president-elect, as well as one of our newer members, Ken Gamblin. What I came here on behalf of the club to ask was to ask if the council could make it possibly consider making changes to the signage ordinances or codes such that we could place signs at all the entrances to the community listing all the organizations such as the service clubs and service organizations. I'm sure you've seen signs like this in some of the surrounding communities as well as all across the United States. The city of Sammamish has grown and matured significantly in the 12 years since its incorporation, and we kind of think that the city would be proud to inform visitors as well as residents as to the service organizations and clubs that are active within the community, and they do a lot of good. Our club would be honored to work with the city as well as the other organizations and clubs to in the concept and design of these requested signs. Thank you.
Good, thank you. Well, you know, we did punt that down to the Planning Commission this evening. So that's a good place where the input can be coming from. Mr. City Manager?
Yes, thank you, Mr. Mayor. Actually, I was just going to say the same thing. I've actually directed the, Community Development Director, Jeff Thomas, to work with the Planning Commission, and as we update the sign code in relationship to the discussion that we had earlier tonight, the different versions of changes we do have to make, that there are necessary changes to consider as it relates to other signage throughout the city. And service organization signage is one of those things that will be looked at. So we would welcome your input to that, as well as any other service organizations like the Kiwanis and other groups that would offer input to that. So we do intend to take that on. So thank you.
Deputy Mayor Valderrama?
And a question for the city manager, just for the clarification of the time frame. It would be good if you shared with them the time frame that we're
We are working, it is on our work plan to take care of that first quarter of next year. So stay tuned, and I'll make sure that we reach out to you as well as the other service organizations for input.
Thank you.
Thank you.
Great. Thank you, and thank you for everything the Rotary does.
I should point out as an observation, there is now a Sammamish Rotary sign in Tanzania, one in Nicaragua, and one at the community center where they put 100,000 in.
Denise Darnell, followed by Lena Croft.
Hi, my name is Denise Darnell. I live at 2121 200th Avenue Southeast, Sammamish, Washington. I'm talking about the YMCA property this evening. A lot has changed since we made the agreement with the YMCA. Our community, I think you have found, has spoken loud and clear, especially this past year, that we want development to be controlled and we want to keep wild spaces. I encourage the council to do a community survey or virtual town hall to find out from the residents how they feel. I think you will find that the majority will want the YMCA land to stay in its present state. I ask you, what is the city's priority? Is our priority to build fields for the 10% of people that want to have an indoor facility? I also like arena sports, and I have a son that plays soccer, but I don't feel that's the city's priority, because last week I heard you honoring Mary Piggott and her land and how wonderful it is that she has donated it. Do we want the only land left in Sammamish that is wild to be Mary Piggott's land? Or are we as a city ready to have a priority of other land remaining wild? I also heard all of the council members talk about how much they enjoy walking their dogs and being out in the wild of Sammamish. If we feel that way, we need to walk the talk. We need to talk the walk. We need to do both ways. We can't just say that we like the wild, yet then go ahead and build and develop until we have nothing left except Mary Piggott's land. I think you'll find when you do the surveys that the majority of the community agrees with what I'm saying. Recently, the Pine Lake Middle School Science Department did a big essay assignment, and I'm excited to have 2 6th graders here today who are going to speak about it. Their assignment was, how do you feel about the land? What do you think should happen to the land next to Pine Lake Middle School? The question wasn't swayed one way or the other, but the majority of the kids, when they wrote their essay, wrote that they wanted to keep the land wild. even kids who play soccer and love sports, they feel that it's important to keep the trees and to keep the land the way it is. I've presented to the council the stack of 60 some odd essays that Pine Lake Middle School sixth graders wrote, and I know that you're working on reading through them, and I appreciate your time in doing that. Included in that was also a petition by the green team of Pine Lake Middle School and their science teacher, and how they also feel about keeping the land wild. So I think that really is an important point, that the children of your city do not want to keep seeing so much development. They love the trees and nature, and they are also sad when they see all the development happening and the community around them changing. So I just encourage you to be true to what you have said you want to be, which are environmental stewards, and to protect, enhance, and keep the wild of Sammamish. Thank you.
Thank you, Denise. Lena, followed by Deb Sogi.
Hello, Lena Crofts, 22912 Southeast 37th Street, Sammamish, and I'm speaking for the Sammamish Highlands neighborhood that actually backs up the YMCA property. My house is the closest, when the map dips in, my house is the closest on the line. So this has real interest to me and my family. So some of us in my family would like the recreational field because I have a lot of kids. I'm not really here to persuade people. I'm here to talk to the city council as a citizen and to citizens. So the contract between the city and the YMCA was written and signed. It doesn't matter what their wishes are. It doesn't matter what the intent was. Let's just go with the contract. I ask the council to uphold this. There are 4 options according to the contract. 1, to buy it for fair market value, which some estimate can be $1 to $7 million. Then we can build it out or leave it alone. 2, to rent the property from the YMCA and build a recreational facility on it for approximately $15 million. We always know that number goes up. Look at the town center. 3, rent the property from the YMCA and create a trail system with bathrooms and disability accommodations for approximately $2 million with monthly upkeep fees. 4, rent the property for 22 years at $1 a year with the opportunity to extend it another 25 years. Again, this is in the contract. This option only requires that the city come up with a recreational facility plan. That's what the contract states. It does not require that a recreational facility actually be built. It does not matter what the intent was. We should move forward according to the contract and the desires of the city and the citizens and the future for it to be left alone. I propose that the city council choose option 4. If the city doesn't want this, I propose that a nature preserve be built. Don, let's quote Don here. He said that 10% of kids will play half of the year. So 10% of the children, not 10% of people, he said 10% of kids would use this. That's ridiculous to me. Based upon what I've learned from the city council and from attending these meetings and from talking to citizens, money is a big issue for all of us here in the city. We don't want to turn out like Stockton. We want to prepare so we're not like that city. We don't want to be in debt. We are in a heavy growth cycle, and our city needs to be able to absorb the growth whilst trying to stay out of debt. This means that the city should spend its money on much needed infrastructure, my group, such as surface water work for those neighbors who are in danger, trails that are in progress but running low of money, improvements to our road system, specifically 228th, and transportation to Bellevue and Seattle. There's so many other places to spend this money. It's silly to me that we're even discussing this.
Yeah. Could you sum up, please?
I propose that we rent this property for 22 years, then continue to rent it for the next 25, according to the contract. I propose that the City Council act on this right away to put these issues to rest and move on to more immediate and important issues affecting our community. I'd rather take this to a judge and get the citizens' needs met than continue to be friends with the YMCA people. Do not amend the contract with the YMCA. Do not change it, and do not interpret it how you think they want it to be read.
Thank you.
We, the citizens, want to be heard and want this contract to stand.
Thank you very much.
Thank you.
Deb Sogi, followed by Catherine Wyatt.
Good evening, Mayor and Council and City Manager Lyman. We would like to take this opportunity, well, first of all, I need to introduce myself. Deb Sogi, Sammamish Chamber of Commerce, and I'd like to also come up here, introduce our President-elect of the Chamber, Craig Doty, who will take office in January. So we're excited to work together. But most of all, we're here because just like the city has grown and developed, the relationship between business, community, and city has grown and developed. And I owe that to the council because you're very engaged. You come to luncheons and meet business people, you listen, and we really appreciate it. You do ribbon cuttings all the time, right, Don?
Right.
So, and it's going to be more in the future. But particularly, we wanted to take notice of Lyman's abilities and willingness to listen to the business community. It's really changed this year. We've noticed a big increase in the listening that's going on, the interaction between business, and the fact that Lyman will meet with me monthly to discuss different business issues. And it's really given us heart that things have changed a lot. I remember a time back in the 2000s, and I'm sure Don remembers this, when the squeaky wheel, Deb Sogi, kept saying, can't we get a sign on the parkway that says downtown or business district Sammamish up the hill? Because there's businesses up here. There's a McDonald's, there's gas stations. And I remember Don saying, you might remember this, Deb, there's really not a downtown here. And I said, if there's one business, there's a downtown. So, and look at you, you gave a proclamation, Council, on honoring the day, Small Business Saturday, November 26th, and we really appreciate that proclamation. We've all come a long way together, and we just wanted to take a moment to notice that your showcase out there doesn't have a plaque from the Sammamish Chamber at all. And you've been devoted members for a long time, so I think it's about time we presented this plaque to both Lyman and the mayor, if you want to come up here. Yeah, we just wanted to say thank you again, and let's keep engaging with each other. The business community has really noticed the difference. And years ago, we had a U.S. Senior Open, and there was a lot of complaints because there were no shuttles going through Sammamish to notice the businesses. And all the economic benefit was going to Redmond because the shuttles were going around and not coming through Sammamish, even though Sahali Country Club is right here. Well, that changed the last time we had the women's golf tournament. Thank goodness to Lyman. He made sure that shuttles were in Sammamish so businesses could be noticed. So thanks for all your efforts. We just wanted to appreciate you.
Thank you very much. Catherine Wyatt, followed by Jenny Bodell.
Hi, I am Catherine Wyatt, and I back up to the Pine Lake Middle School area that's under discussion. And I wanted to read some things. I am also representing my mom, Deborah Swanson, who was not able to come because she's disabled and she's not feeling well. So our family, I have lived there my entire life. I have grown up with these woods behind me. I have heard coyotes greeting packs when they meet up in the woods. We have the pileated woodpecker, which is an extreme importance, and it's a high risk endangered per the Audubon Society that supports the fish and wildlife. Its habitation is back there. We have seen the nests where they peck away at the trees and they make their homes. I just really, really want this to be preserved and kept the way that it is, the way that I grew up with it, knowing that this gorgeous wildlife corridor is behind, you know, our neighborhood, and coyotes and bears and birds and all kinds of things are back there that it's just critical to them because there's so much development going on. They have nowhere to go. They're just getting shoved everywhere. So if you take this beautiful place that they already know is their home, they're going to be shoved out into other neighborhoods. They're going to have more issues. I've heard that there's an issue with a coyote up in the Issaquah Highlands that is getting aggressive with homes. Those kinds of things are going to become more common because they don't have a home to be in. So it needs to be left alone so they have somewhere to be, you know. Another thing is traffic. Will the city of Sammamish do a traffic study on this area? It is highly congested already with a small entrance and an exit. The city of Sammamish is building a high school and elementary school just short distance down the road on the old Lutheran Bible Institute property. This will unload thousands of vehicles per day on a short area already overwhelmed with traffic. Any more development would just be cramming a building in a small area just adjacent to the Pine Lake Middle School, which shares the road with the Pine Lake Shopping Center and Sunny Hills Elementary. This 1 mile strip on 228th provides travel for an already congested arterial that also allows traffic for several adult care facilities, several neighborhoods, and Providence Point. The entrance to any development would be shared with Pine Lake Middle School parking, pickup and drop-off, and the bus barn. This is an overload for the 228th traffic that would be a disaster area. The traffic congestion is not reasonable to increase. If a recreational area needs to be built, it should be closer to the heart of the city and not at the end of it. The noise will increase for my neighborhood and the surrounding neighborhoods also. I've even heard that there's been word of having the facility open till midnight. I'm not okay with that. You know, seeing the lights through the trees and increase of traffic and people coming and going. Please deeply consider a decision that has the least minimal effect on the environment and the surrounding residents and businesses. There are many more areas in Sammamish that are larger plots that will sustain the growth and prosperity of Sammamish than this uniquely treasured nature wetland.
Thank you, Catherine. Did you give us your address, please?
22916 Southeast 37th Street.
Okay, good. A couple points. We're not building the schools. Issaquah School District's building the schools. And
I understand that, but
Okay.
it's just
And they
something
are
to
in
consider
Issaquah.
that it will be built down the road, and then if you build this facility, you're going to have a large increase.
And the pileated woodpecker is not an endangered species.
It's not endangered, but it is
Not threatened either.
It is on the
It's
threatened
making
list.
noise in my neighborhood.
They're beautiful, but it is on the
They are.
threatened list.
They are indeed. Okay, Jenny Bodell, followed by Athena Burke-Bravo.
That's a pretty name.
Hi, I'm Jenny Bedell. I live 44702 38th Place Southeast. And there's, actually, we're not sure if we're Issaquah or Sammamish, but we know we're kind of part of Klahani, so here I am. I wanted to echo some of the concerns of other community members that have been here tonight and my family. You know, in where I'm at in the grand scheme of things even is I thought that this whole property was part of a protected wildlife corridor. You know, Yellow Lake, Rainbow Lake, Laughing Jacobs Pond, you know, the stream that goes past there and on down to Lake Sammamish. So I'm really surprised that there's been all this communication and contracts and lease agreements for wetlands that I thought was supposed to be protected in the first place. So as a community member, I just wanted to voice my concern with that. I mean, I can't remember which meeting we were at. They were talking about there was, 83 tagged and tracked black bear that use that corridor regularly. So, I mean, clearly building any kind of facility versus, you know, bathrooms or picnic shelters or a giant indoor arena, it's going to have some significant impact on the animals there. So I'm very concerned to hear about any of that. Then the pileated woodpecker is a high-risk species. It may not be on the endangered species list, but it is listed as high risk. So just encourage the council to listen to the concerns of the community. And I agree. I think the majority of people that I've talked to anyway think that another indoor arena is ridiculous and not necessary. So, thank you.
Thank you very much. Athena Burke-Bravo.
Hi, my name is Athena Burke-Bravo, and I am a sixth grader at Pine Lake Middle School. In my science class, we wrote letters to the city council about this topic as an assignment, and I'm going to read mine. Dear Sammamish City Council, hi, my name is Athena Burke-Bravo. I'm in sixth grade, and I go to Pine Lake Middle School. I'm writing to you today about the 7.25 acres of forest south of Pine Lake Middle School. As you may know, this land is home to many plant and animal species. So what would you do if your home was destroyed? Forests are very important to human life. The trees in the forest provide oxygen we need to live. Also, many animal species live in the forest, which provide us with food, like the kokanee salmon, which are endangered. So, if the forests were replaced, the animals shouldn't have a place to live and die. I think this land should not be used for a sports field or a playground, but instead for some bike trails. In a regular forest, you take hikes regardless if there are trails or not. But what about bikes? When people think of strolls or trails, they most likely think of walking. But in Sammamish, there aren't many bike trails. Also, with the sports field or restrooms, there would be encouragement to produce more carbon, which causes global warming. Thank you for reading my letter. I hope you understand my opinion. What do you think? Do you think there should be bike trails? How do you feel about this debate? Sincerely, Athena Burke-Bravo, 6th grade, Pine Lake Middle School.
Thank you very much. Kelsey Bullock.
Hi, my name is Kelsey Bullock. I'm a student at Pine Lake Middle School. I'm here tonight to help save the trees from being cut down to create another sports field in Sammamish. So many trees have already been cut down to make space for many new homes and other buildings. This is taking away the forest habitat that so many animals need to survive, like the kokanee salmon who are endangered. I hope you will consider not clearing this land of the trees. Thank you for your time.
And thank you. Laura Grubb, followed by Dan Young. Is Laura here? Dan Young, followed by Lisa Van Breville.
Hi, Dan Young, 2558 Audubon Park Drive, Southeast in Sammamish. A great conversation tonight. I was enjoying listening about the Planning Commission and speaking about character of our neighborhoods and our community. And boy, that seems to tie right into this YMCA property too. So a couple of things I just wanted to bring up. Talking about our community and the character of our community, I really do encourage the Planning Commission and hopefully the City Council to start moving forward. I feel like we're spinning our wheels here, back and forth, punt, punt, punt. I really like to see the Seahawks score once in a while, so let's get her down the pike. And the reason why is because we're watching the development happen so fast here right now. It is a big growth time, and I think it's better to have the city say to the developers, this is what we want our city to look like. This is what we want our neighborhoods to look like. And we're going to give you some bones to build on, and then the rest is yours. Go for it. But it's critical that I think for our community to say, hey, this is where we live. We want it to be this way. And we like it this way. And here's our structure. The Planning Commission's worked hard. The City Council's worked hard. Now the developers can do their thing and build around that. And then that helps preserve where we live in a way that we want to live in. And, if we get more developments that folks don't like, some of these squished in houses and no trees and things. Really, I enjoy Sammamish because of the forested area, the Pacific Northwest feeling here. And if it keeps looking like that, and the point's already been said, we might as well move to Redmond. So It's, I think, really important that we start making some decisions and start building those bones and start using those tools that they talked about and get it going here soon and have some intent on what we want Sammamish to be like. Thank you.
Thank you very much. Lisa, followed by Wesley Herzog.
My name is Lisa Van Brow. I'm from 14745 245th Avenue, Southeast Issaquah. I'm from the very south end of Issaquah, and I am here representing the Issaquah School District Girls Lacrosse Team. I'm their youth director. I've been with the program now going on 9 years. I have coached 3rd and 4th grade girls from 7 to 9 o'clock at night up at East Lake Community Fields. We use the Skyline Community Fields, and there's not a lot of fields. But because the majority of the kids are situated up here, I travel up here. So I'm stuck in that traffic for a good 45 minutes coming to coach a lot of very young, impressionable girls. There's not a lot of fields. We have girls that play year-round, and we do go down to Auburn. We go down to Redmond. We use Robbinswood Court down there in Bellevue. We use those in the evening time. We have young girls that are out on the fields at nighttime when there's not a lot of lights. We have parents that come and walk around the fields just to make sure that they feel safe because it is very dark. From October to pretty much April, we are needing to use lit fields. So having an opportunity to have an indoor field for these young kids to be able to access would be fantastic. I have a sophomore this year who coaches and helps the youth. She's giving back. She did come up last week and talk about it. She is going to be driving in this traffic. She loves the sport. She goes anywhere she can to go play. The arena field that they were talking about over at Magnuson Park, that's a long haul for a couple of kids to go that don't have a lot of driving experience. So having something on the east side would be great. We, as the Issaquah School District, we did contact Arena Sports in Issaquah. They were full from October to the end of February. The sports get started, and a lot of these kids, it becomes something that they turn around and get back to. Our Super Sticks team, which is a year-round sport, it's another lacrosse program. It's based out of Sammamish. We have kids that come from Auburn, Snoqualmie, Snohomish. Their parents come down. They utilize all of your services here. They use your grocery stores. They enjoy the whole city. We do a lot of Wednesday night farmers markets when we have field practices over at Skyline. I just want to let you know that I think it is an important thing to be able to have an indoor field for people to be able to utilize. I think that it could be situated on your property so that there's still a lot of those trees that are available. When the kids get done, they still hang out. They still participate in what your city has to offer. I'm at the south end, and I'm up here a lot. So thank you very much for your time.
Thank you, Lisa. Wesley, followed by Kathy Bravo.
Hello, my name is Wesley Herzog, and I play for 7-8 Skyline Lacrosse, and I attend Pine Lake Middle School. My address is 4115 205th Avenue, Southeast Sammamish, and I'm here to support an indoor lacrosse and soccer field. The reason we need an indoor lacrosse and soccer field is because when it's pouring down rain on my team, we can hardly practice because it's so cold, therefore wasting a practice, which is wasting time and money. Also, sometimes practice is canceled for it. Thank you.
Thank you very much. Kathy Bravo, followed by Mary Wichter.
Hello, my name is Kathy Bravo, and I live at 22101 Southeast 32nd Street. I've been a resident of Sammamish since before its incorporation, now almost 20 years. I moved here from Miami, Florida, where for the most part, there are very few natural spaces left undeveloped. I once commented to a local that I grew up in concrete, and she became very excited, and I quickly realized that concrete was a city here in Washington. During those first 10 to 12 years, we lived near a small forested parcel off of Inglewood Hill Road. I have fond memories of living near that property. Before children, I used to take walks to that space. I often noticed deer and other animals living there. Teenage kids even built and rebuilt their own BMX-style trails there. Later, as a mom of toddlers, I took my daughters there with other neighborhood moms, and we explored what the kids called the forest and its animals, bugs, and even began doing some of our own basic digging and building. As of 4 years ago, that land was completely gutted. Now that almost 20 years have passed since I've been here, I've seen much of that natural space in Sammamish cut down, and I'm starting to again feel like I'm living in concrete. I understand the drive or even the need for recreational spaces, but at this point, does the city really need another sports field? I've listened to people here today talk about the percentage of kids that will use those fields and the time frame in which they use it. And it seems as though that time is, everyone's kind of lobbying for that same time. And even if we were to build another space here, wouldn't we all be competing for that very coveted same time, and then that lag of time that doesn't need indoor space? Will that facility pretty much go unused? So sports seem to dominate so much of what's happening in our community, but some of your residents have different interests and priorities. And once we clear cut the land, we cannot easily undo or mitigate the damage that's been done. Planting a finite amount of trees or sectioning off or protecting wetlands simply just isn't the same. Thank you.
Thank you, Kathy. Mary Wichter?
Hello, my name's Mary Wichter, and I live at 408 208th Avenue Northeast in Sammamish, and I believe I have a PowerPoint. And a surprise for you, it's not on drainage. So anyway, when the Planning Commission was working tonight, Councilmember Kathy Huckabee had talked about how there's an interaction between regulations and how they impact each other. So I have a very brief visual presentation tonight on neighborhood character. First of all, just noticing the font that I chose, it makes you feel different than if you use Arial or Times New Roman. And then if I just generally look at the shapes of houses, I would say the left block is a 1 or 2 story rambler or split level. The 3-story looks like the houses I see in the Highcroft development. And the 4-story, I wouldn't consider to be a home. It would be more of a tower or multifamily. And as part of the low impact development improvement tonight, if you get enough incentives, they're talking that you could have 15 feet added. So I offer this visualization for you. This is going on 228th down past the Water District. Highcroft is on your left. Right now there's a maximum height of 35 feet. And if you allowed homes, single family homes, to add 15 feet, you would not even be able to see the mountains there. And I think it's really important to preserve the views and neighborhood character, and I don't think we need to go to towers for single family home. I do not have this feeling for town center. I think there should be tall towers there. I think there should be multifamily here. I just think we have to be really careful about extending a 15-foot height requirement, which would go to 50 feet. And then for the sign ordinance, there's some really big fish that are on I-90 that you see attached there. I'd like to be able to have things like this, no matter how large they are in our city. These utility boxes, this is down by Value Village in Issaquah. It's kind of abstract, but I think it's a cool thing, and it looks a lot better than the utility box there, and you can see the other signs around. Issaquah is presenting mountains recently, and this one is actually an artwork. You can see it signed by the author there, and it actually covers the front and the back. And if you know art, it even reminds you a little bit of Starry Night from Van Gogh. And then I would really like to have murals in our town. This happens to be the Dairy Gold building down in Issaquah. I know Leavenworth is a Bavarian village, and they have an entire street of Bavarian things, and that's huge. That's a huge sign. These are other signs. So the cow actually looks real there, but I think you can have some very fine, large format art. And then you can even do history. So I think the mural actually in the Dairygold building is to honor the history of where it came from. So that's just my feedback is as you go through the sign ordinance, please make sure that there's art. And I would love if the commission, anytime somebody does a development, why don't developers have to put some sort of art in their neighborhood? That would just be a feedback that I had. So thank you for listening to my presentation. That was it.
Thank you, Mary. Is there anybody else that would like to address the council? Please.
I'm Laura Grobe, and I've been here about 20 years in the community. I'm at 118 211th Place Northeast in the Tamarack neighborhood. I was hoping my husband would come tonight and talk about this tree we need to have down in our yard. Behind us, we have Morningside going in and the other neighborhood that's further ahead of it, which is escaping my thoughts right now. But big development right behind us. So the forest that was behind us is totally gone. It was just pasture land for years. So all those trees came down, and we have one tree in our front yard that ever since we moved in, the arborists have told us that needs to come down. And it is leaning precariously over my bedroom window. And we took photos of it, and my husband went through everything, came to City Hall and found out what we need, you know, and what the permit's going to be to get the tree down and all. And anyway, to make a long story short, my husband knows the details. He said, we're just going to have to wait for the next storm to take it down and then make an insurance claim for the damage. The only thing that's holding it up right now, I think, is the macadam in our driveway. It's diseased, and it's sapping, it's bleeding. The woodpeckers are going after it.
Pilated?
And I took my hearing aids out when I went home to change, you know, so I didn't hear my name called earlier. But anyway, it's just this one tree we need to have down, and it's not in a spot where we could replace it with another significant tree of any size. You know, we do have a septic field. And so I'm hoping before it lands on my head in the middle of a storm that we could get that tree down without having to pay a huge permit. And that's all I want to say.
Mr. City Manager.
Thank you. I'd be very happy to chat with you about your tree. I'd be happy to chat with you about your tree. So if we could maybe take a moment at the end or between this this section.
Good. Thank you very much. Is there anybody else that would like to address the council? Nope. Seeing nobody, public comment is closed. Okay, we'll take a 5-minute break. Okay. So back in session. The next is the consent calendar, which has been modified by removal of item 2 and item 5, but it includes a whole lot of contracts, which I won't go over. And item 41, which is a resolution 2016-710, final acceptance of Eastlake High School turf replacement project. And item 42, the ordinance authorizing the city manager to accept certain routine real property conveyances on behalf of the city, providing for severability and establishing an effective date. That's ordinance 2016-427. Do I have a motion to approve the consent?
Second. So moved.
Sorry. Moved and second.
Twice.
All in favor, say aye.
Aye.
Opposed? By your vote of 7-0, the consent agenda is approved. And now we go to public hearings. We have ordinance 44, second reading, related to surface water management, amending Title 13 of the Sammamish Municipal Code, adopting the 2016 King County Surface Water Design Manual and the Sammamish Addendum thereto. Mr. City Manager?
Thank you, Mr. Mayor. At this point, I'd like to turn things over to Chief Leszewski, and he can walk us through our plan for this evening on these two items.
Thank you. Good evening, Mayor, Council, staff, and citizens. Steve Leszewski, Public Works Director. So the Public Works Department has the first two continuation hearings, Surface Water Design Manual and Low Impact Development Code. We did have a robust amount of electronic submittals over the week, so I think we would like to have Cheryl Paston, Tony Dalzell, and Wayne, one of our consultants, Carlson with AHBL, just maybe briefly go over some of those to help clarify, maybe bring some light to some of those comments, and then certainly open the hearing and then go from there. So with that said, I'll give you staff. Thank you.
Alita, will you? Yes. Good evening, Council. So, as my director has indicated, we did receive a number of public comments in the last couple of days on both the Surface Water Design Manual and the Low Impact Development Code revisions. In an effort to consolidate and try to clarify many of those comments, I met with Mary Wichter, one of our most steadfast public commenters that we have in the city, to try to come to some understanding on those comments. Based on that effort, we have made some changes to the exhibits in the proposed ordinances, some small changes that I'd like to go over with you at this time. So the first change is to modify the landslide hazard drainage area map that is included in the last few pages of the Sammamish addendum, which is your Exhibit 1 of the Surface Water Design Manual Ordinance. So we have had this landslide hazard drainage area map for the public hearings, and we've discussed drainage review being a requirement for when development proposes 500 square feet or greater of new impervious surface. One of the things that Ms. Wichter has asked that staff do to clarify is to show a landslide hazard drainage area within the Tamarack area. And so we've added what we've seen in hatch here to indicate that this area is designated as a landslide hazard drainage area. And I've provided some maps to you prior to this presentation, 4 maps that should be part of your packet. The first, and they're in no order, one map should have the flow control basins, another map should have water quality, a third map should have erosion hazard areas, and a fourth map should have this landslide hazard drainage area. And what I provided in that fourth map is the small revision that we've made in the Tamarack area.
I have 3 maps, but I don't have the erosion hazard, but that's okay.
I have 4.
We can provide those to you.
I think that's the same one, isn't it? One of those is a double map.
We're okay? Okay.
Yeah.
So we made that small change, and I do want to add that these maps are illustrative. When we do any kind of review for development sites, we do it on a site-specific basis. So whether or not these areas are indicative of the site conditions on a new development, that needs to be field verified with a professional and then reviewed by staff.
What was that hatched area you showed on that map a second ago?
Sure. That is the Tamarack area upslope of a landslide hazard area.
Okay, it's just the upslope, but it's not on the map that we're adopting as part of it.
It is now part of the map that
That's not the one you gave us.
It is now part of what I've provided to you.
It doesn't have the hash mark, but
It's on there.
Right, it does not have hash
Okay.
marks.
It will soon be hash. Yes.
The second area that we help to more clearly define is this definition of critical drainage area. So with the definition in SMC 21A.15 to 55, we've taken out some indication about King County Surface Water Management Department, and we've indicated that it's a citywide standard, and we've added language to clarify that critical drainage areas are areas that include areas that drain to Pine Lake, Beaver Lake, and all these landside hazard drainage areas. This will allow us to provide pre-application meetings for projects within this area.
Question, why is Lake Sammamish not cited, since we're citing two of our major lakes?
Lake Sammamish is one of our lakes. You are correct. Pine Lake and Beaver Lake have special water quality requirements in them for areas that drain to them, because we've, in our previous plans and studies, have shown that these lakes have higher and elevated levels of potential phosphorus.
But Lake Sammamish doesn't have that same quality standard that they're supposed to be maintained?
Lake Sammamish also has a phosphorus standard, but it's to a lesser extent than Pine and Beaver Lake.
Most of the land in the city drains into Lake Sammamish.
That's what I'm saying. That's why I'm curious that it's not. You got the two of the three biggest lakes.
Yeah.
Okay.
And then we added a definition for landslide hazard drainage area consistent with the Surface Water Design Manual. We added it to the SMC. So it means a critical drainage area applied to sites where overland flows pose a significant threat to health and safety because of their close proximity to a landslide hazard area as defined by SMC 21A.15.680. So that is that area in yellow that I showed you in the map. Fourth thing that we did was to include landslide hazard drainage area as a critical area in its definition. And it's found both in the Surface Water Design Manual exhibit, page 15 and 36 and 37. And the last small change that we made was we looked at some additional requirements for critical drainage areas, and in yellow, we added this language. I'll read it. Development proposed in critical drainage areas requiring drainage review will not require, let me start over. Development proposed in critical drainage areas requiring drainage review shall not qualify for any exemptions or exceptions from core and special requirements in the Surface Water Design Manual unless approved by the director. And that was something that we thought was necessary in order for us to do a proper review of these areas that are in between 500 and 2,000 square feet of new impervious surface. We indicated that those areas needed to have a drainage review, and this language allows us to require core requirements if necessary. So we clarified that in the critical drainage area language. Those are kind of the summary of things that I discussed with Ms. Wichter and things that we felt were necessary to help improve and clarify the proposals that we've made for both the Surface Water Design Manual Ordinance and the Low Impact Development Ordinance.
And I will point out that we will correct the spelling error on the previous slide under manual.
And then Tanya, one quick question for you to answer, maybe for the council. The Low Impact Development Code maybe not being restrictive enough. Another comment that did come in. Was it later today?
Sure. We received two emails from some residents, and they indicated that they thought that the incentive-based low-impact development code that we had proposed in 21A.85 allowed too much flexibility, that low-impact development should be required within the city, in their opinion. I think that they had not been made aware that the Surface Water Design Manual actually does impose minimum requirements for low-impact development, that all new impervious and replaced surfaces need to address feasibility of using low-impact development. So I think they were just not clear on the Surface Water Design Manual requirements.
Councilmember Odell has a question.
So, Tony, given that, do you think we've answered their concerns or only partially?
I think we've answered their concerns. They gave specific examples about wanting to see rain gardens on single-family homes, and the new Surface Water Design Manual, if we adopt it, would require that be assessed for feasibility. And if it's feasible, then they would have to put a rain garden, bioretention, or another type of low-impact development, a best management practice on their property. I think it has been addressed.
Okay, second question, the 3 other maps that were handed out, were there any changes on those, or are they
were not.
Simply missing?
There were not any changes.
Okay, these are just missing pages, okay. Thank you.
Councilmember Huckabee.
Yes, I was reading through Bill's comments here, and there were some interesting comments, and they're former residents in the city. They're no longer residents. I think you know that.
Right.
It seems to be implying that we should require LID everywhere. And as we learned, the site over at where the YMCA property is not amenable to LID because it is not permeable. And my understanding is that many areas in the city are not permeable. But some of the comments they've made, I'd be interested in your response and how we incorporate that or not in our development. Because, for example, in item 13 on Gales, she talks about the fact that obviously in construction, the soil is compacted, and here it talks about that all soils need to be dug up, deeply tilled, and amended with a deep layer of topsoil, compost, and sand. Only then can plants thrive and rainwater find its way deeper into the soils. Is that something worthy of consideration, of including in our codes? I happen to have a lot of sympathy for this because our soils were so heavily compacted when we went to do some planting. We had to get an electric post hole driller in order to even make the holes to put the plants in, which we promptly drowned because there wasn't enough till and things around it. But we didn't understand that at the time. But is there, that seems to be...
Yeah, actually, there is a language in the Surface Water Design Manual that requires 8 inches of compostable soil to be placed on top of any landscaped area in a new development. We previously had that as a requirement in the 2009 Sammamish Addendum. We took it out of our 2016 Sammamish Addendum because it was now included in the 2016 Surface Water Design Manual, so we didn't need to add it in the addendum. So it is required per our adoption.
She's talking about deeply tilling and then adding and amending the soil as opposed to putting it on the top. So what you're speaking of, is that comparable to what she's speaking of? Because that strikes me as a bit of a difference. If you even if you're putting it on top, once the roots hit that heavily compacted soil, they're not going to go very far, and they're probably not going to survive at that depth.
Yeah, actually, when we do infiltration sites, so not landscape areas, but infiltration sites, we scarify that soil before we put landscaping around a rain garden. It's not in the Surface Water Design Manual, it's not in the addendum, and it's something that we could, if the council so chooses, to add to the requirements for scarifying 6 to 12 inches of the existing ground before compost is mixed it in. was my feedback. I'm not sure.
Yeah, I believe it's already in there.
Okay.
Yeah.
So let us do this, if the council so chooses. We'll look up some of the code and take a look to see if there is existing language in there. My consultant has indicated that he thinks that there is language in the Surface Water Design Manual that requires that mixing and scarifying of the compost with the existing soils. So let us look at that, and if it's not in there and we want to revise it so that it's in there, just indicate so, and we will do that before it takes effect.
Okay. And item number 14 was also very interesting in that to limit the distance that the water is flowing, and I'm assuming that is similar to what we've been hearing from Mary Wichter at Tamarack, because you don't want the water flowing down the street, picking up all the copper and the other things, the other chemicals that may be out the street, and then carrying that into whatever ditches or other places where the water is being captured downstream.
Let's see. So in the addendum, we have language on Exhibit 1, page 26, that talks about the maximum pipe run between structures of 300 feet. So you can't place a catch basin more than 300 feet apart. Mainly, I would assume that is for ensuring that that catch basin has enough capacity to collect the stormwater from that 300 feet. But I think that might address that kind of maximum impervious surface that she's speaking to. You guys have any?
I think it might in some circumstances and not in others, where you have hilly communities. The water is running down quite a distance just down the driveway, picking up a lot of chemicals and other things that you may not want that to have, and then probably running down the street after that before it actually hits a place where it's actually encountering soil.
So water quality treatment is a requirement of all pollution generating impervious surfaces in the city. So whether or not it travels 100 feet or 300 feet, it's going to go to a water quality treatment facility to capture those metals or those sediment pollutants before it hits any of our receiving water bodies. When we're talking about dispersion is a low-impact development best management practice. We saw it in the lower commons, and those have minimum requirements once it passes that dispersion trench to filter out before it hits a wetland or a other water body.
I remember seeing those.
Yeah, so there are minimum flow path, they call it vegetated flow path requirements for that kind of discharge.
Thank you.
Councilmember
You always
O'Donnell,
ask the tough questions, Kathy.
do you have another question? Okay.
Well, not a question so much as a concern. Looking at the time stamps on these two communications plus Mary Wichter's, they were sent after I had left home for the duration of the day this afternoon. And frankly, I haven't had time to digest any of this stuff.
I'm just looking at it now, too.
Yeah. And I think I would be more comfortable if we gave ourselves time to really study this stuff and perhaps have further dialogue with staff. Is there any harm in deferring this until the first meeting of next year?
Technically,
Well,
Yes.
yes.
yeah.
We've been put on notice by the
Puget Sound
Keepers
Yes.
that we would be in violation of our MPDES permit on January 1st if we did not adopt the new manual, as well as the Low Impact Development Code and your surface water comprehensive and surface water storm and comprehensive plan. I said it backwards, but nonetheless, which we previously adopted.
Okay.
And again, these are fluid documents that can be amended as we go, but I think it is important to keep this on track. Not that we haven't had as little time as you have to review these, but we have looked at them, and the code is very comprehensive. The stormwater manual is very comprehensive. The addendum has further...
This is a small piece, but I get that.
Yeah, yes, I agree. But so there is side effects. There is other additional paperwork we have to actually fill out and submit if we are not in compliance to the feds. So there's more work to be
can we
had.
pass this thing knowing there's some warts in it, and then come back and fix it in the first quarter of next year?
I don't know. I mean, we can certainly do a deeper dive into some of the comments, but we have given them a review, and I think as we've answered some of the questions Kathy's brought up, Councilmember Huckabee's on the behalf of these submitted comments, I think things will be mitigated through the process in the manual itself, as well as the addendum. I think we can certainly do a little digging while we have the hearing and then come back for discussion. But I think most of those things are covered. I think scarifying is required already in the manual as a base, plus the emitted soil on top. Those things are there. Catch basin spacing, there's more that goes into that too, the technical information reports where you have velocities and other things that are considered. So, the manual is a good manual. Surface water addendum that staff has provided, through all the processes adds more protections. So, I'm confident in that.
I would propose we have the hearing, decide if it's good enough,
Yeah.
and then take these comments. This has been in place for a while. To get these last-minute comments is kind of last second.
Yeah.
But we can certainly consider them going forward if we adopt the manual tonight.
Well, I'm going to suggest we adopt the manual based on what...
No, you forgot to push
you just said.
forgot to push your button.
Sorry.
The question is, we still have some questions that I brought up and Christy brought up. Should we have the hearing first, would you suggest?
I'd say so.
Okay, we'll have the hearing first. Okay. This is the continuation of the public hearing on the 2016 Surface Water Design Manual and Sammamish Addendum Update. Do we have people signed up? Okay. George Weyerhaeuser. Oh, no, Mary Wichter.
So I'm passing out to council the 13.20.040 critical drainage and/or critical erosion areas that Tawny has updated, but this is what is currently since 2011
Just give me the whole bunch, we'll pass them down.
So my name's Mary Wichter. I live at 408 208th Avenue Northeast in Sammamish, also known this week as the lady in the newspaper again. I wanted to thank Lyman Howard had asked to meet with me, and I met with him today. Tawny had asked to meet with me, and I met with her yesterday, and I feel we made good progress. While you received a lot of input, which you consider at last minute, I've been working on these issues since last August. One of them was the docket thing with some of the maps. I will say that the map here, which is the erosion hazard, I have no problems with the map except for the color. The color actually conflicts with some of the stuff on King County IMAP. So I would like to see the erosion hazard area instead of the slashes this way, or straight across, probably in black or red. I think that's easy to do. I had sent this afternoon something called essential edits, and I would like them to be done. I would ask that you not adopt without agreeing to what Tawny has presented, because it meshes with what we agreed when we talked, and I think it covers what you need. First of all, the greater...
Talk a little slower and repeat what you just said, because
Okay.
it just went so quickly.
You're almost at a mumble, Mary.
Okay, sorry. I would like what Tawny has shown is what we agreed to when I met with her. I have been working on these type of ideas since last September, October through the Planning Commission as well as here. I'm excited that they are able to be incorporated. I would suggest that if you are going to go forward with adopting tonight, which I think is fine, that you make the changes. Do not adopt without making the changes. And then if you don't like the changes, that's one of the things that I talked with about Lyman, is kind of putting this on a steady thing. So just to let you know, so the essentials edits that I emailed this afternoon, because I had to meet with Lyman and send it in as soon as possible, I do believe that the greater than or equal 500 square foot threshold to invoke drainage review is appropriate for landslide, landslide hazard drainage areas, and any drains to areas, which is the yellow and gold map, landslide hazard area map that Tawny has already updated for you. I do understand that the ordinance for Tamarack would be repealed as of December 31st, which I think is okay. If you wanted to keep it around, you could, but I think it's okay. And also, the ordinance covers new, replaced, and new plus replaced. The code, the way it's done, is just new, which is what Tawny had been working on the whole time. For Lyman, I had said, because you didn't do a moratorium and you did the ordinance and you're making changes, I think it makes sense to have a staff work item for 2017 to allow you to research landslide and steep slope areas, because I've noted that those words are missing in most of the documents that have been put through. For one thing, like the Inglewood map for attachment B should just be labeled in Inglewood. It's very confusing, and I had been talking with Jeff Weems about that, and they would also like to have their things looked into, which I believe you're going to put on your work plan anyway. Anyway, this would allow you to watch how the Tamarack area might be affected under the new codes and additions, and then the city should continue doing this ongoing research and evaluate the effectiveness of your requirements, because landslide and erosion overlap so much. Maybe some of those codes make sense, and you guys studied erosion a lot in the past. I also think some of the GIS work being done by King County, they're doing a lot with landslides. I believe it's due to the new surface water design manual changes. They're doing a lot of mapping. I believe some GIS would work, and you can actually hire them out as a service or consultant if you would like that, I've learned. Tawny did make the change to include landslide hazard as a critical drainage area. One of the reasons that's important is you can't say you want a drainage review, do the Core 9 requirements, and then change all the code to limit the 500 square feet. So putting it as a critical drainage area gives you the flexibility to require what you need for what type of parcels. Some parcels are below a landslide hazard area, some parcels are above, and it gives the Director of Public Works the flexibility to do that in the code to invoke and use. The final thing is I have just a few small updates that could get in. I think there's no reason not to take them. I don't have time to go over them here, but I don't see any reason if you make a motion to adopt that you can't make the wording wide enough to say that with the public input that you've got for the simple changes that could be done, that they could be put in. Like I want permanent as well as temporary erosion controls. I also think that you shouldn't interact with the stormwater because King County Surface Manual says not to do that, so people should not be swimming and wading or feeding the waterfowl in these. I'm a little bit worried about reduction of the size of the lid facilities, which I can talk about during lid. There's a word non-impervious. You should be using pervious. And the simplified drainage review, it looks like just a few of the changes were missed. So I think those are things that could be updated by staff before it would become effective. So that's my input, and you'll see me later on the other items. Thank you.
Okay, thank you, Mary. Anybody else that would like to address the council? No? Then the public hearing is closed. And I appreciate the comment about non-impervious. That was one of my comments, too. It's under pollution generating pervious surface. It states pollution generating pervious surface means a non-impervious surface considered to be a significant source of pollutants. Now, why would you use non-impervious instead of pervious when you're talking about pervious surface? That's in 13.10.540, Exhibit 1, page 54. But it's just a minor thing, but it's ridiculous. And my phone doesn't have it in the dictionary. So what you're saying is that it's in the King County Surface Water Design Manual.
It's not only in ours. It's sort of so that's one of those
Okay. Okay.
Okay, thank you.
Good. I looked at the other comments to my input, and one of them, I asked about definitions. We have in 1310-300, a project is subject to simplified drainage review, targeted drainage review, direct drainage review, or large project drainage review. 3 of those are defined, but direct drainage review is not defined, and you tell me that there's a table someplace, but I didn't see it defined in our list of definitions. What is direct drainage review as compared with simplified or targeted? It boggles my mind.
Sure. It's a new drainage review that is in the Surface Water Design Manual. It is defined in the Surface Water Design Manual, which is why it's not in the Sammamish Addendum, it's not in the SMC, it's in the Surface Water Design Manual, and there's a flow chart that is very similar to other flow charts that have been in previous manuals on how to figure out what type of drainage review you need for your development. It's very technical in nature, but the high level kind of description of a directed drainage review is it's more than a simplified review, and it's less than a full drainage review. It really allows a developer or homeowner to come into the city and ask us, what requirements do I actually need for my development? And it allows the city to help guide them on the core requirements or special requirements that they will need to address.
So what you're saying, it isn't that big a deal? A half an hour or an hour more of staff time? I'm just curious how much the bill builds up for a poor homeowner that's trying to get something done.
Yeah, there's definitely going to be more staff time, more requirements to the submittal documents that a developer or a homeowner needs to submit. So for example, they need to submit more of a geotechnical report and analysis to determine whether or not they can infiltrate on their site. So there's going to be definitely some more work that will be needed to assess feasibility of low-impact development. And the half an hour additional for simplified drainage review, that may be the case. If it's more difficult, it may be more. We just don't have yet the numbers to share with you right now.
Okay. So one other question I had was on replaced impervious surface. And the question I have is a gravel driveway impervious?
It is impervious.
So if
And
you
if-
want to pave a gravel driveway, it's called replacing impervious surface, right?
Actually, it would be, the way that the manual describes it, it would be new impervious surface.
Right.
Yeah.
Which doesn't make sense, does it? If it's originally
But it
impervious.
actually hasn't changed since the 2009, or actually even going back to the 1998. When you pave a gravel driveway, that is subject to drainage review. It's a new impervious surface. It's got to provide, if you meet the threshold, you have to provide flow control or water quality treatment. And with new core requirement number 9, you would be subject to a low impact development thresholds for looking at feasibility there. So it hasn't changed since the 1998, and we actually don't have an option to change it if we want to be consistent with our permit requirements.
Yeah. See, because common sense, for example, in Pine Lake, there's some long, narrow lots. I brought these up before. And if you have a gravel driveway going all the way down, and historically it's been there, the water flows off the side and infiltrates. Now you want to pave it, and you can't, because you've increased the impervious surface beyond the threshold.
Nothing is impossible. So when you say you can't, that means that you don't have the resources to pave it. So it would be subject to drainage review like other projects within the city, and you would look at options for either flow control or low-impact development if you could disperse it to a vegetated area and provide some water quality treatment if you met the thresholds there.
So it is possible. Okay. Well, you've answered most of my questions. Christy, how about you? Did you get yours answered?
I think they provided a graphic, but it was more specific to LID specifically, not the
Okay.
design manual.
Deputy Mayor Valderrama? No.
Nope. This time I'm quiet.
Can we get a summary of what we've talked about tonight that's changing from what's in what we have here?
The summary was the presentation that I had, what's changing in what we
map.
have.
And that's the
Yeah.
only changes?
That's the only changes.
None of the comments that Ms. Wichter talked about with the language changes are in this?
They're not in your handout, they were in the presentation
no.
under strike and delete format on the screen.
Those languages, but none of the stuff that was in public hearing. I thought those were
I believe Ms.
additional.
Wichter summarized that she was 100% behind the summarized changes that Tawny had shown
I thought there
earlier
were some
today.
other changes she was looking for. Okay.
I think she's still saying there's grammar and a couple of other
That's what I
edits,
wanted to
but
better understand. Okay, yeah, okay.
We can certainly comb for Scrivener's errors.
Got it.
I do want to actually touch on the pollution generating pervious surface definition. So it does define it in the surface water design manual, and it says it means a non-impervious surface considered to be a significant source of pollutants. So
Does it have a hyphen in it? Non-hyphen impervious?
yeah, it does. And I think the reason is because people don't like to use the pervious when you're trying to define pervious surface.
So you make it a non-impervious.
So-
Oh, boy. Okay, but with the hyphen, maybe I'd find it in the dictionary. So I think we're ready. I don't see any more questions. We're ready for a motion, which would include Tawny's amendment.
Propose amendments to the exhibits to the ordinance on the surface water design manual.
Okay, well said. Do I have a motion to that effect?
So moved.
Wait, Bob has a comment.
Oh,
I just want to make a quick comment that Mary had put in on her changes. Mary wants, she mentioned the photo, taking a photo, requiring a photo. And this really struck me when I was going through this, because when we were having problems with people cutting trees down, we had no record of the trees that were being cut down, that they were supposed to be saved, and one of the neighbors was claiming that the trees were being cut, and there was really no record. I'd mentioned to Ben, our city manager at that time, it's pretty much a common procedure now that people can take photographs and put it into the process. And while I don't know that we need to put it into the wording here, just as a process with the city, could we start taking some photographic records of these things when they're done so that we can refer back to them later? Is that something we could at least start looking at? Because I think there's more than an application than just this. In stormwater, there's an application, as I brought up originally, that trees, when we label trees that are supposed to be protected or cut down, we could take a photograph of them at that time so that we have a record that we can go back to. So that was just a comment that I'd like to make.
A quick note of caution, if I will. We have a clerk and an attorney here. Depending on what photo is taken when and what it is associated with, I don't want it expected that it's going to be here forever, because some files can go away in a year, 3 years, 7 years, or never. So I just don't want to,
If you could
be
just look
clear
at it. Just
if
look
you'd
at
like. Okay. Records retention is quite a challenge in following all the steps. So.
okay, Councilmember Hornish?
I move that we adopt the ordinance as drafted that amends Title 13 of the Sammamish Municipal Code, adopts the King County Surface Water Design Manual and Sammamish Addendum, provides for severability, and establishes an effective date with one addition, as was discussed and revised here tonight, and would continue to be looked at early in the year for additional comments that we did not have time with to consider the lid impacts to the manual.
I'll second that.
And there may be none. It might be more on the lid adoption, but just in case.
Okay, any further discussion? All in favor, say aye.
Aye.
Aye. Opposed? By your vote of 7-0, it is approved. Thank you, Steve.
Don,
Yes?
I'd like to direct the city manager to have staff come back to us by a date certain on this particular issue.
Okay.
Like, say, the end of April, no later than.
Okay, the next one, Bill number 45, the Low Impact Development Code updates. Mr. City Manager?
Well, I think we've got the same situation here. We need to open and close the public hearing. Staff is here to discuss any updates that or questions you might have, but I believe the presentation covered this material.
Okay, then we'll open the public hearing again. Public hearing is open. This is for the Low Impact Development Code updates. Is anybody going to address the council on this?
That's Mary's nodding her head, yes.
It's empty?
Just one.
We guess?
This George Weyerhaeuser again?
I believe in trees, but I'm not related to George Weyerhaeuser. Sorry. My name is Mary Wichter. I live at 408 208th Avenue Northeast in Sammamish, and this is my public hearing input for low impact development. I had also emailed this in to you and said that I know that you're supposed to remove barriers to adopting LID, but I really think you need to concern that you're going to put it more places than there are people. So I would like to see like a 1-year warranty surety bond added like Bellevue does for restoration to improve, to make sure that things are rechecked and inspected. And this should include landscaping, because if you do it and then your landscaping doesn't survive for a year, kind of your lid isn't going to work. So since Bellevue does it, I think it's a simple thing to add, and it just gives a way to move forward. And you can also put an inspection in there that you can have people prepay. I had given other inputs and other materials online. I did talk again about taking the photo to document prior to site clearing and any disturbances, so you'll know where your native soils and plants are, that maybe an inspection is advisable too, that you should do the 1-year warranty. In attachment D, there's one word or a series of words that says that you can be interacted with stormwater for ponds. I would like interacted with deleted or clarified, that people and dogs should not be swimming, wading, or feeding waterfowl, because it's in direct conflict with King County. What King County does is they make those requirements and they have signage. We're not using that signage, but these ponds that are being created, they're not recreational ponds, they're stormwater ponds and do have pollutants in them. In attachment E, for standards in landscaping, landscaping should not hinder the operation of the facility. You should add wildlife corridors wherever you can, just not trails. I'm a little bit concerned about using parking lots all the time with pervious pavement for the water quality going in. I'm worried about if you get enough lid incentives that you could increase the height of the building 15 feet, particularly for single-family homes. I think that's also a seismic concern. I think in town center they could put earthquake braking in. I do understand that maintenance plan for lid is going to be required, but I think it also needs to be recorded with the county, so it's not a city record-keeping thing. If there's something that goes with the land, it should be recorded with the title, so people have to take care of it. I think lid should not be used on or near utilities, and I had sent you some Bellevue maps and some bullet points in the text box that said it shouldn't be near utilities, construction lines, that sort of thing. I think a list outside of this should be given for users. There's some small errors, like the bikes, pathways, trails should be known as a non-motorized plan as well as that, because they changed the name. So anyway, again, I think you're pretty close here. I think there's some small changes. If you could, if you're willing to adopt, if you would like to do so and just say that, small changes or submitted things from public hearings could be added, I think that would be useful. And I did send in my input, I believe, for this on Sunday.
Okay, thank you.
Thank you.
I have a question. Where does that talk about raising it 15 feet to 50 feet outside?
It's one of the lid incentive things. It's, hang on, I'll look it up.
I missed that one.
It's attachment G, page 34 of 67, if you have the labeled version. And it says technique points and incentives for building height incentive. And I put that 15 feet's like a whole story with a high ceiling on a house. I think that's fine in town center, but I
trying
don't
to
think
find-
it's fine for single
G?
family. G like George Warehouser.
Yeah, got it. Okay,
Page 34
attachment
of
G, and then what?
I have page 34 of 67, and it's items 3 through 4, talking about the technique points and incentives for building height.
We don't have any page numbers, so
Yeah, I was in the prior, I don't print out 800 pages every week,
No,
so
no,
I
what-
went with the prior.
what is the section?
What's the section number, because there are no pages here?
I did not.
040, LID incentives.
21, somebody. 21.885. 885. 21A.85.
You said 040?
040.
Oh,
There it
lid
is.
incentives?
Yes.
Okay.
So it's numbers 3 and 4, technique points and incentives. And they say, hey, if you get enough, you should just be able to put 15 more feet.
3 is restoration of critical area buffers. That's the incentives. And 4,
3 and 4 are struck out on mine.
okay, but where does it say about the height limit? The 50 feet, I don't see that. Yeah. Can staff help me?
I see 030.
This is it.
Yes. Oh, they got it. Thank you. Number 4.
The maximum building height up to 15 feet. This building height incentive was not changed since the 2009 update to the the SMC 21A.85.
So you could raise the height limit to 50 feet then?
15.
Well, 15 more to 35 is 50, which is basically 5 stories if you have a flat roof, huh?
Is it 5 stories? Yes.
Good grief.
Let's not do that.
Flat roof.
I understand she says it was in before, but I also understood nobody ever did the lid because it was too hard, so nobody ever tried to do the 50 feet thing, I would imagine.
Oh. So it's in there, but nobody's ever used it.
Get it out.
Not to my knowledge, nobody's used it.
Well, but now there's the ability to do it if they have 20 technique points, though.
Right.
So it would be worth striking.
I'd rather they go up than out.
Do they get points to do the required lid?
They do not get any incentive points for required low-impact development. This is primarily for low-impact development techniques that we've listed in this chapter.
Above and beyond what's required.
Above and beyond, yeah.
So that's a big difference, actually. I mean, they're going to really have to do some proactive lid techniques to get to this. I mean, it's still there. I don't like it either, but the risk is minimal. Okay.
I actually prefer going up rather than giving them density to go out.
Yeah, but I think this speaks back to the neighborhood character issue. You want
Yeah,
five-story
which seriously
homes.
will.
It does. Yep.
It's getting almost as high as the trees that they removed.
Oh, God.
Point of order, Mr. Mayor. It's 10 o'clock almost.
Remember the guy that came and told us we should live in tree houses?
Yeah. Okay. Well, what does the council think on this? Leave it the way it is?
I'm okay.
I'd take it out.
Does anybody want to make a motion one way or the other?
Well, I want to understand what you mean by taking it out. The whole incentive for 20 points, that whole paragraph?
The option to go to 50 feet.
But
I like this one.
So then what do you substitute if they've got 20 points?
Well, The one just above it's 24 points. So.
Right, that's 24, so what do you get for 20? And then the one below it is 12.
You have to work your way up to 24, I guess.
Yeah.
To go from 12 to 24, if we left out the height.
Could reduce the height.
Well, I don't see any motions right now. Steve, you have a comment?
I wasn't quite sure if it was the height that it maybe was a point of contention, or maybe the allowed habitable stories within a structure. So you may have some latitude on that, i.e. up to 15 additional feet, or so many stories thereof for habitable space, 1, 2, 3, 4, 5. Maybe you could omit a flat roof, but still allow the 15 feet where you would include the pitch.
Yes.
You were kind of stalemate there, so I just offer a couple of items.
I want to live next to it.
Well, okay, I don't.
I moved to-
Councilmember Malchow, you have a comment.
Yeah, no, I just wanted to make a quick comment on this because I think, what we don't know is that we've had LID in place, but it hasn't been used. Now we're requiring it as a bare minimum, but now we're offering some incentives that might actually have developers take the bait on this. And what happens if they get 20 technique points and then we have 5-story houses? We're already hearing about the 3-story houses. What happens when they're 5?
Yeah.
That's truly, I think, a community character issue. And I think this, I don't know how much LID they would have to do in order to acquire 20 points in order to start raising.
So I will add that the conversations that we had with developers in our stakeholder meetings, the building height was not really a discussion. So it alone as an incentive, I don't know that it would be that attractive to them to do the LID. So I guess what I'm saying is if the council so desired to remove that section 4, I think that there are other incentives like the density and the recognition and the others that we listed that probably would encourage them just as much to use the technique points.
I move we strike number 4, the building height incentive.
Yeah.
It's been moved and second. Any further discussion? All those in favor say aye.
Aye.
Opposed?
Nay.
By a vote of 6 to 1, it's struck.
Point of order,
we're in-
John. 10 o'clock.
Do you have a motion to extend?
Move to 11:30. Afraid that might be too short, but.
Right. Coming from you. Have a long report?
We all do. The council reports, we're going to talk about the why.
Second.
Okay.
Aye.
Aye.
All in favor, aye?
Aye.
Okay,
We
opposed?
can always get out early.
That's right.
Okay. Okay, so where are we now?
Well, now that we're in this section, we talked about it, it seems when I'm reading this section, when you look at, for 12 technique points, you can put another monument sign out on your property.
A political sign.
Wait a minute. But also, for those same 12 technique points, 100% of the housing within a proposed residential development may be designated, may be designed to accommodate attached housing consistent with SMA 21A. That's huge. I mean, putting a sign versus having additional housing or attached housing to every home in the property, it just seems like I can't, the equivalency
The points
there.
are skewed. The
The points
skewed.
are absolutely skewed. There seems to be no equivalency there. I mean, you put a sign outside, big deal, it doesn't do anything, but you design it so that you can have attached housing. You've obviously got more density, more impervious surface, and just a variety of other things going on, so that seems to me to be.
That doesn't mean.
It's a little
more housing.
counterintuitive.
It says to accommodate attached housing.
Right, so it is a little counterintuitive when you attach the housing. Usually you do reduce some of the impervious surfaces. Again, I don't know if the development community had any real strong comments or incentives on this.
So attached housing would reduce the amount of impervious surface?
Yeah, just think about, if you have one house versus two, if you stick two together, you at least minimally cut the overhang between houses, right? So you've got a 24-inch soffit on two houses, that's, if it's 50 feet
Why
long,
wouldn't we
that's 100
want-
square feet times two, that's 200 square
If
feet
that's
that
the
now go
case,
together.
why wouldn't we want to encourage it rather
You
than they have
do.
to earn it?
Well, that's
I
a
mean,
question for a development community, but in general, when you do multifamily, it does reduce footprints overall.
Now that I'm understanding, I was assuming it was like ADU housing or something that you could add to it.
No, you know,
But
I don't think,
but-
this is not an increase in density, it is the construction type.
But it seems like that designing it so that you have attached housing would reduce the impervious surface. That would be something that we'd want to promote in any case, as opposed to saying, oh, no, you can't do that unless you get 12 technique points and you have to earn it. So am I misunderstanding?
That's a zoning, that's normally a zoning issue, multifamily versus single-family detached. The attached factor versus detached factor is, it's more of a planning question, but I don't know if you guys have anything to add on that respect.
Well, if you do clustered housing, you can do it attached, can't you?
That's
So
the basis.
That might be something to take up with our setback issues that we're going to talk about, that we sent down, we punted down to the Planning Commission. Okay? You okay with that?
I don't have an answer.
Oh.
Should we, is this something that we should not include as something that has to be earned, but just as an incentive, or am I totally off base here?
So are you proposing to make it a requirement or something that we should just flat out allow if they want it
I would
without
think
any
it
kind
would
of
be an
technique
option-
points?
An option that we should just simply offer as opposed to something they have to earn. Unless there's something I'm missing.
Yeah.
Then we have to change the zoning
Yeah, and
code.
I think that we may want to
It is, actually.
speak to our community development group on that, in the sense of, if you have R1 or R4, which is normally single-family detached, right, but you incentivize some of it to put it attached, I don't know if that overarching, like to just make it mandatory or allowed in a zone is definitely different than incentivizing it.
Okay, well,
in a-
let's pass this tonight, and then let's ask that, because that seems to be more logical than saying you have to earn it.
I think you
And if
can,
you earn it, then you're going to, and they're doing it, then how does that play in with the development code? Or are we somehow changing the development code in that area? Because that seems to be the same objection that you would have just simply by allowing it outright. Or we'd have to make consistent with the development and zoning code. Okay. So is that something that we can take out or should take out because it's not consistent with the development code?
I don't think I'd make a recommendation on that.
I don't know that it's not consistent with the development code. It doesn't allow you to introduce any type of new use, whether it's attached dwelling units or whatnot, that wouldn't be allowed in underlying zoning. It's just talking about the incentive to make 100% of the lots within a development be allowed to accommodate the attached units.
So the zoning code then, if it is allowed to be attached in that zone, it's not superseding the zoning code. So if it's single-family detached and attached is not allowed, that incentive is not applicable.
Okay.
Sorry, that was
Okay.
good. Thank you.
Any other comments or questions? Christie, are you okay?
Yep.
Okay, then
Hold the question.
we haven't made the question yet.
Too late.
You got tricked.
Basically just asked, what, if they're required to use the minimum LID and they don't do anything else, what does it look like? Because we got the graphic that depicted basically no LID used versus one that would gain an additional 3 lots in that 100.
The one with the housing and the tree clusters and that?
And I asked to say, well, you know, if somebody uses the bare minimum, what does it look like? Yes, that one.
Yeah, so I don't have the graphic available to show on the screen, but you have it on your email that we sent out.
Did everyone get that?
Yeah.
You did?
The question, as I understood it, was to show you a depiction of what a development would look like without using any of the incentives in 21A.85 and show you what a development would look like using the minimum required low-impact development techniques in the surface water design manual. So what I did was I showed the 100 lots that you would get under net density without any kind of incentives, and I showed depictions of locations where bioretention or dispersion could or could not be used in a development. And I showed all the trees within the right-of-way as well. Yeah, the ability or inability to use low-impact development best management practices on a development is going to be based on that development, that site-specific geotechnical information, and the layout for it. So it is really difficult to give a depiction of a typical one, but that's kind of what we tried to show you.
Okay, I guess I was hoping to get a tangible example of what it would look like, knowing that if we're implementing a minimum LID, that it's actually serving its purpose. I think Gail kind of alluded to that in her email to us.
Yeah, there are full low-impact development neighborhoods throughout the Puget Sound. High Point in Seattle is a good example of one where they've really implemented low-impact development to its maximum. And they also have a beautiful stormwater pond as well. But they've got bioretention swales in the planter strips. They have pervious pavement in the sidewalks and also in the streets. They have green roofs. They have areas where they disperse the stormwater. If you want, I can share with you some photos of that development. And Wayne has actually worked on several in the Puget Sound as well.
Thanks.
Yeah, they're beautiful. We saw those photos years ago when most of you weren't here.
Right.
Okay.
You want a motion now?
Yes, please.
Just have one other question.
Okay, go ahead.
This is really, it came to my mind when I was reading through Councilmember Malchow's questions. It's on the last page of the document that we were just going over where the graph is. It's saying any open space resulting from lot clustering should be located where existing strands of native vegetation exist, and shall not be altered or disturbed except as specified on recorded documents. And it's the recorded documents that I just have a question for. When we went on the tour, I asked about this. Now that LID is going to be required, the maintenance will be the responsibility of the property owner. Here, it's specifying that it's going to be on the recorded documents, but how can we be assured that a new owner that comes into a property is going to know that they are required to maintain the LID features on their property?
Well, they get a title report, which...
So it's going to be recorded. That's what this is recording. It's going to be on their title document. I just want to make sure. So And all who LID reads that, other than you? requirements will be on that document.
So we've actually talked about that exactly because there are neighborhoods who have low-impact development implemented it on a per-lot basis, and it's effectively they're gone, which is part of the program is to go out and do inspections, which we're doing, and we're finding some of those pitfalls. So we do have a meeting set up to go over how do we overcome that. We talked about adding required kiosks to maybe the neighborhood where, what is low-impact development? What does it mean? Again, putting it on title, which, again, I don't know how many of you have ever read your title, but 9 out of 10 people don't.
Your realtor is supposed to read it.
I understand, but the sad reality is they come to us when we come out there and say, oh, you're supposed to have a rain garden right here. And well, I don't know that. Well, it's on your title. Well, I never read that. So we're still in that place. So we're trying to put it in prominent places where The HOA covenants, it can be copied into that as well, a map with which units have it on them, again, the kiosk in the neighborhood, something to just bring to the forefront in their mind that as a homeowner, there's something else on their site. And we will begin doing those documented inspections at the final plat stage and the home occupancy stage.
We talked about that a little bit when we talked about monitoring, because that's a major concern especially after we went out on the tour, is that somebody's going to buy this property that has no knowledge of a rain garden or what kind of plants to put in there. So how do we ensure as a city that that is ongoing? And I'd heard some chatter that we were going to take ownership of all these. And be
We do not intend to
responsible.
take ownership on private properties.
Okay.
We are required to provide inspection and summarize reports for our permit, but we do want to bring it to the forefront of homeowners' attention.
We had talked
Yeah.
about it under education, and that was going to be a significant portion of that. And there are a lot of homes that are not in HOAs.
Yeah.
So you can't.
Most of the new ones are required
The
to be.
new ones are almost all in HOAs, yeah, but a lot of the older ones are not.
So we are working on that concern, Councilmember Keller.
Thank you.
Councilmember Malchow.
I was just going to move that we adopt the low-impact development code updates, including the amendment made tonight, striking the building height incentive.
Second.
Been moved in second. Discussion, Councilmember Odell? No discussion, okay. Anybody else? All,
I just want to make sure that the amendments that are passed include the discussion in my presentation on the further defining critical areas in the exhibit attached to the ordinance.
Yes.
So.
Yes.
okay. All in favor, say aye.
Aye.
Aye. Opposed? By your vote of 7-0, it's approved.
Thank you.
Item 46, now this is a public hearing required on an emergency
I'm
ordinance.
sorry, Mayor, same motion as Councilmember Odell for the lid, to bring that forward with some additional comments.
Okay, we could do that at the same time.
Fair enough.
Okay. Mr. City Manager?
Thank you, Mr. Mayor. So before you is a request or requirement that we hold a public hearing on the interim ordinance, amending the stormwater management regulations for Tamarack neighborhood. This particular agenda item essentially becomes moot with the passage of the prior legislation. However, we had a legal requirement that we have this public hearing within a certain number of days of the passage of the emergency ordinance. So therefore, we have it here. It will be in effect for a few more weeks, and then it will actually be sunsetted by action that you took earlier today.
Okay. With that, we'll open the public hearing. Is there anybody that would like to address the council on this issue?
You're good.
Actually, you've got Dan Hagee first and Fred Schmall second. Charlie Smart. Mary Wichter.
Hello, my name's Mary Wichter. I live at 408 208th Avenue Northeast in Sammamish. And I do understand that this ordinance is going away, but I just have a couple suggestions. The attachment B, which shows in the code, Inglewood area has never been titled as such, so it says attachment B and it draws it. I think having a title added, that would really help. The attachment C for Tamarack is fine. I like the map. It shows the slopes and the landslide hazard area, but the blue lines, which Maya had talked about during her science experiment, those are not all the subdivisions for Tamarack. They're actually the westerly flowing subdivision or subbasins that were done as part of the downstream analysis. So they're not really all the Tamarack subbasins. It's the downstream analysis subbasins that are blue. So I just wanted to clarify that on the map for anybody. Also, there's a lot of areas in this city that have erosion hazard areas that are similar to landslides, so that's why I made the request through Lyman to put on the work calendar or the work items, that you would look at those and see if there's code that needs to get done and kind of look back to see how these are working. And then I had submitted a whole list of questions that I would, as part of that, I think would be useful. There are things like, can I repair or replace my driveway? Can I convert my asphalt to concrete or concrete to asphalt? What happens if I pave? How much, if my home burns down, can I rebuild it? Or what's going to trigger if I remodel my existing home or change the footprint? Is it just going to be the changes that are looked at or my entire lot? If I put an addition on my house and I'm not adding a bedroom or a bathroom so I don't need sewer, what size is going to trigger things? What level of drainage review might be required for the modeling projects, and if you do sheds or foundations. So anyway, there's a list of 12 items. It's not as part of the code, but I think in fairness to the Inglewood people that had this put on them, they gave a lot of feedback. We had a lot of questions this last couple of weeks from owners that live in my area, and we talked on the street. So I came up with this compiled list, and it's not part of the code, but I think it's how a user is impacted by the changes that you've made. So I would like to have that work done.
Okay, thank you, Mary. We can take that list and...
Yeah, we'd be happy to receive that list as part of the public hearing record. Okay, very good. Thank you. Okay, thank you. And related to this particular item, council does not need to take any action.
Right. Jeffrey Weems?
Good evening, Council. I'm Jeffrey Weems, address 941 206th Place Northeast in the Inglewood Plat. I'm here on behalf of the 206th Place homeowners group. I haven't seen you all for a while. I suspect you probably remember me. We have concerns about the emergency ordinance that was passed 2 years ago now on the Inglewood Plat. Very similar to the now moot ordinance that was applying to Tamarack. We're not going to have the Inglewood amendment made moot on the first of the year, as is happening with the Tamarack one, but probably more importantly, we are looking forward to seeing how the LID development code update affects the options for homeowners in Inglewood, because the vast majority of the 540 homeowner parcels in the Inglewood Plat are kind of landlocked. They're far from the parkway, which is the only place that you can dispose of runoff that's below the hazard areas, and a lot of people just have no way of getting pipes down to the parkway. I'm sort of beating the same drum I've beaten every time I've been here. One point I did want to make was that, you know, we appreciate what the work that the city has done and the taxpayer money that's gone into doing the main trunk line down Inglewood Hill. I imagine most of you probably in the last month or two have been down Inglewood Hill and seen all the work going on there, and the sidewalk will be very nice. Planting strips will be nice. That'll be good. It's important to remember, though, that the trunk line there on Inglewood and some of the side spur lines that go to the northeast don't provide a disposal point for the vast majority of the parcels that are in Inglewood. Cannot take advantage of any of that infrastructure to get their runoff below the hazard area, down, in other words, down to the parkway. One thing I wanted to mention is that some of our members in our group have filed appeals with King County Tax Board of Appeals, Board of Equalization, just because they feel that the valuation of both, in some cases, their homes, and in other cases, or their vacant lot that they've owned for a while, that the assessor's valuation of that parcel is not accurate anymore, because while technically there is not a moratorium or anything in Inglewood, the fact is that many of these lots, remember, cannot get a pipe all the way down to the parkway. There are many blocks of private property away from the parkway. So we'll be looking to see, working with Tawny, we have a sort of an informal commitment that early next year, first quarter of next year, we would be looking at what are the options other than tight lines to the parkway for Inglewood homeowners. And LID may provide some of that. Thank you for your time.
Thank you very much. Is there anybody else that would address the council on this? Seeing none, public hearing is closed, and there's no action. So that's that. Now we go back to new business, item number 2, which is the contract with Lynn Moberly to provide general prosecuting attorney services. Mr. City Manager?
Thank you, Mr. Mayor. We have a contract for services for our prosecuting attorney, and Beth Goldberg, our Administrative Services Director, will give us a very brief overview of the process and what the contract entails.
Good evening. I'm Beth Goldberg, Director of Administrative Services, and just a brief overview of our contract with the law firm of Lynn Moberly. Ms. Moberly and her law firm have served as our prosecuting attorney since 2007. She provides services to a number of cities on the east side, including the city of Carnation, the city of Mercer Island, to name a few. She provides us high-quality service at a competitive rate. In fact, the rate increase that we're providing her this year is the first time in 4 years that we have provided her an increase in her monthly rate. She has also been instrumental and a critical player in our efforts to reduce the number of traffic tickets that have been dismissed. You will recall that in 2014, we were seeing traffic tickets being dismissed at a rate of 30%. There were several factors, but one key factor was our contract didn't provide for prosecuting attorney coverage at contested calendars where people weren't represented by attorneys. So the judge would have very little choice but to, in most cases, dismiss the ticket. So she worked very collaboratively with me, with the police, with the court to devise a plan, and the plan has been very successful. We are now down to a traffic infraction dismissal rate of less than 7%. She is also what I would describe very much as our eyes and ears of what is going on in the court. So if she is seeing the judge flag things of concern, or if our police officers are making errors in how they are drafting or writing their tickets, which then leads to the dismissals, she is notifying us right away, and we are able to get a handle on those issues right away, again, to keep our traffic ticket dismissal rate down. So I would say from a performance perspective that we are getting a high quality service from Ms. Moberly and the staff of her law firm.
Deputy Mayor Valderrama.
Yeah, first I'd like to open with a question. As we saw on item number 4, with the Stewart, McNichols, and Harmel, we put that out to bid. Why now are we not putting out to bid this contract? I know she's got great service, no question with her service, her responsiveness. She responded back to our request to change, to address these tickets. Eyes and ears, though I expect anybody who we hire will be our eyes and ears as part of their service. And so why are we now going back to where in the case of Stewart Harmwell, they've been with us since inception. Why is this still a sole source contract?
So a couple of reasons. First of all, Stewart McNichols Harmel has been with us since the city incorporated. Ms. Moberly has only been providing a service since 2007, so it is a shorter duration. We decided to put the Stewart McNichols Harmel bid, the public defense bid, out to bid because there were structural problems with the way the contract was structured. So the contract was structured in a way that required us to pay a base 10 cases every month, regardless of whether we had 10 cases. And what we were seeing, if you see from our caseload trends, and I talk about it in the agenda bill, is that some months we might have 3 or 5 cases, another month we might have 12. In those months where we have 3 or 5 cases, we're still paying for 10. And in those months where we might have 12 or 13 cases, we're not getting any credit for the many months, and it's actually more frequent that it's been less than 10. We're not getting any credit for those months where we fell below the 10 threshold. So there were what I would describe as fundamental structural issues with the way that contract was structured. So that was the impetus for putting it out to bid. We invited Stuart McNichols and Harmel to submit a bid, and they did. It was the more expensive. We received 4 bids. It was the more expensive bid. I will also say, however, that Supreme Court rules about the administration of public defense says you can't just make a decision on price. We made the decision to go with Steinlotzgar Starr, not just based on price, but based on quality of service. The way their contract is structured is they're actually also charging us for a base 10 cases per month, but they're looking at it, we're looking at it over a period of 6 months. So if over a period of 6 months we stay within 60 cases, but 1 month we had 3 and another month we had 13, we won't be paying for those extra 3 cases because we would fall below the 60. So it is a more favorable contract structure, and that was really the impetus, was that there was a fundamental structural problem with the contract. The other issue in terms of why not put all of these out to bid is you have a very limited staff in your administrative services department, and frankly, from a workload perspective, we couldn't handle putting more than one item out to bid.
I have also a question that why did you choose to use the same COLA rate as staff, 1.7? I appreciate that she didn't take it for years, but what was the rationale to use that after these years?
That was the directive from council, I think, 2 years ago, is to use a comparable COLA rate. And so that's what we applied, and it's not just to this contract.
No, we've applied it on the past, but there was an issue actually I raised in 2012 as I went back as to using the same COLA rate that we use for staff and treating them exactly like staff. In this case, it's even more peculiar since it's just 1 year out of a series. So that's what jumped out at me. I would like to see this, pass this now, given the workload that you had, but to see that next year that this go out for bid. Again, you do not have to base it on the cost, and you can include the quality of it, but out of good housekeeping and good business practices, and I'm appreciative that they've put in that it's a sole source. In the past, they hadn't done that, so I commend the city manager for that, but I'd like to see this going forward next year with the workload to come back as an RFP and credit her for her experience and the services in that waiting.
Are we okay with that comment?
Well, just to be clear, it's a 2-year contract.
That's correct.
So it would be after the 2 years.
2 years. Yeah, I'm sorry. After the 2
Okay, that'll be next council's work, whoever's here. Okay.
So is council directing staff to put this out for bid in 2 years?
In 2 years.
In 2 years, yes, not at this moment because of the workload, but in 2 years.
2 years, people can decide.
But right now, we have Mr. Odell wants to say something.
I had a question. If we're done with this particular
We're not
line
done
of
with it.
conversation.
No, we still have to have a motion.
Okay. My question pertains to both Bills 2 and 3, and as I looked at these, Beth, I had a hard time distinguishing between the two. What is the difference?
Bill 2 is the actual contract for 2017 to 2018 with the law firm of Lynn Moberly. Bill 3 is a contract amendment on this year's contract. The work on the contested calendars, that contract had a not to exceed limit of $30,000. The workload this year has been higher than what it was last year, and through the end of October, we had spent $29,000. So we were going to exceed the not to exceed limit of $30,000. So Bill 3 increases the not to exceed to $38,000 to get through the remainder of this
year.
Yes.
Okay, thank you.
And then for the 2017-2018 contract, and you'll recall, we started the contested cases on a pilot basis. I think the data is very clear that it has been wildly successful.
I agree. I just didn't pick up the difference in years.
But I just wanted to point out that for the 2017-2018 contract, we removed that not to exceed limit so that we won't get into that issue next year.
Okay, thank you.
Okay, so do you want to make a motion?
Motion. I'd like to
Oh,
make a...
wait, I'm sorry. Sorry.
No, pay no attention to the leftists.
Yeah,
Right wing?
I'd like to just make a comment about this. I know this has come up previously as we go review these. And I understand the point about, putting it out for evaluation, and the corresponding argument is always, well, it's not like you're comparing apples to apples, because the services and the quality that are being delivered and the knowledge that is gained and that influences the evaluation of these contracts. So I'm just wondering if it would satisfy, rather than saying we're going to put it out to bid, that we get it a month earlier before the contract is being evaluated, so the council can actually look at this and be part of the process of, should we put it out for bid, or is it okay to do an evaluation like this?
I would like to put it out for bid and let the staff, it's not going to be based on cost, as the Supreme Court has ruled on that. So you can weigh in those factors. But I don't want to get into an RFP evaluation process here. That's a pretty timely thing.
I'm just talking about before it comes up. It's like right now, this is being approved right now. It's the end of the year. There's no more discussion other than this tonight. But if you have concerns about it, if we had this last month, we could have had this discussion.
Oh, okay, 1 month, or direct them to put out an RFP, but 1 month before, bring it to our attention.
Bring it to our
and then-
attention.
So that council can then look at it.
So you have time to
I'd be
actually
fine with that.
evaluate it.
Okay.
They might do the same thing, but we get to talk about it.
Member Hornish.
So just to clarify, what you're proposing is any sole source contract to be renewed at the end of the year for the following years would be brought to council before December. Any sole source.
When you're saying any, that's a good question. I hadn't thought it through as any, because I know this one, the illegal contracts
Legal
have come
services,
up
I
many
think he's
times.
limiting it to legal services.
This is not the first time that Councilmember Valderrama.
How many other sole sources do we have?
We have an additional one with the city attorney, and honestly, I think this is a very bad idea at this particular point to say any legal contract has to be.
Right, I'll agree.
I think in this case, I would say if you desire us to, at the next point in time, go out and assess prosecuting services, we can do that. And would take that direction from council.
All right. Okay, so I'd like to make a motion authorizing the city manager to sign the 2017-2018 contract with the law firm of Lynn Moberly and direct him in the next reiteration or the next one of this contract to assess an RFP.
Is there a second?
Second.
Further discussion? I've got buttons lit. Do you want to discuss it further?
Oh, sorry.
Mr. Hornish.
Yeah, I'd like to make an amendment to not require the RFP, but approve this bill as proposed.
I'll second that.
I'll second that.
How do you improve it? I don't understand.
Approve this contract for 17 and 18 as sole source, but
Okay.
not require staff to put it out for RFP because of the legal sensitivity. I'm hearing, and as a lawyer, I understand the sensitivity on the legal side and the representatives and those services. That I think staff needs the discretion to decide whether or not to put it out for an RFP.
Okay, the amendment was seconded by Councilmember Huckabee. Any further discussion? Seeing none, all in favor of the amendment, say aye.
Aye.
Opposed?
Nay.
By a vote of 6 to 1, the amendment is passed. So now we're back to the original motion as amended, which actually reads as the original motion here.
That's correct.
Any further discussion on that? Seeing none, all in favor say aye. Aye. Opposed?
Nay.
By your vote of 6 to 1, it is approved. So now we go to bill number 4. Sorry.
Thank you, Mr. Mayor. Before I turn things over to Beth Goldberg, our Administrative Services Director, I just wanted to make a couple points. Kenyon Deason is considered to be one of the premier municipal law firms in the state of Washington. The relationship between the city attorney and city staff and city council is extremely important. There is a level of trust here that has been built over many, many years. We are pleased, very pleased, with the quality and the timeliness of services that staff from Kenyon Deason provides to the city of Sammamish. We have received very good legal advice that has consistently kept the city out of, shall we say, legal hot water, for lack, that's a technical term. And we are receiving good value for the amount that we are paying. At this point, we have no need, in my mind, to question the value of the services we receive. They are of the best quality and at a very fair rate. So thank you, and I will turn things over to Beth to give us a bit of background.
So I will piggyback on that with a few facts and figures, because that's what I do. I want to point out that this contract covers two basic bodies of work. First is general city attorney work, which includes Mike having the pleasure of sitting at these council meetings every couple of Tuesdays. Anyway. Providing us advice on day-to-day operations of city government, and we make full use of the services that he and his staff provide. So that's one body of work. The separate body of work is he and his firm represent us on matters of litigation, either when we are getting sued or when we are suing someone else. And that workload has grown significantly over the last couple of years. Last year, we had 24 active litigation cases. This year, we have 25 active litigation cases. One of the benefits that Kenyon Deason provides us is they have an institutional knowledge about the city as a body, and the issues, the legal issues that are coming before us. Lawsuits, litigation don't begin and end with a calendar year. They often will span multiple years. Some of our cases have spanned, 3, 4, and 5 years. The advantage that Kenyon Deason provides is that they have that institutional knowledge. If we were to issue an RFP for this contract, a new firm would be spending a heck of a lot of time on a learning curve, getting up to speed on the multitude of issues that are provided by Kenyon Deason. The other thing that I want to point out is that they are going above and beyond what we are providing through contract dollars. Through November of this year, they have made nearly $140,000 of community contributions. And when I use the word community contribution, these are hours of work that they are putting in to providing a service for which they are not billing us. So if we were to pay for those, our costs would go up significantly. If you look on page 2 of the agenda bill, you'll see that their effective hourly rate has dropped significantly since 2011, and that's in large part because our workload on our general city attorney work has increased, and the dollars we are paying has not kept up. So that's one thing I would point out. I would also point out to the footnote at the bottom of page 2, you will will all recall that Kenyon Deason successfully represented us in the waste management bid protest that happened at the end of last year and into the beginning of next year. The judge in the case, we prevailed, and the judge awarded us attorney fees, and in making that award, she stated the hourly rates of the attorneys and legal staff at Kenyon Deason were reasonable at the time of service at the time the services were rendered. The attorney rates charges were in fact substantially below the prevailing hourly rate of similarly experienced municipal attorneys in the relevant community. So all of this, I think, collectively reinforces what Lyman said: getting good service, getting good value, and that is the reason why this has continued to be a sole source contract over these years.
Thank you.
Can I speak to?
Yes.
All right. Thank you. Well, first, I'd like to start off before responding to that. Because I think we're going to get lost if we don't. In the actual services of the attorney, Exhibit 1, point number 2, we have the statement: the attorney shall work for the city at the pleasure of and under the direction of the city manager. I'm actually wondering if that should be shall work for the city at the pleasure of the council under the direction of the city manager.
I believe I'll respond to that. I believe that actual direction under the form of government that you've chosen is actually at the direction of the city manager.
Understand, that part I put left.
For all contracts.
Agreed.
The city attorney does work very closely with the city council, and you are free to consult with the city attorney at any point in time. City attorney will keep a confidence for the city council, and I don't believe we have a problem with the language in this particular contract. It is standard throughout the state of Washington.
Well, I'd like to come back to that, and we don't have to do that today, especially at this hour. Back to the original portion of this. Again, I have no question on the quality of the service or the personality of Mike, who I enjoy. He has been very responsive. I've been very happy with his service. This issue I've been raising since 2012 on multiple levels. The first level was just at a good practice that you have, regardless of how good the quality of your attorney or your accountants. I used to run KPMG, government education, health, and utilities, and we were required after every so many years to be able to bid those contracts back out. However, similar to what the Supreme Court has said here, because of the expertise, the knowledge, and the responsiveness, we were able to renew those contracts again. And I have no question as far or hesitation that we would renew Kenyon. As far as the community service hours, as in the waste management contract for public services, that was also an issue in community services. Those are included in. What became more troubling to me was in 2012, we were treating the firm of Kenyon Deason and the then city manager, Ben Yazigi, used it that we were going to treat them because they're like staff, and gave them a COLA. The COLA increase was higher than we had with our contractors. So that was for that year. We then came back in 2013, and if I'm not mistaken, we gave them, suddenly we broke from the COLA, and we gave them an 8% increase for that year, and the subsequent year for 5%. We then came back and we gave them a COLA increase. Then we're coming back now and changing the fees again. And I've been asking, are we treating them like staff because they're like staff to us, or are we treating them like competitors? And this is where we've gotten inconsistent responses. Again, the city manager 2012 on the record said we're treating them like staff, and then we changed. So there is a process issue that's not correct here as to either he stays with those COLAs or he's going to be having different fees, but this is very inconsistent how we've been doing it over the last number of years, that some years he gets COLA increases equal to staff, other ones he's getting fees. So for good business practice, I would say this needs to go out for a bid at this point, and I would be the first to support Kenyon Deason in getting his contract renewed with us because of the quality services. But the optics on this, on how it's been managed, what's been said to the citizens on this is not matching, and I think it's time to put it out.
So can I maybe offer some context for this year's increase? And I wasn't here in 2012, so I can't speak to that. But what I can speak to is that this increase is not tied to whether they're staff or not staff.
Not this increase, but there have been past.
Well, I understand that. What I'm speaking to this year is that one of the fundamental things that is going on here in the chart on page 2, I think shows this pretty clearly. The workload has increased such that the rate that they are getting paid in 2016 is $153 per hour. Some of the attorneys are paid $250 an hour, but we're effectively paying them $150 an hour. The rate in 2011, because of workload, was equivalent to $266 an hour. So this increase is not just do they deserve a salary increase. It is also related, and it's trying to catch up for what we have seen over the last couple of years is a significant increase in the number of hours that they have had to contribute.
I appreciate that. That's workload, no. Now, it's been 2 different times on COLA. On the 8% and 5%, it was because they deserved increases, so it's inconsistent how we're doing this whole process, and it has been for years. And while I love Kenyon Decent, especially Mike here, it just has bad optics.
Yeah, and if we do put it out to bid, the rate may actually be even higher than.
Understand, but if he comes back again next year and says, like he did before, I need an 8% increase and a 5% increase, we're doing the same thing. So, and it's not based just on the cost.
Okay, we have Councilmember Hornish with a button there.
Yeah, I got 3 points. Number one, if you were to get a new firm in, I would expect them to waive any getting up to speed, so I wouldn't use that as a factor, just to be fair. Number 2, the clarification about the city or versus the city manager. I mean, I like the language, and I think you have to look at it a little bit closer to understand. The attorneys shall work for the city at the pleasure of and under their discretion. So they are working for the city. We are the city as council, I would say. So he is working for us, even though it's under the discretion, just to kind of make that distinction. Having said that, and looking at it, again, I go back to my experience that the legal is a little bit more of relation-driven. I'm looking at the rates. They are very favorable. But more importantly to me is the institutional knowledge. I do have to question, though, with the increased lawsuits, is he really keeping us out of hot water? But having given that, I can support staff's, using staff's recommendation in this regard.
Further discussion. Councilmember Odell.
If we're having a lot of problems with Kenyon Decent, I'd be all in favor of putting this thing out for bid. In fact, anytime we have a major issue with Kenyon Decent, we could fire them for cause. That option is always there. I think the fact we've gone back and forth from one form of incentive to another is as much our fault as it is the city attorney's fault. We have created this. We created this. So putting it out for bid is not necessarily going to fix that. What we need to do is establish a methodology that we're all comfortable with and stick with it and not go back and forth. That is a problem that I think is in the past, or at least I hope it's in the past. But there is an awful lot of institutional knowledge that would have to be transferred to a new firm, and that's not easy. I've had extensive dealings with legal firms while I was at Boeing, and frankly, when they come in the door the first time, you are shut down in terms of being able to get anything done because you're dealing with the attorney and educating them. The cost to the city, even if they do waive their fee, is going to be tremendous because all of the directors will be spending an awful lot of time with the attorney educating them on what the issues are and the nuances thereof. So I think the Supreme Court justice or the justice said it very well, that the fees are very, very fair, and I don't think we need to rock this boat. A bigger issue down the road, maybe, do we start bringing some of this work in-house? Are we getting to the point where maybe we should bring it in-house? A couple of our neighboring cities that are roughly our size do part of that. So that's a subject for a future discussion. But right now, I'm very prepared to stay the course. Thank you.
Thank you. Councilmember Malchow.
Yeah, I would tend to agree with Councilmember Odell that I think we can fix the inconsistencies that we have with regards to the rate increases, whether it's a percentage increase or if it's using COLA. And I looked to the chart, and Beth, I assume you put this chart together. I appreciate it. I think it really kind of paints the picture as far as the effective hourly rate and what we're really getting. And so it has decreased. It went from 266 in 2011. It increased slightly in 2012 to 291, and then has dropped since. So I think we're probably getting a fairly favorable rate.
Okay, so would someone like to make a motion?
I'll make a motion. That I'm trying to look for this. I'll make a motion that we approve the 2017-2018 contract with Kenyon Deason to serve as Sammamish's city attorney.
It's been moved and second. Any further discussion? Seeing none, all in favor say aye.
Aye.
Opposed?
Nay.
By your vote of 6-1, it is approved.
Thank you, Council. It does truly remain my privilege to represent my hometown.
And ours to have you.
We especially enjoy the 1 o'clock meetings. Yeah. Okay, so now we're to council reports and council committee reports. And we'll start with Councilmember Odell to my left.
The guy who gets here.
We also talk about the why during the council reports?
Yeah.
Okay.
And also, we're going to appoint an ad hoc committee to review the city manager's performance.
Okay.
Not necessarily tonight's performance, but the whole year.
I say tonight.
So am I on? You're on. Okay. First thing I have to report is that I have resigned as the city's representative to the Y Board to avoid any potential conflict of interest in upcoming decisions that involve the Y and the Y property. I felt that even though after conferring with council that there may be a legal out, that the optics were not favorable for me to stay on. So a week ago, I resigned from the Y Board as the city's rep. My suggestion to council is that we do maintain a representative on the board, but it'd be a staff member as opposed to a council member. The second thing is there will be a meeting of the Transportation Committee tomorrow at 9:30. We will be once again dealing with the Sahawi Way project, getting ready for bringing it back to council for further discussion. We'll be talking about Issaquah Falls City Road again, design again. And the major issue here is whether or not we replace the culvert that's there already today with a much larger culvert, or do we go with a bridge? There are some major issues the council will need to grapple with, one of which is the time involved. The second one is also the fact that we're going to be bringing in, if it's a culvert, bringing in several thousand truckloads of fill material and the effect on traffic. Speaking of traffic, either option does close the road for anywhere from 3 to 6 months as we rebuild the culvert or replace it. There are some major issues the council will have to step up to in terms of how we manage that situation. That's as far as I'm prepared to go on this issue tonight, but just a heads up for you guys, you're going to have this put into your lap. I did attend the Transportation Technology Conference a couple of weeks ago. Found it very interesting. Once again, I think that the Index Corporation has some very interesting stuff that we need to understand better. It will help us in the city to a great extent, but even more so on a regional basis, understanding what is actually going on in the Puget Sound area traffic-wise, and by inference projecting to the future. More on that later. On the pure technology side, there were some very interesting things on driverless vehicles. I'm not ready to hop in a driverless BMW quite yet, nor am I totally convinced they are actually going to help traffic. They may actually hurt it. If you take a driverless car to Starbucks and there's no room in the parking lot, you order it to orbit the Starbucks. That's not going to do anything. But there is possibly something here we need to look at, and that is this council, and particularly the Transportation Committee, has been dabbling with the idea of an internal shuttle. And one of the issues there is the cost of the driver or finding volunteers to drive the vans that King County wants to give us. If these could be driverless vehicles and programmed to go where we need them to go, that might make this whole thing a lot more feasible. It's not a next year issue, but it's definitely on the horizon. Lastly, I attended the Growth Management Planning Council meeting today. This is my last one of these because I am not going to be on GNPC next year. But there was one issue today, and that was the PSR conditional certification of 4 small cities comp plans. And I don't know how closely you may have been following this issue, but the 4 cities, let's see if I can get this right, it's Snoqualmie, North Bend, Covington, and...
Lake? Bonnie Lake?
Not Bonnie Lake. I think it might be Carnation. Have
in our county anyway. In our county.
Yeah, that have submitted comp plans to PSRC and gotten them bounced because they are exceeding their growth targets. Now, growth targets previously been understood to be minimums. That's what Don Jaron told me several years ago when he and I were trying to educate me on what was going on with this thing. Well, somewhere along the way, PSRC changed their definition to be growth minimums, or growth ceilings, rather. They went from minimums to ceilings. So these 4 cities have exceeded their growth targets and are in violation. And the city of Covington has already lost 1 grant for parks work because of this. We discussed a couple of options developed by council staff today, rejected one of them, and North Bend came up with another version of the first one that was retained for consideration that will be given further consideration by the council on February 22nd. But we will not have a representative at that meeting. I think Matt from Snoqualmie is going on, and he's obviously definitely infected. Just for information, I will be joining the flood control group, which has implications for Lake Sammamish. So that's my report. Thank you.
Thank you. Councilmember Melto.
You want to talk about the YMCA property at all?
Go ahead.
No report aside from the YMCA property, if you want me to jump in on that. Of the options that Jesse had up, and of course we don't have those to reference anymore, my preference would be to defer the decisions on the property and the planning process until the pro plan update and the land acquisition strategies are complete. The reason being is that I don't see that it makes a whole lot of sense to study an indoor facility until the pro plan and the land acquisition studies are done anyway. I think if we're prioritizing, it's really hard to do that when we don't have the plans completed. That gives us the information to make educated decisions. So I think that would be my preference is deferral.
So do you want to make that a motion?
I sure can.
Include engaging the Parks Commission?
Wait a second, we got somebody, a runner.
A crazy tired runner. If your motion could include authorizing the staff to meet with the Y to renegotiate the terms of the lease agreement, I would need approval from both parties to extend the deadline for that site development plan to do what Christie just proposed.
Okay.
And engage the Parks Commission?
Yes. Which will happen naturally, I'll just say, because they will be overseeing your park planning and land acquisition processes.
Okay.
Should we go for just 1-year extension? I mean,
well, that's.
I think
would be
until the motion would say until these plans are completed. I don't know if that, I
well, but
assume
we
those
have-
will be
but
done.
we have to renegotiate it, so because we're never going to make the deadline if we don't negotiate that mid-18 development plan.
My preliminary conversations, non-binding, with Marcia were that a year would be reasonable for us to do our work, and that's something she thought they could possibly agree to.
So we need to give you authority and okay to renegotiate that to extend it to 2019 to come up with the development plan after we do the
Do you want me
program.
to specify
That-
June
that would-
2019? Because
that
that would
would
be
be
an
helpful.
additional year. What was that, Lyman? Sorry.
Yeah,
I would
that
say
would
your
be, that
minimum
would be
1
helpful
year.
to extend it a year to 2019.
Do you want me to specify June? Or not necessarily? Because June is currently, it's June of 18.
I would say just June of
Actually
18.
gives us a year and a half.
1 year, or June of 19, I'm sorry.
Okay, right, okay. All right, so I would move that we defer decisions on the YMCA-owned property and the planning process until the pro-plan update and the land acquisition strategies are complete. I would ask that we authorize the city manager to meet with the YMCA or staff to renegotiate the contract so that we can get an additional year to June of 2019, as well as engage the Parks Commission in the property.
Second.
Okay, it's been moved and second. Discussion, Councilmember Odell?
Yes, I am in complete agreement with Councilmember Malchow that we need to figure out a number of things before we figure out what we do with this property. I fully believe we need a needs assessment of this type of thing and others around the city. I also feel that we need to look at alternate locations in addition to the Y property site. This may not be the best location. Perhaps it should be in the middle of town, maybe it should be the eastern part of town, northern part of town, we don't know. For 1.9 million, frankly, the best thing for us to do might be to buy it, but I'm not going to presuppose that decision. But the property is kind of unique in both in terms of location and the nature of it. There's certainly a large number of people that do not want to see this particular facility located there, and I think we should respect that, but I would prefer to see more scientific sample.
Sorry, can you repeat the last?
I would prefer to see a more scientific survey done than simply who does what on social media or walks into council public comment.
Okay, thank you. Deputy Mayor Valderrama.
Yeah, I also support the deferring this for 1 year. I would, however, continue to cherry pick the rest of the menu items. I think that given this process had started a couple of years ago, we should be looking at the feasibility and design of a non-site specific facility with those dimensions. I would also piggyback on what was said as far as the locations. I think one of the problems we're having right now, in addition to this facility, I know of 4 other properties that citizens have come to us and say, buy this land, and we can't go buying all of this. This land in particular is the one that's the closest walking distance to Pine Lake and to Big Rock Park. So I think we need to look at this and say, does this make sense to have 3 big parks in the south there on close to 228th? But that will let the study do. I think we also need to take a look at what kind of property we need. I mean, the parks plan that was done, the last parks plan, said we didn't need any parks at all. We had exceeded all of the indicators, except I think in the Northeast, which was debated, and actually after further debate, Ben said we really didn't need one if you take it from the half mile to a mile of other city standards. So that study would be beneficial to look to see, does this make sense? Following up on what Councilmember Odell said about wanting to have a more scientific study, I think what we need here, I mean, you can't have a town hall. You're not getting a representation. You're not getting a representation. So like the community center, I would suggest that we put this out for an advisory vote with the amount of money that's going to be spent on this for a facility. If we're talking $15 million, mind you, even if we buy this land at this site and put recreational, the $2 million for the land, you have to add what a passive park costs us. The only indicator we have right now is Big Rock Park. First allotment was $4.2 million plus $400,000 annually. So that's a significant chunk of money, and I think it would behoove us either way to put this out to an advisory vote so it's the most scientific possible. Let the voters and the citizens decide how they want to utilize it. So that would be my amendment, is to, one, continue with a feasibility study, non-site specific, and two, look at an advisory vote.
Is there a second to the amendment?
If I may comment on that, so I hear the terms scientifically valid survey. Part of the PROS plan and the land acquisition plan will have a statistically valid survey compiled and completed. So, and we haven't formulated the questions of that yet. We could explore indoor athletic facilities inside that survey, and that would be statistically valid and representative of the community. So that could provide the data to inform some of these decisions.
The problem we've had in the past, going back to the first community center valid survey, is they didn't understand there were trade-offs, and they said, yeah, buy everything, and we ended up with a $70, $80 million facility that was unacceptable. So it was statistically valid, it was just impractical. I think we have a very directed advisory vote, as we did in the community center. Let them pick.
Okay, we got other people that want to talk. Is there a second to the amendment? Well, there's no second, so
What?
guys.
What's wrong with you guys?
Councilmember Huckabee.
Yes, I think from my perspective and from where the city is standing right now, considering that we have the pro plan and we have hired consultants to help us identify and prioritize our land acquisition, it's really important from my perspective that we take the time before we jump into any property. And you're right, people are saying, buy this, buy that, buy
Absolutely, all the time.
And I think that it's our responsibility to look at the overall picture and to decide whether we should move forward, where we should move forward, and we need the information to do so that we can identify, do we need this type of facility to begin with? Is it in the appropriate place? We already know it's going to cost simply $500,000 or more just to do the sidewalk in Frankfurt. But just getting an idea of, for example, if we had the opportunity to spend $2 million on buying some property that would save a stream or save our kokanee or provide some additional property on the waterfront as opposed to this property, how would our citizens respond? I think we owe it to them also to provide them the information through these two studies that we're conducting, or the pro plan update and the contract that we're going to be receiving about priorities on property, that they'll have a clearer picture of what our idea is. They can criticize or not those results, and then we can go from there to decide what specific items we're going to be adding to our purchase plan.
Thank you. Councilmember Keller.
Yes, I definitely support the motion and really agree with a lot of the points that have been made, so I'm not going to just pile on. I will say that the pro plan should answer a lot of questions for us. And in fact, while I agree with Deputy Mayor Valderrama in putting, that it would probably be a good idea to put it out to a vote, an advisory vote, I think we should let the pro plan speak to that it will inform the public as well so that they know what kind of input they would be looking for an advisory vote as well. So I think the point is well made that he's making. I just think timing is that we should probably let the Parks plan develop first with information before we would do that.
Councilmember Hornish?
I concur. I think it's just, I think an advisory vote would be good. I think it's premature without the pro plan.
Thank you. I agree also. Did you want to?
Yeah, well, I just wanted to speak to the advisory vote. I think it would be wise to do, but considering that the motion was to defer, it doesn't make sense to do an advisory vote now if we're deferring.
No, this would be after. What I was proposing was after the pro
Yeah,
plan.
but just a minute.
Well, yeah, I think if we let the information come to us from the pro plan and the land acquisition strategy, then we know what we're dealing with. And then if we're still sitting in this same seat in, a year from now, then we might be. Then we can put it out for an advisory vote.
The pro plan may say don't do it.
It may, exactly.
Okay. Are we ready for a vote? All in favor, say aye.
Aye.
Opposed? By your vote of 7-0, this is approved. Very good. Okay, now,
Council reports.
Councilmember Keller.
My turn. Okay, hopefully this will be quick. We actually have an open motion on the table right now that is left over from 2 meetings ago. And it was pertaining to the R1 zoning study request. I had actually opened up a motion that to direct the staff or the city manager to direct the staff to do a study on the R1 zoning. And the reason for it was to look at the R1 zoning in terms of its environmental protections, how it was related to traffic, the historic zoning accuracy. We heard from a lot of public comment about they had SR 9600, and that was equivalent to R4, and there's just no history there. I think we need to actually have those things looked at. The emergency potential of upzoning R1 to R4. There was a number of reasons that we would have this motion, or why I put the motion on the table. Neighborhood character was another one. Councilmember Malchow seconded that motion. We had a lot of discussion. It ended with a suggestion from staff, but we left the motion on the table. There is an open motion on the table, so I would like to call
What?
for
The
the vote.
chair left it on the table?
Yes.
Under the table, under the table.
I did go back and view, I understand, yeah, I did go back and view the meeting, and I can understand there was so much discussion in how we ended with the staff jumping forward. Actually, the city manager himself jumped in and said that he would be happy to ensure that the study was presented to the council, but I would like to just call for the vote, and we just have it on record and the motion is passed. I can reread the motion if you'd
Please.
like me to reread it. Councilmember Keller directed the city manager to initiate a formal policy discussion and review on R1 zoning on a citywide basis related to any upzoning. The process should include review of the historical establishment of all R1 zoning and any related overlays, environmental and wildlife impacts, any current comprehensive plan direction, potential traffic, infrastructure, parks, would include Emerald Necklace, and school-related impacts. The process should follow our legislative review on land use, including prior evaluation by the Planning Commission.
And that was seconded by Councilmember Malchow.
Yes.
Any further discussion on it? Seeing none, then we'll call the question. All in favor, say aye.
Aye.
Opposed? By your vote of 7-0.
Fantastic. Now, unfortunately, this slipped my mind as we were going through this. This is good. This is my priority to have that done. But since we are going to have that study done, it occurred to me that the R1 or the TDR programs that we have talked about, I'm talking about inside of Sammamish, that we have talked about it quite a bit. I'd like to actually put a motion, if it's appropriate at this time, that we actually direct the city manager also to complete the study for a presentation to the council for the Sammamish TDR program for Sammamish. The idea of this program and the primary use, again, I'll reflect back to the conversation that we had. with the Planning Commission earlier. Is it still the same day? Yes, it is the same day. About neighborhood character. Well, the issue of the TDR program, the intra-TDR program, as well as a lot of the concepts that we can look at in our comprehensive plan, was to focus the density in our town center to protect the neighborhood character of the single-family homes in our city. That's one of the reasons why we actually would even be looking at this program. So I'd like to put a motion on the table that I'm not saying we approve it yet, I'm just saying that we put it on the calendar and the agenda so that the staff does in fact present an intra-city TDR program to the council.
Do we need a motion, or is that something we seem to have talked about this off and on?
Well, we can
for
have it
some
as a
time.
motion.
I'm just asking whether it's already part of a future work plan, or
It-
is it something that we're going to be doing.
It is part of our work plan.
That's what I
Okay.
So,
Okay.
so,
It's already taken care
but
of.
we're happy to
Formalize it?
formalize it if you so desire.
This is one that I'd be happy to formalize it because I think that way we just make sure that it actually is,
Okay.
it doesn't get pushed back. It
We've got a
actually is
motion, is there a
To move
second?
things along, I'll second it.
Very good, it's been moved and second. Wait.
I have an amendment.
Councilmember Odell.
I'd like to amend Councilmember Keller's motion to including directing the city manager to simultaneously look at making Sammamish a sending site for locations outside of the city in addition to intercity.
Sending site so that we can get the TDRs.
So that we could send our TDRs to Soto. if we
Send
want
ours
to.
out.
Yes.
I think,
Covington or somebody with
I think it's fair to ask him to look at that. I've heard of no history of someone accepting it.
Well, it
Okay,
should be part of the process.
Amendment's been moved and second. Any further discussion?
Yeah, the only comment that I would ask the city manager is, will that distract from the initial motion from a resource point of time? Does this sound like it's too complicated?
I think we can report back on our investigation on that part of it. I don't think that that's going to be overly burdensome.
Okay, all in favor of the amendment, say aye.
Aye.
Opposed? By your vote of 7-0, the amendment's approved. And back to the original motion as amended. Any further discussion? Seeing none, all in favor say aye.
Aye.
Opposed? By your vote of 7-0, that's approved. Very
Okay.
good.
One last comment then from my report, and that is, I know the city manager is followed up with the Inglewood Hill, or excuse me, the Northeast 8th Street traffic situation there, and I know he is working on discussing this with the Lake Washington School District. I'd like to add one thing, or just make a note on that, is this problem came up with the intersection at Inglewood Hill and Northeast 8th about a year ago or so. There was a lot of problems that were being reported by the neighborhoods of the kids crossing the school. And the principal, as well as Stephen Chen, our traffic engineer, worked together, had a discussion, and my understanding was they really did make a difference.
They did.
The traffic is bad there, but it's hard to notice, I guess, at this point, but they did make a big
I
difference.
mean
That was
Inglewood Middle School.
Inglewood Middle School.
Uh-huh.
Okay.
Did they put another exit? Did they?
No, they didn't make an exit. No, they just changed the way the signal worked, and they
Okay.
put more people coordinating the crossings.
But that has been part of the discussion that I've had with staff. And so we're actually prepared, staff to staff, to push forward with those improvements, basically a check-in, as well as what else can we do. But I also wanted to talk to the superintendent of schools, essentially to get her buy-in before we actually approach her staff to work on this. And so if we get our grassroots effort, staff to staff, plus my direction and her direction, hopefully we can achieve some good things here.
Fully appropriate. I understand that. I just wanted to get it on the list that might be one of the things on your agenda then, is to maybe get the principal involved with his ideas, because
Yes.
they're probably getting the same calls from the parents that we get about the traffic. The school district
And-
is as well.
Yes, and that was part of my voicemail to Tracy Pierce.
Excellent.
Along those same lines, do we need to have a conversation with Issaquah about, for instance, the Pine Lake Middle School being reworked?
We actually already have had that discussion staff to staff with them, and
Okay.
they've been very receptive to that.
And are there any other problems we know of in Issaquah that need to be addressed?
Well, I know we have had some additional discussions with them on some of their schools, but I don't think the issues are as heavy as this particular area. We've got an elementary school, we've got a middle school, and we've got a high school, all basically converging right there. But I'll work with staff to determine if we do need to reach out to Issaquah School
Well,
District
I'd like
as
to
well.
comment on that because both Dawn and I were interviewing seniors on Monday of last week at Skyline High School. And you remember there was a little bit of snow and a little bit of bad weather. It took me precisely 32 minutes to go from 228 at QFC, but in the QFC area, to Skyline High School. And it was primarily because there were so many parents that were driving their children into the high school, and then on the internal roadways, they would not allow people to go through to get to the parking lots because they were all trying to get in and out of the building. As a matter of fact, Ron Thiele was also scheduled to be there, and he got there 5 minutes after I did and was most embarrassed. They had to go find other people to do the first set of interviews because we were all so late. The fact that the schools are causing so much of a traffic backup, it's something that we need to have a broader conversation with both school districts, because it's not just school specific. It is really very broad-based, and with bad weather coming, it seems to even be getting worse.
Okay, good.
Ben, actually, EFR, no report. I'll leave that to anybody else, but would like to compliment Chief Clark.
Is somebody going to give one?
If you have some comments, I just want to make these comments. I wanted to compliment Chief Clark on what a great job that he did. He completed the strategic plan this year, and the chair in our last meeting of EFR actually complimented the Finance and Administration Committee, the FAC Committee, on how successful they were and how much they accomplished this year. I just wanted to make sure that our members, Councilmember Huckabee and Hornish, both are recognized for the good work that's been done there. Great.
Great, thank you. Kathy?
Okay, well, then I'll follow up with my fire district report, because we had a FAC meeting from 12 to 1, and Ron always gets us out in plenty of time. So it worked really well. And again, I do have nothing but compliments to say about the chief. We're working on the exempt policy, which is really the deputy chiefs and several staff members, civilian staff members. And he was trying to address the compensation issue through a performance system that covered both the deputy chiefs as well as the non-uniform staff. And he's very gracious about taking suggestions. We all basically said, this isn't working for us. We really need to separate the two, because we have a compression problem. When somebody goes from battalion commander to deputy chief, they actually dropped in salary because of the overtime and other issues. And we said, we really, instead of trying to address it holistically in this, or to try to cover everybody in this fashion, we need to do something, and we need to address the deputy chief's salary, because this is not fair. We want to encourage them to step up. So we all agreed that we would increase the deputy chief's salary to a incentive to move from battalion chief to deputy chief, and then we would have perhaps a pay-for-performance bonus system, which is going to be distinctly different than what he presented to us this morning. We were all in agreement by principle. He will be sending that back to the FAC just for us to look at, because we were very comfortable with him rewriting it and just sending it directly to the board for the January meeting. So you will be seeing it at that meeting. And again, I just really have to compliment not only his thought process, But as people ask questions about the impact as we're moving forward with the renegotiation of contracts next year, he's thinking long-term. He's not thinking short-term. And so I find that so refreshing. I just can't imagine. Regional Transit Committee, again, as I said last week, I really am just thrilled that Cheryl and Jesse and Don and Tom Odell were able to help me work through the ordinance that the county has put forth. I think we spent 2 hours or so on it. I spent an hour and a half the next day with the SCA and explaining it to them. Spent another 45 minutes on the phone with Claudia on Friday. Don't look at your watch. You were talking for a long time, too.
We're past 10:30 now. Despite
11:30.
We have to-
11:30, beside 11:30, we need to extend the meeting.
Okay, do we have a motion to extend the meeting
So moved,
15 minutes?
at the most.
Okay, all in favor, say aye.
Aye.
Okay, go ahead, Kathy.
So, and then spent 15 to 20 minutes with Claudia on Friday, reshaping some of the verbiage that got mixed up at the SCA level. So we are meeting tomorrow. Our meeting starts at 10:30 and will go till 2 o'clock. Suburban cities will be meeting for an hour and a half ahead of time to go through this, and then we'll have a regularly scheduled RTC meeting to pass this ordinance, which I think everybody is absolutely really excited about, because it does give the Regional Transit Committee the opportunity to review, comment on, and make recommendations, not make decisions. I was told that's not in our bailiwick. We can make recommendations as to transit and how transit is going to be provided in the future. So that's a huge win for suburban cities. With regard to, I just wanted to make a comment on the conference that we went to on advanced technology, because one of the things I've been waiting for years is finally going to be coming.
Finding what?
Finally going to be becoming a reality. It was the last provider that talked about flying cars. And flying cars, which are coming in the near future, which my older brother used to watch the Jetsons, so we always had this idea of flying cars. But what I was commenting to Tom Odell, my brother happens to be the director of transportation and transportation planning in Cobb County, Georgia. And we had a long conversation, and I sent him some of the materials. They are not having any conversation about alternative ways of getting people to and from places. They're not talking about driverless cars. They're not talking about Uber. They're not talking about Lyft. Meanwhile, the Atlanta football team is moving out to Cobb County, where there is absolutely no transit. There's one highway with one turnoff lane to get everybody out there to the football game, and no light rail or anything else. So we are so far ahead of the curve as far as what people are doing in other very urban areas. We just all have to pat ourselves on the back that we're so far ahead.
Thank you, Kathy.
You're welcome.
Deputy Mayor.
Yes, I had the fortune of attending that conference with the mayor, Kathy Huckabee, and Tom Odell for the advanced transportation, which was good to see that
Bob was
it's
there,
coming our way. Excuse me?
Bob was there.
Oh, and the illustrious Councilmember Bob Keller leading the pack. Actually, flying cars have been around for 50 years. It actually comes from the Pacific Northwest, the first one who passed the FAA requirements, but then had to go back to the car requirements because the cars had advanced in. You can still see those in the museums. Additionally, the big highlight of the last 2 weeks after that was, of course, the Army-Navy game, followed by the meeting of Eastside Fire and Rescue that we had attended. We had already heard it, and I second the praise given to the chief and the strategic plan that's underway as we're starting to hit those goals. Just to bring to your attention a nuance dealing with the PFAS issue. The city of Issaquah released or had a press release go out citing that the headquarters of EFR was the primary source. EFR has come back and rebutted that and said, no, we are a potential source amongst many others, including a school in Issaquah, 2 prior city facilities of Issaquah, and they're waiting to gather a lot more data because right now, as they were showing us, there are some conflicting data that are being shown, and they want to gather more data before they look at this. And they are looking at the standards for cleanup. The problem is there is no standard for cleanup, so they can't clean up because in 5 years they could be told, well, that doesn't count. So, and they're also looking at how much could we have actually cost here since the trainings were done in other places. So a lot of conflict of information and what to do, but they are being very proactive, very diligent, and stand by because I think they're going to have a study in the next few weeks coming out with more data they collected in different sites. Thank you.
Good. Tom?
I have nothing to add.
Not even the Army Navy?
Okay.
Ohio Clemson?
Coming up.
What we have to do is select an ad hoc committee to review the city manager, and we had volunteers. Who was it that volunteered? Well, there they are, the 3 culprits down there.
The committee of the willing.
So I would suggest that we appoint a committee of 3 and have them work with our deputy city manager and our city attorney to come up with a process and perhaps ask our city manager to give us an extension from the end of the month to review his performance. Yeah. I said an extension.
By the 20th, for me, we have to, or I would have to ask somebody to sit in for me then. I'm going to be leaving town
For how long?
for a week.
Oh, well,
So,
that's,
pardon?
yeah.
On the 20th? I leave next Tuesday, and I'll be back the following Tuesday.
Mr. Mayor, in light of the fact that we are going to be entering a period where people will be doing a lot of other things, is it not unreasonable to go into some point in January?
Yes, well, we'd like to appoint the committee now.
Yes.
And you can talk with the deputy city manager and the attorney as to process and timing.
Okay.
And we'll ask our city manager to approve an extension of when he's supposed to have his performance.
Mr. Mayor, we did add an executive session on Tuesday, January 3rd. If that date needs to be adjusted, I'll just ask you to let us know.
Okay, good. So a motion to appoint those 3 culprits to the committee?
Second.
Yeah, it's been moved and second. Any discussion? All in favor, say aye.
Aye.
Opposed? Okay.
I just did.
Okay. Mr. City Manager, do you have a report?
I've got a couple things I wanted to cover very, very quickly. One is, I'm sorry I missed the Transportation Technology Conference. I was looking forward to that. But I actually was representing the city at the King County Sheriff's Fallen Officer Memorial Dedication at that same day, so it was very worthwhile to do. First of all, just a reminder that through our change over for solid waste provider, one of the things that we are endeavoring to do is to encourage composting of food scraps, et cetera. So there is information in the material that was sent out to everyone. There's also material on the King County website, Compost More, Waste Less. And as part of that, if you do go there, you can get 10 free compostable bags as a sample to collect your food scraps and food soiled paper. We are looking into the possibility of getting samples out to everybody in Sammamish and give people a good head start in that. But at this particular point in time, we have not worked through that. So I would encourage people to look at their material. The second item
Lyman,
is...
before you go on.
Sure.
Is there a way we could talk to the local grocery stores about carrying them as inventory?
I'm sure we can. We can add that to our list.
We do composting all the time.
Yeah,
And we can do
we do
that
too.
for
Yeah,
Okay.
they're available.
Thank you. And then secondly, I received today from Public Works, and you'll get this in the email tomorrow, and I'll pass it over to the Transportation Committee, is in that the traffic analysis was done as it relates to Central Washington University citing their campus here in Sammamish. And the conclusion from the consultants is that it would have little or no impact on the vehicular operations of the nearby intersections in both short-term and then also long-term. So we can go into the details of that tomorrow. We'll send out that data to you. Lastly, I wanted to just touch base with you and give you an update on the GIS system updates that we were endeavoring to do. We fell behind slightly. We intended to get at least the beta site up by November 15th. As you know, we lost our technology manager, and we basically had to do a major workaround in order to figure out exactly how things were configured, passwords, et cetera. That took us more time than we had anticipated. So at this point in time, as of yesterday, I saw a first draft or first beta of that website. There's still a lot to do, a lot of data that we need to update, but it is coming. And then that's the first part of the GIS update. Then the second one, the GIS assessment that AWC was going to be helping us with, will basically fall into January of next year because of all the work that we ended up having to do on this particular first project to get something up. For lack of a better term, we burned through that budget in getting this to the point of functionality. So it's coming, and but it's just delayed. And then lastly, I just wanted to say thank you, Council, for a great year. This is our last council meeting scheduled for 2016. We've accomplished a lot, and I think our citizens should be very happy with what has transpired. So I thank you and look forward to meeting with you again next year.
Okay, before we go, the mayor's report. And for the mayor's report, I've asked for a few minutes of personal privilege to reflect on the passage of one of our long-term Sammamish citizens and a very close personal friend of mine, Jim Kahn. Oh. And Lita. Jim was a neighbor of ours, and for years, while walking our dog in the morning, I would drop in on Jim and his wife, Rosemary, for a half hour or so for what we call our seminar. Jim grew up on Long Island. He attended prep school there and then graduated from Princeton with a history degree back in the 1940s. His early career was with the family clothing firm, and his subsequent working life was spent in marketing and sales. He retired in the Pacific Northwest, and then he went back to his first love, history, and earned his master's degree at the University of Washington. His passion for history was all-consuming, and in his late 80s, he was working on a biography of a former chairman of the UW History Department, W. Stoll Holt. And this W. Stoll Holt was a veteran of World War I and World War II. Fascinating story.
Back-to-back champions.
Yeah, a synopsis of his work was published in an award-winning article in the University of Washington Alumni Magazine in 2013, and this is it here. And I think we have some column magazine, and go through the figures. Go through them. I just show you that it was an awesome article, and that's why it won some awards. And this was in his late 80s. He did this and he was working on the biography. And our morning seminars would either be lectures on history by Jim or lectures on science by me, or we might read a book of mutual interest. One time we even read a novel, Deadline Man, by the Seattle Times business columnist John Talton. I think you probably read some of his columns. Jim was an extraordinary individual with an incredible memory of facts in all fields. I often tested his talent by asking him such questions as, who was the first baseman for the Milwaukee Braves when they beat the Yankees in the World Series in 1957? He knew it. Once I asked him who was the first person to break the 4-minute mile. He answered, "That's easy, Roger Bannister, who was a personal friend of mine, whom I first met back at Princeton when he was on a competition trip to the United States." Jim was also very interested in the evolving city of Sammamish and acted as a sounding board for me on many issues affecting the city. He was a founding member of the Association for the Protection of the Pine Lake Environment, acronym APPLE, and actively participated in various political campaigns. This unique man will be dearly missed by friends and family. Thank you. And with that, we're adjourned.